Hi, everybody. Before I start my true crime live chats, I prefer to acknowledge the victims of the cases. In this case, it is John O'Keefe. He was a Boston police sergeant who raised his niece and nephew after their parents died in 2013 and 14. And then John died in January 2022 when he was found in the snow on a lawn around 6 a.m. Before we start debating the case details, just a general chat overview. I turned on slow mode, so you have to wait 30 seconds between messages. In my live chats, all types of opinions are welcome. All I ask is that people just be polite, or my moderators will ban anybody being rude or commenting negatively about people instead of chatting politely about the case facts. If you're an adult, don't act like a child. Click on the name of an annoying person in the chat to get the option to block them. I never see hundreds of comments, so use the chat to talk to other people. I try to highlight a variety of comments from a variety of people as I go along. In the top of the chat box, it defaults to show top chat, but you can change that to live chat to see all comments. Finally, I try not to curse, but I cannot promise anything. I do not highlight comments with curses on the screen. Hi, y'all. Happy 4th of July to anybody in America, if you even care to celebrate. We're at the last day of Trial 1 testimony rewatch. As you can see on the bottom scroll, it's about 9 hours of testimony. That's at normal speed. I have it at 1.5 speed once I'm going to start playing it. We have 3 people, Trooper Paul doing the crash reconstruction for almost 4.5 hours. ARCCA is some company, and they have 2 people, Dr. Wolfe for about an hour, Rentschler for 40 minutes, and then finally almost 3 hours of closing arguments from both the prosecution and defense from Trial 1. Before this live chat started, I was looking at my schedule to see what I'm going to share on live chats for Trial 2. There were I was looking at 11-hour days. So I've appreciated everyone, like the 10 people who've been showing up for these rewatches. Unfortunately, for anybody who cares, which is probably nobody, I cannot do Trial 2 on live chats. I'm unable to pause. I'm taking notes on another computer over here as I'm watching on these live chats, but I'm having to go back and spend a lot of time rewatching instead of being able to pause. So I'm not going to be watching Trial 2 on YouTube. I am going to continue watching every piece of testimony by myself in my recliner, not in this uncomfortable chair. As I'm going towards this deep dive video, again, I'm going to look at all the testimony. I'm just not going to do Trial 2 on YouTube. So this is the last day of the live chats for testimony. So hi to everybody. Let's just get down to it. Whoever sang that song, Cool in the Gang. Anyway, here we go. First up, Trooper Paul for about 4.5 hours at normal speed. It's probably like 3.5 hours or 3 hours at maybe 1.5. Let's go.
All right, Mr. Lally, whenever you're ready.
Thank you, Your Honor. Good afternoon, sir.
Good afternoon.
Could you please state your name and spell your last name for sure?
Trooper Joe Paul, that's P-A-U-L.
And how are you employed, sir?
I am currently employed with the Massachusetts State Police.
And how long have you been a trooper with the state police?
I have been a trooper for approximately 8.5 years.
And,
sorry, 12.5 years. I apologize.
And where is it that you're currently assigned within the state police?
I am currently assigned to our Collision Analysis and Reconstruction Section, otherwise known as CARS, our recon.
And how long have you had that assignment to the reconstruction department?
That one's for about 8.5 years.
And with respect to your assignment to that unit prior to beginning with that unit, let me ask you this first, as far as the CARS unit is concerned, about how is that sort of divided up as far as certain regions that you would specifically cover?
Correct. We have four separate regions across the states. We have Southeast, the Northeast, Central, and the Western.
And which of those are you assigned to?
I am assigned to the Southeast.
And geographically, how much territory are we talking about that the Southeast covers?
Anywhere from Boston down to the Cape, Marks, Vineyard, Nantucket, anywhere southeastern part of Massachusetts.
And currently, how many troopers are assigned to this specialized reconstruction within your Southeast region?
Within our Southeast region, we have, I believe we have 9 now.
And is there some kind of on-call system that your unit operates by?
Yes.
Can you describe that to the jury?
So we rotate every day. Our on-call is for 24 hours from 0700 to 0700 the next day.
Now, with respect to yourself, upon or prior to you entering into the cars unit, what, if any, specialized training do you want to go in regard to crash reconstruction?
So when I went to, before I got to the unit, I was sent to 3 separate classes. Each class was 40 hours long. So the first class is basic at scene crash investigation. Next one's advanced crash investigation, and the other one's traffic crash reconstruction.
And with each of these trainings that you underwent prior to being assigned to the cars unit, and some more that we'll talk about in a moment, with respect to each of the trainings that you've been part of or undergone, is there some sort of certification that you receive in regard to a successful completion of those trainings?
Yes, each one has its own certification.
Now, with respect to, since you've been working with cars unit over the last several years, what, if any, additional specialized training have you received in the area of crash reconstruction?
Since I've been on, I've been into probably about 877 hours of education in the units. That's anything from bicycle crash investigation, human factors. I'm currently certified through Berla for examiner and the technician. I'm a CDR analyst and a CDR technician trainer. Just recently I've attended multiple seminars, and most recently I attended a seminar in Houston on EDR data retrieval.
Now, among those other trainings that you received, some of those trainings pertain specifically to pedestrian crashes?
Correct.
And in addition to the training that you received through the state police, what, if any, professional organizations do you belong to in regard to crashes?
Yes, I am currently a part of NAPARS, which is the National Professional Accident Reconstruction Section, and I'm also certified through ACTAR, which is the Accreditation Commission for Traffic Accident Reconstruction.
Now, if I can focus specifically just on the ACTAR certification, can you explain to the jury sort of what goes into that, and as far as that certification is concerned, how does one obtain it?
Okay, so first thing you do is you got to submit an application to ACTAR to be allowed to take the test, and part of the, you got to tell them how much education you've had, how many crashes you investigated, basically anything within the crash investigation world. And then once they find that you're accepted to take the test, then you guys set up a time for the test. We did it as a section throughout our state, and the test is a 2-part test. It's a practical and theory portion of the test. Each part's 4 hours long, and you got to pass both portions to be certified through ACTAR.
So there's a written exam and a practical portion of the test as well?
Correct.
And can you explain to the jury sort of the practical portion? What does that consist of?
The practical portion is you basically have to analyze a collision. So they give you a simulated crash, and you have to go through and document the evidence. You have to answer a series of questions based on that specific crash. So where you find the speeds, the distances, times, and everything else related to that collision.
And you successfully completed and received that certification, sir? Is that correct?
That's correct.
And how long ago was it that you first received your ACTAR certification?
In 2019.
And how long is that sort of in perpetuity, or is there a sort of continuing educational component attached to it?
There is a continuing educational component attached to it. The test is certified for 5 years, and within those 5 years, you still have to maintain a certain amount of education to reapply for ACTAR again.
And with respect to that ACTAR examination, are you familiar with sort of the success rate or the passing rates when it comes to that examination?
Correct.
And what is it?
It's fairly low. I can tell you within my unit at the time I took it, there were probably 27 of us that took it, and only 3 of us passed it at the time. Yeah, it's not a very high pass rate.
Now, over the course, let me ask you this: when you first sort of enter into the cars units, are you just sort of you go through the training and then you are on call and get sent out on the road by yourself, or how does that work?
No, you first get initially assigned to a field training officer, and then at that point you shadow the field training officer to various crashes.
And is there any sort of set time period for how long that shadowing process goes on for?
Not really set time. It's more based on experience, on how many crashes you go to and how much experience you have in the field. And then they basically, if they feel like if you're team qualified, then they'll send you on the road on your own.
And over the course of your years within the cars of the reconstruction unit, approximately how many crashes have you responded to and investigated?
As of now, I've been to approximately 196 crashes, and I probably assisted on another 150 crashes.
And of those, of all those crashes that you've responded to, investigated, if you know percentage-wise or number-wise, approximately how many of those have been crashes involving pedestrians?
I know I've been to approximately 55 pedestrian crashes, and I've assisted others on pedestrian crashes also. So I mean, 55 out of 196.
Now, with respect, if I could turn your attention to January 29th, 2022. Do you recall that date?
I do.
And at some point over the course of that date, were you contacted by somebody in regard to a pedestrian collision that occurred, in the town of Kinematics?
I was.
And do you recall who was it that first reached out, or how did you first become aware of this?
My sergeant, Sergeant Brian Mahoney, was the one who called me at the time.
And initially, as far as your involvement was concerned, what was your understanding as the initial request for your involvement?
My initial request was to image the airbag control module, dual inspection, test the vehicle, and map the scene out.
Now, you've used that term a couple of times. If I could just ask you to explain it a bit for the jury. When you say an airbag control module or an ACM, what is that, and what do you understand that term to mean in the context of crash reconstruction?
The ACM is the module in a car that controls the airbags and the seatbelt pretensioners.
And what you were referencing before, as far as being a CDR, having taken CDR trainings and being a CDR instructor, what, if any, relationship does the CDR have to ACM?
CDR is just a crash data retrieval software. It's the software that we use to image or download an airbag control module.
And can you explain to the jury sort of the process of physically sort of how that's done as far as what are you doing to the vehicle in order to download that?
Yes. There are two ways really to download a vehicle. It's either one is direct to module or just direct to the vehicle through the DLC port or diagnostic link connector. The direct to module, we don't use the direct to module if a vehicle had no power. Then we would have to go directly find the module inside the vehicle and go right to that specific module. But if the car has power, we would go right to the DLC port, which is the same port that you see when you're like a technician would do the diagnostics on a car. They would plug underneath the steering wheel, and then we'll get there, extract the information from there.
And once that information is extracted, what if any training have you received in regard to reading or interpreting the data that's extracted from?
Yes, I've been certified through as a CDR analyst, and I've taken 2 classes on it now.
Now, sir, turning your attention to February 1st, 2022. On that date, where, if anywhere, did you go in relation to your investigation of this?
I went to the Canton Police Department.
Now, at some point prior to that, were you made aware, or did you do any research into sort of what the weather was like around the time? What was reported to you initially as around the time of the crash occurred?
Before that, I know it was snowing and turned to a blizzard at the time.
Now, initially on February 1st, 2022, where did you go?
Canton Police Department.
Now, sir, at some point in time on that day, did you also have occasion to go to a residence or a street called Fairview Road in the town of Canton?
I did.
And specifically, there was a address that you were directed to. Is that correct?
That's correct.
And who, if anyone, did you go there with?
I believe it was one of the Canton Police officers, Lieutenant Paul Gallagher, I think his name was. I met him there.
And without anything specific as to what was told to you by Lieutenant Gallagher, what was sort of the purpose of having Lieutenant Gallagher there with you at that time?
He was going to show me where basically the evidence that they have at that point was.
Now, in addition to that, were you also able to, you're familiar with another specialized unit within the state police called CERT?
I am.
And at some points, did you have access to certain diagrams created by Lieutenant O'Hara within the CERT unit?
Yes, I was.
May I approach the witness, John?
Yes.
I'm going to show you what's been marked as Exhibit 135 and 136. Ask you to review that before we finish. I'm sorry. You recognize those, sir?
I do.
And, Your Honor, with the court's permission, I'd like to just publish that briefly to the jury.
Okay.
Ms. Gilman, if I could actually have Exhibit 136. And Trooper Paul, do you recognize what's up on the screen as Exhibit 136?
I do.
And this is the diagram that you were able to view from the created by Lieutenant O'Hara from the CERT.
Yes, it was.
And what's contained, at least when this overhead shot, is that fair and accurate trail of the roadway or conditions of the roadway, absent obviously weather at the time that you went out there February 1st.
Correct.
Ms. Gilman, you can take that. Thank you. So I'm going to retrieve that. I'm going to go to other photographs before you actually get to those when we finish.
Yep.
And do you recognize those, sir?
I do.
What do you recognize those to be?
They are pictures that were in my report. They're Google images of the roadway.
And one facing from the northbound direction, one facing from the southbound. Is that correct?
That's correct.
You want to approach?
Yes.
I'm also going to do some business. Trooper, directing your attention to the screen. What you have before you is that what's up on the screen? Excuse me. Is that what you have before you now, marked as divided into?
Yes, it is.
And if you could, there should be a laser pointer on the desk somewhere there before you start. If you could, using that laser pointer, direct the jury's attention to sort of what we're looking at in this particular photograph of the road.
So this is Fairview Road, also facing northbound. 34 Fairview Road would be onto the left in this area.
Now, with regard to the roadway, when you went there, what if any observations or what if anything did you know about sort of the roadway surface or markings on the roadway or the general overall condition of the road?
The roadway was, there's no significant difference. Anything significant with the roadway.
As far as the roadway material, were you able to determine whether or not it was sort of asphalt, concrete, or anything?
Right. Yes, it was an asphalt roadway.
And as far as the markings within the roadway, what if any observations you made of those?
There was double yellow center line, white fog lines both sides of the edge of the road. Is that what we're going after? The roadways?
And then as far as adjacent to the roadway or adjacent to the fog line, what if anything did you observe there?
So as you look at the picture, the left side has asphalt curbings. These are about 5 inches tall, same on both sides, and there's a sidewalk along the right side of the roadway here.
Inside of the asphalt curbings, that's the same side 34 Fairview was located on, is that correct?
Correct.
Let's go if I could have the next slide. And again, sir, what's up on the screen, is that what you have before you with 583?
Yes, it is.
And if you could, again, using the laser pointer, just briefly direct the jury's attention to what, if anything, you know as far as from this perspective.
Yeah, so this is the southbound. 34 Fairview would be on the right side here.
Ms. Gilman, you can take that. Now, Trooper, with regard to the roadway as far as Fairview Road, what, if anything, did you know in regard to postings regarding the speed limit on that particular roadway?
Yes, the posting for speed limit is 30 miles per hour. At this area, it's only posted 30 miles per hour for northbound operators, and I believe it was like 19 Fairview was posted in front of. For the southbound operators, it was not posted.
And so for a northbound operator, that would again be someone where the residents of 34 Fairview Road would be on the left-hand side of the road, is that correct?
That's correct.
And with regard to the width of the lanes, or what any measurements did you take in regard to the lanes or the roadway itself?
Yeah, each travel lane was approximately 12 feet, and the overall width was approximately 27 feet.
Now, as far as measurements being conducted with regard to the scene, what, if anything, did you use or employ to make those measurements, or what, if any, devices?
Yes, I mapped the scene with a Leica GNSS GPS total station, and also used a drone.
That's a UAS, is that correct?
Correct.
The drone, I mean.
Yes.
And with regard to each of those, as far as the GPS mapping and the drone, have you received any sort of specialized training in regard to employment of each of those tools?
Yes, I have been certified for the use of Leica, and I've also have a Part 107 license for the drone.
Now, as far as starting with the Leica or the GPS, if you could explain to the jury sort of what that is and how you use that device in order to, as you termed it, map the scene.
Yes, it's essentially what surveyors use to make roadways. It uses satellites and GPS data plus cell phone data to make marks on the roadway, or actually not marks, but just mark points in the roadway that are within millimeters of the device. And
with regard to the drone device, sir, how does that? Can you explain to the jury sort of how that works and how that's used?
Yeah, so the drone, and we fly the drone around the area. We set it to set up a grid pattern to fly around the scene. And while it's flying this grid pattern, it takes a series of photographs, and these photographs are also GPS marked. So once we get all the photographs in, we throw it into a program, and the program will essentially stitch it all together. And then once we get that picture, we throw it into a diagramming system.
And that diagramming system, have you also received training in regard to utilization of that diagramming system?
Yes, I have.
And the one that you're currently using within the car's unit, what is that diagramming system or software called?
It's IMS 360.
And you want to approach the witness?
Yes.
Sir, I'm showing you 4 documents. Actually, just review those. Finish. And do you recognize those, sir?
I do.
And what do you recognize those to be?
These are the diagrams that we print out through the program.
And the last one is the drone image. Is that correct?
Yes, they're all drone images. The last one is just one that was put into my diagram, and I labeled it as a drone image.
You want to approach?
Yes.
I'm off to introduce the next 4 exhibits.
No objection.
Now, Trooper Paul, are you familiar with the term? Well, let me ask you this: in regard to the roadway itself, what if anything else beyond sort of lane width and overall width? What if any other measurements did you take there?
So we took measurements for the evidence.
Let me ask it this way: as far as with elevation and incline of the roadway, what if any measurements did you take in regard to that?
Yeah, so we took the elevation and roadway measurements, or the elevation for the roadway.
And where in relation to the residents at 34 Fairview did you take that? Sort of the entire street, or just in the general area of that specific address?
In the general area of that specific address.
And from your measurements, as far as, well, let me ask you this: how was measurement regarded to elevation or incline? What kind of tool do you use for that?
We have a level, to digital level, that we'll place on the roadway, and we'll get a measurement from that.
Now, with regard to the measurements that you took of the elevation or the incline in the roadway, anything, or what if anything of significance did you find from that?
So this road had approximately plus or minus 1 to 2 degrees.
So nothing significant, is that fair to say?
Nothing significant, yes.
Now, sir, through your training experience as a crash reconstructionist, are you familiar with the term related to crash reconstruction called roadway evidence?
Yes.
And can you explain to the jury sort of what your understanding of that term is and what types of things could be termed as roadway evidence?
Roadway evidence is anything that's related to the collision you're investigating at the time. It could be anything from vehicle debris, gouge marks, tire marks, anything that's related to a vehicle or whatever type of crash you are investigating. It could be vehicle or pedestrians.
So any sort of anything from either the vehicle or pedestrian as well, is that correct?
Correct.
So pieces from a vehicle, holding items from a pedestrian, correct?
Yes.
Now, with respect to both your review of the CERT team diagrams as well as speaking with members of the Camden Police Department, were you able to then plot certain pieces of roadway evidence onto those diagrams that you that I just showed you a few moments ago?
Yes, I was.
Now, with reference to, you're familiar also through your training and experience when it comes to pedestrian crashes, as far as sort of physics or kinematics of how pedestrians interact with vehicles in the course of a collision?
Yes, I am.
Now, I'm going to ask you just a couple of terminology questions when it comes to items that are involved in a collision, sort of simple Newtonian physics, Newton's first law. Can you explain what that is to the jury and sort of how that pertains to any collision between two objects?
The first law?
Yes.
Yeah, that's when an object stays in motion or stays at rest, will stay at motion or rest until acted upon by an outside force.
Now, with respect to, are you familiar also with a crash reconstruction term called final rest?
Yes, I am.
And are there different derivations of final rest as far as controlled final rest versus uncontrolled final rest?
Correct.
And can you explain just first to the jury what final rest means in relation to crash reconstruction, and then what, if any, differences there are between a controlled final rest and an uncontrolled final rest?
Yes, the final rest is what we use for describe the area where a pedestrian came to stop after the collision. It's immediately after the collision. This is where they first stopped, or a vehicle, usually after the collision, it's where this vehicle first stopped. And a controlled final rest is when an operator actually controls the vehicle to the stop, and as opposed to the uncontrolled final rest is when there is no control, usually acted upon by outside forces that will control the vehicle or pedestrian to its final rest.
And, Your Honor, with court's permission, if I could publish what's now been marked as exhibits 584 to 587 for the jury.
Yes.
Ms. Gilman, if I could ask you to zoom in just a little bit on that. And now, Trooper, what you have up on the screen is that what you have before you as first in that exhibit.
Yes, it is.
Now, using the before you, if you could, I would ask you to draw the jury's attention or direction to what, if anything, of significance you have noted within this diagram.
Okay. Let me use the pointer. Okay. So in this time, I labeled each part of evidence. So right here would be the pedestrian's final rest, and they're all since there's so many put together, everything was labeled with a red arrow that would be pointing to where the final rest is. And this is where a glass cup was found. And these are the red and clear plastic pieces. That's where they were found. And pedestrian shoe was found here. The smaller versions here in the light blue is one's a fire hydrant, flagpole. This is a label for the street 34, and also the street name Fairview Road here.
Now, as far as measurements were concerned, what, if anything, were you able to do to measure sort of between different points of roadway evidence, or specifically from the pedestrian or Mr. O'Keefe's final rest in reference to other items that you have depicted on the diagram?
So, on these diagrams, I can try to see here, but it is a scale diagram. The diagram itself is scale. Once you put it roll up to the actual paper, it's scale. I've also have on here, sorry to see, but there's things right here. They're called ground control points. They're little X's on the roadway. They are used for the drones imaging, and using the drone imaging will use those in order to help put all the pictures back together. At the time of this, I measured between each point from ground control point 1 to 2 and put it as approximately 50 feet. And 2 to 3 is 50 feet, and 3 to 4 is 50 feet. So it kind of is the second way to measure off the diagram, and also using the program to measure to different points while using the diagram.
And as far as starting with the shoe that you have depicted in this diagram, what was the measurement of the shoe away from Mr. O'Keefe's body?
I believe the shoe was approximately, I don't know, I think it's approximately 10 feet away.
Your Honor, with the court's permission, may the trooper refer to his report just for the specific measurements?
Yes.
Okay, sorry, trooper, with regard to the shoe, how far away approximately was that from Mr. O'Keefe's body?
9 feet.
And did you also have a measurement for how far away the glass cup pieces were from Mr. O'Keefe's body?
Yeah, 1 foot.
And for the red plastic you have labeled on this diagram as A, how far away from Mr. O'Keefe's body was that?
7 feet.
Now, with regard to the directionality, you also measured sort of directionality as far as the 9 feet that the shoe was away. Which direction was it?
Each evidence was measured from the pedestrian's final rest. So the shoe was 9 feet southeast from the pedestrian's final rest.
And if you could, using the laser pointer on the screen, as far as the directionality of support, if you could first direct the jury's attention to where Mr. O'Keefe's final rest is, and then as far as the directionality of southeast from that rest.
Okay, so right here, pedestrian's final rest, it's more right there. The shoe is right here, so it would be kind of southeast. I have an arrow pointing north to kind of give it extra.
And the glass cup that was 1 foot away, which direction was that?
It was about 1 foot north. I think it was found like within, right next to him. So.
And the red plastic that you have labeled as A, again, that was 7 feet. Which direction was that, sir?
That one was east, so it was right here.
And as far as the clear plastic, what was the measurement and what was the directionality for that item, sir?
10 feet southeast, so about over here.
And the red plastic that you have labeled on the diagram is B. How far was that, and what directionality was that?
That was 12 feet southeast, and that's found right here.
Okay. Sir, if I could direct your attention to the next exhibit before your diagram is going to fight that, please. Sir, do you recognize what's picked up on the screen?
Yes, I do.
And if you could, again, using the laser pointer, but if anything of significance to observe in this particular diagram in reference to the roadway evidence?
It's just essentially the same diagram. It's just a closer up version of it. So you have, yeah, so you saw the pedestrian's final rest, glass cup, plastic pieces, the shoe. It's all still depicted in the diagram.
And the red arrows that you had indicated, delineated, depicted sort of from where the words are, where the items were, is that present in this diagram as well?
Correct.
If I could direct your attention to the next exhibit before you, if I could have diagram 3 still. And again, Trevor, do you recognize what's up on the screen?
I do.
And if you could just describe to the jury what we're looking at in this diagram.
Yeah, so this is just a closer up to the evidence. It's a little smaller scale.
And these diagrams are created from photographs that you took with the drone overhead on that day, February 1st. Is that correct?
That's correct.
And if I could direct your attention to the last exhibit within those images. And again, sir, if you could, you recognize what's up on the screen?
I do.
And could you describe to the jury again using the laser pointer to delineate what anything is significant to observe in this drone photograph and diagram analysis?
Yeah, so this is from my report. It's the same diagram. Has the same amount of evidence on here. There's a house. There's a light pole here. These lines here, which I mentioned earlier, were the edge of the road and the edge of the sidewalk.
Thanks. Now, with respect to the evidence, specifically pieces of taillight that are depicted within this diagram, did you put every single piece of taillight that was covered on January 29th within this diagram?
No, I did not.
Fair to say you did also not put every piece of taillight that you were aware was recovered over the course of this investigation and depicted in this particular diagram.
That's correct.
Now, with respect to this particular area of Fairview Road, understanding that you were there in the daytime, correct?
Yes.
However, when you were there in the daytime, what kind of note did you take as to sort of overhead lighting or available sort of ambient street lighting in the area?
Yeah, so on the top corner, I'll try to right up here, there's a light pole right there, overhead light pole.
And with relation to where you've marked as far as the final rest position of Mr. O'Keefe and the other areas of items of evidence that were recovered from the scene, was there any lighting in that particular area?
There wasn't.
Now, turning your attention, sir, back to February 1st, 2022. At some point, you were at the Canton Police Department, correct?
Yes.
And where specifically within the Canton Police Department did you go?
To the back in the garage area.
And within the garage area, what if anything did you do in the garage area?
In the garage area is where we imaged the airbag control module.
And so, I'm sorry, it's fair to say the defendant's vehicle was located in that garage area?
That is correct.
And you imaged that vehicle, and what if anything else did you do with respect to that vehicle that day?
At that point, we just analyzed the damage to the vehicle.
Now, at some point, did you perform any sort of mechanical inspection of the vehicle?
Yes.
Was that day or at some later?
It was that day.
And was that within the garage area itself, or where did you perform the mechanical inspection of the vehicle?
We analyzed a little bit of the steering and the brake pedals while it was sitting in the garage. Then we did testing with it on the in the driveway next to Canton PD.
Now, sir, starting with a visual inspection of the vehicle. You know, may I approach?
Yes.
I'm showing you some photographs. Do those look up when you finish? Do you recognize those?
I do.
And what do you recognize those to be?
They are crime scene photos that I've attached to my report.
You're on the Commonwealth to seek to introduce in the minutes the next two exhibits.
Objection.
Yep. Sorry.
And Trooper Paul, do you recognize what's up on the screen right now?
Yes, I do.
And what do you recognize that?
That's one of the crime scene photos that I attached to my report.
And what's contained in this is that a fair and accurate portrayal of sort of the front of this vehicle looking at it from the passenger side.
Yes.
And Trooper, do you recognize what's up on the screen now?
Yes, I do.
What do you recognize that?
That's a crime scene photo that I attached to my report with notations that I made on it.
And what's contained in this photograph is that a fair and accurate portrayal of what you observed in the rear passenger side area of the defendant's vehicle in the garage on February 1st.
Yes, it is.
Now, with regards to what you've noted within this, if you could, using the laser pointer before you, just direct the jury's attention to what, if anything, of significance you observed in your inspection of this area of the Lexus.
Okay. So on the left side here, I put down the scratches, and there's a dent there. The broken tail light here was here. There's some scratches on the bottom right rear bumper here. And there was glass from a cutback on the bumper.
As far as the glass on the bumper, what, if any, observations did you make of that in relation to the vehicle itself?
Yeah, it appeared to be from a cup as opposed to any glass that came from the vehicle.
Objection. So I'll strike the first part of the answer, but the second part will stand.
I no objection to the second. Thank you.
Now, with regard to the dent that you've delineated within this photograph, did you take any measurements from the ground as to where that was located?
Yes, I did.
And how far did you measure the dent to be approximately from the ground?
Approximately 48 to 50 inches from the ground.
And what many measurements did you take as far as from one part of the vehicle to the other, as far as where the dent was located?
Yeah, so it was approximately 19 inches from the right side of the vehicle.
Now, the scratches that you were talking about before, where were they in relation to the dent?
Right above the dent. I can see right there. As my hand shaky.
Now, as far as you obviously also made observations of the driver's side tail light as well.
Yes.
And so, from what you observed of the driver's side tail light versus the passenger side tail light, what, if any, observations did you make as far as the color of the pieces that you found missing from the passenger side tail light?
As compared to the left side of the tail light?
Yes.
So on the left side of the tail light, there was red and clear plastic pieces.
Now, the scratch marks along the bumper, did you take any measurements with relation to them?
Yes.
And specifically, did you take measurements from the ground to where they were located?
Yes.
What did you measure those?
They were approximately 27 to 28 inches from the ground.
Now, Trooper Paul, we can talk about a mechanical inspection of a vehicle just first in general terms. What is it that you're doing with respect to the vehicle in order to conduct that mechanical inspection?
So when we do mechanical inspections, we are obviously checking the steering, make sure the steering moves properly, the brake pedals, make sure they are firm, make sure the tail pedal moves back and forth. Just generally looking at the tires, make sure there's no issues with the vehicle.
And what, if any, observations did you make of the vehicle itself as far as any defects or anything to do with the braking, the tires, or any of the other areas that you inspect?
We didn't observe any mechanical defects with the vehicle.
Now, with relation to the weight of the vehicle, what, if any, analysis, what, if anything, did you determine as to the weight of the Lexus?
The way the Lexus side was doing analysis was just based on I think I have the gross vehicle weighting for the vehicle.
And how much did the vehicle weigh according to the gross weight?
I think it was approximately 7,000 pounds.
Now, with respect to the lights of the vehicle and being the tail lights and the headlights, what, if anything, did you determine those to be as far as what type of lights were they?
They were LED. Both they were headlights and taillights were both LED type.
And if you could just expound a little as far as LED lights, what, if any, significance does that have to you, or what kind of lights are LED? How bright are LED lights?
LED can, well, most comparison to what most people think in car and tail lights, where they have the bulbs, where they have the filaments. LED is more electronically controlled. There's a sensor that will light up, as opposed to a bulb type headlight and tail lights.
Now, are you familiar with an organization called NHTSA?
Yes.
And what does NHTSA stand for?
It's the National Highway Traffic Safety Administration.
And what, if anything, did you do with regard to NHTSA in respect to this vehicle itself?
We run the vehicle through NHTSA to see if there's any recalls on the vehicle.
And what, if any, recalls did you discover when you ran this particular vehicle through NHTSA?
There were no recalls.
And to be specific, we're talking about this specific vehicle as opposed to just Lexuses in general, make and model, correct?
Correct. Yeah, we put the VIN into the system, and it will tell you if this vehicle has any recalls to it.
Now, you indicated on February 1st at some point you did some testing with the vehicle. Is that correct?
Correct.
And where was that testing done, and what did it consist of?
It was done in the parking lot of Can PD on the same day. We did a forward braking test, a reverse braking test, and a reverse acceleration test.
Now, the parking lot of the Canton Police Station where you did this, what kind of roadway surface was that?
It's an asphalt surface.
So similar to the asphalt surface at 34 Fairview Road, is that correct?
Correct.
And what was the condition of the roadway as far as how dry or wet was the roadway when you conducted these acceleration and braking tests?
It was wet at the time.
And with respect to your understanding of January 29th, 2022, with the asphalt surface in front of 34 Fairview Road, what was the condition weather-wise as far as that roadway surface at the time of this collision?
At the time of the collision?
Yes.
What I'm saying is it was snowy, so the asphalt road had been fairly wet from snow.
Now, when you conducted these acceleration and braking tests with the defendant's vehicle, what, if anything, did you, what if any tool or what, if any, implement did you use in the course of that testing?
We use a device called it's called a V-Box. It's the V-Box Sport. The device is attached to the windshield, and it's also attached by an antenna that goes to the roof. And then basically V-Box, you want to explain what V-Box is?
Please.
Okay. So a V-Box is just, it measures performance for the vehicle. It uses GPS data to measure the speeds and its location. And use that it'll give us how fast we were stopping, a drag factor for the roadway for that specific vehicle and type of road, and acceleration factors. So we attach that to the windshield, just kind of give me a way to check its acceleration, check its performance.
And so the V-Box is attached to that vehicle, so what specifically is it measuring?
So yeah, it's using the GPS data to apply its location, and so it's measuring its speeds and using the speed and the location, putting that together. And once you use the app through the V-Box, and you set certain parameters as like you can go out 30 miles per hour, 20 miles per hour, 10 miles per hour, and it'll set your vehicle. So when you go to 30 miles per hour, it'll tell you what you're doing at 30, what you're doing at 20, what you're doing at 10, and then it'll know if you're doing braking or acceleration tests. And it'll use those numbers that you have to give you, your acceleration factor or braking factor for the vehicle.
So from the V-Box Sports device that you use, and you've received training as it applies to using that device?
Yes, I have.
And certification as well?
It's usually just the training on it.
Now, with respect to the V-Box Sport as it's attached to that vehicle, that's measuring specifically from that vehicle with those tires on that roadway surface that day, correct?
That's correct.
Now, with regard to that testing on that day, you did some acceleration or reverse acceleration tests, is that correct?
Correct.
And how many of those tests did you conduct?
2.
And describe to the jury sort of how you conducted those tests or what speeds you were using or sort of that process of the 2 reverse acceleration tests that you conducted that day.
So the reverse acceleration test we conducted, we set the parameters up to 25 miles per hour. So what we did is we try to come from a stop at 0 and then press the accelerators all about as hard as I could press it and try to go back and see how fast I can get to 25 miles per hour and see what the performance they did at that time.
And what, if any, kind of data did you see with the V-Box Sport using during those 2 reverse acceleration tests?
It gave me acceleration factor. It gave me its speeds and times and distances that it was at each location.
And if you could explain to the jury, sort of when you say acceleration factor, what is an acceleration factor?
It's just a number of how fast the vehicle could travel from an acceleration. It could be a light acceleration to a medium acceleration, or hard acceleration. They all have a different number that you can use to kind of relate it back to what the acceleration is for that vehicle.
And what was the acceleration factor that you were able to obtain with those 2 reverse acceleration tests?
I believe this was I had 0.317, I believe.
Now, during the course of those the reverse acceleration tests that you conducted on that day, what, if anything, did you know? Well, let me ask you this: as far as the operation of the vehicle, who was actually physically operating the vehicle?
I was actually operating the vehicle.
And what, if anything, did you note during your operation of that vehicle during the reverse acceleration test that you conducted?
We also noted the accelerator pedal moved freely. There was no binding. There were no interference from anything on the floor. Nothing interfered with the accelerator pedal. It worked as it's supposed to.
And when you're doing this reverse acceleration test, how are you, if at all, are you manipulating the steering wheel at all, or is it a straight line test, or how is the test? How is the vehicle directed during the test?
So I try to keep it fairly straight.
And when you accelerated in reverse in a fairly straight fashion with the steering wheel, what, if anything, did you note about that?
We kept the vehicle fairly straight. There was it was fairly easy to keep control of.
Now, in addition to the 2 reverse acceleration tests, what, if any, testing did you do with regard to reverse braking?
Yeah, so we conducted 2 reverse braking tests.
And again, similar, can you describe to the jury, this is also with the V-Box Sport attached, is that correct?
Correct.
So you're obtaining data from that as well?
Yes.
And during the course of the reverse braking test, what, if anything, first as far as data is concerned, how fast were these tests being conducted? What, if anything, was input, and what, if any, data did you receive from?
Yeah, so the reverse braking one, we try to get up to about 30 miles per hour. And then once we get up to that speed, that's when we apply the brakes, try to brake the brakes fairly hard to try to get the vehicle to stop.
And are you also familiar with the term known as a deceleration factor?
Correct.
And can you explain to the jury what that is?
It's just essentially the opposite of an acceleration factor. This is a number for how fast the vehicle would slow down.
And with regard to the deceleration factor from the 2 reverse braking tests that you conducted on that date, what, if any, figure did you receive from the instrument from the V-Box Sport?
For the reverse braking?
Yes.
I believe this one was so it gets you a drag factor number for this vehicle too, and our deceleration factor, which both are used the same way. This one was a 0.71.
Now, with regards, again, you're operating the vehicle during these two reverse braking tests, is that correct?
Yes, I was.
And what, if anything, did you note in regards to the operation of the vehicle when you were conducting these two reverse braking tests?
Yeah, the brake pedal was firm. There was no pulsation from the brake.
Now, in addition, sir, were you able to conduct some forward braking tests?
Yes, I was.
And similar again, could you describe to the jury as far as how you were operating the vehicle during the forward braking test?
Yes, essentially the same thing as reverse. If I was going forward this time, I got up to 30 miles per hour, and I would just apply the brakes about as hard as I could apply them to the stops.
And again, are you receiving from the instruments some sort of deceleration factor?
Yes, I was.
Did you recall what that was?
Yeah, it was a 0.69.
And during the course of your operation of the vehicle during the forward braking test, again, what, if anything, did you note in regards to the operation of the defense vehicle?
Same as before, the brake pedal was firm. There was no pulsation, no issues.
Now, you talked a little bit about the ACM or an airbag control module, correct?
Correct.
You indicated earlier in your testimony that you had downloaded information from that. Is that correct?
Yes.
Now, when you download that information, what, if anything, do you get from the vehicle, or what, if any, how are you able to sort of read or interpret that data?
So in the airbag control model, it's equipped with a spot event data recorder on EDR. And in that data from the EDR, we will use the boss CDR software and we'll attach to the vehicle. And then that software will basically extract the information or image the information that's in the module. And so that information could range from getting us speeds, if there was braking, if there's steering wheel movements, basically like looking for change of velocity, that type of. So there's a lot of information around the vehicle.
May I approach you?
Yes.
One of your documents are 7 pages in length. Ask you to review that when you're finished. Do you recognize that document, sir?
I do.
What do you recognize that to be?
This is the document that gets printed out through from the airbag control model through the crash retrieval software.
Thank you. May I approach again, Your Honor?
Yes.
I'm up to introduce the minutes and exhibit. No objection.
590.
Now, sir, when it comes to the CDR printouts, or let me ask you this. When it comes to the airbag control module, who is that designed to protect or to apply to in respect to safety measures with the vehicle?
Applies to the occupants inside the vehicle.
And this may sound a little first when I say it, but essentially the airbag control module is typically not designed to protect people on the exterior or the outside of the vehicle, correct?
Correct.
Now, you've been involved in a number of crash investigations involving pedestrians, correct?
Yes.
And as far as this particular case, what, if any, sort of useful or significant information were you able to interpret or retrieve from the ACM?
And this through the software, there was no data recovered or no events recovered.
And when it comes to pedestrian crashes in general, and as far as there being no data in this case, is that something that's abnormal?
It is not.
Explain to the jury sort of why not.
So what an airbag control module is doing, as it's running, it's constantly monitoring the vehicle. It's looking for like a sudden change of velocity, and like a collision. So once it feels that sudden change of velocity, essentially we'll wake up and monitor the vehicle, see if there's people wearing the seatbelts on, what's the speed of the vehicle, a number of different things that it could look for. And all it wants to do is either do I deploy the airbags or do I tighten the seatbelts? So most motor vehicle crashes with a car-on-car crash, there will be a higher change of velocity. So that's usually kind of what it's looking for. Pedestrian crashes are going to, they're not going to be much change of velocity to the vehicle. That means when they both interact with each other, the pedestrian is not going to change that vehicle's velocity in such a quick manner as, say, two cars would strike each other.
Now, with respect to crash reconstruction in general, are you familiar with a term called delta V?
Yes.
And can you explain to the jury sort of what that term means as far as what is a delta V and what is it measured?
So that's kind of what I was saying about the change of velocity. So the change of velocity. I mean, like change of velocity, like it's also within a certain amount of time. So change amount of speed within a certain amount of time. So.
And with respect to people as it applies to crashes or collisions involving pedestrians, and I think you've said a little bit about this, but what, if any, impact on the velocity of the vehicle would striking a pedestrian typically have?
Very little.
Now, specifically when it applies to pedestrian collisions in general, are you familiar with the concept of linear momentum?
Yes.
And can you explain to the jury sort of what that is and how it applies with pedestrian crashes in general?
Linear momentum. Momentum is essentially when two objects interact with each other. They come in with momentum and they leave with momentum with essentially the same momentum. And linear momentum just means something that's in line with each other.
Now, as far as we talked a little bit earlier in your testimony about roadway evidence, when it comes to your experience with pedestrian collisions, what, if any, relationship does that linear momentum have in relation to roadway evidence that you would expect to find at a scene of a pedestrian collision?
So when a pedestrian strikes a vehicle, they will go in the direction where the vehicle was traveling. So if the vehicle is traveling one way, the pedestrian strikes, it will go essentially that same way, depending on what part that vehicle strikes.
Now, as far as other items that the pedestrian may either have in their hand or other items of looser fitting clothing, what, if any, experience do you have as far as observations of those on collision scenes involving pedestrian collisions? Yeah, so it's not uncommon for pedestrians to lose essentially any sort of loose clothing. So shoes, belts, hats, anything that's not very strapped on very well, could leave the body. And as far as directionality is concerned, when it applies to that linear momentum that you were speaking of before, those sort of loosely held or handheld items, or would glasses be included within that as well?
Correct.
So those types of items, as far as directionality is concerned, what, if anything, can you tell the jury about that?
Yeah, so they will go in the same direction the pedestrian travels post-impact. We usually use that as kind of a post-impact path of travel for the pedestrian, showing that this is the direction that they would have traveled from where they got struck.
Now, are you also familiar with the reconstruction terms known as area of impact and point of impact?
Correct.
And can you explain what those terms mean in a crash reconstruction context for the jury?
Yeah, so an area impact is essentially the area where the crash happened, where these two vehicles or vehicle pedestrians, where their initial impact happened. Point impact is the same thing. It's just more down to like that specific point at that specific area. Area can mean a little bit broader in that sense.
And what are some of the, is this something that is delineated somewhat, at least by roadway evidence?
Correct.
And if you could describe to the jury sort of what types of roadway evidence that would lead you or any crash reconstructionists to formulate an opinion as to the area?
Yeah, so like I said earlier with the path of travel, so a lot of collisions we start where the final rest goes, and we follow the debris or the clothing. We're back to where, follow that path back to where it came from. And we know within that area, that's where an area impact would be.
Now, with relation to the evidence that was depicted on the diagrams that were up on the screen before as the exhibits, what, if any, relationship would the taillight pieces and the shoe that were recovered from the street in front of 34 Fairview Road have in relation to that area of impact?
Yeah, so they were found alongside the roadway. So I know that they were found, the air impact had been somewhere within the roadway and probably somewhere at the beginning, just prior to the beginning of the first point of evidence that we found.
So somewhere toward the first point of evidence contained within that debris field, is that correct?
Correct.
Now, sir, are you also familiar with a safety system specifically applicable to Lexus vehicles?
Yes.
And have you seen training in regard to downloading information in regard to that as well?
Yes.
And what is that safety system? What is that called?
It's called the Toyota TechStream software.
And so the Toyota TechStream is a software similar to the crash data retrieval or CDR software that you're talking about, but just specific to a Lexus.
Yeah, it's between Toyota and Lexus has software. The TechStream, it's similar in the fact that they both record data to the vehicle. TechStream was created by Toyota for their technicians to diagnose vehicles and use that information to help, any kind of mechanical issues that they would have with the vehicle, that they can do when you bring your car to them. They can look at the TechStream and just kind of find out what caused the mechanical issue.
Now, with respect to the Toyota TechStream data that's available, what kind of data are we talking?
So TechStream, yeah, they also do diagnostic stuff. So they're looking for any engine defaults or anything else. But they also have what's called a vehicle control history in it.
Sorry, I missed that. Called what?
A vehicle control history.
Thank you.
And the vehicle control history it's basically monitoring people's driving behavior. So it has certain, they call it triggers that they have listed. And when those triggers are met, they will record data related to that trigger.
And what type of data, in general terms, what type of data are you able to recover through the Toyota TechStream tool from the vehicle control history?
Yeah, so each trigger, you can record this the same as the, you got to get your speeds, brakes, the accelerator pedals on, for steering wheel angles, engine RPMs, all the information that you have related to vehicles.
Now, in addition, is it possible with vehicles that have some vehicles made that are accessible through this Toyota TechStream, including Lexus, which I should say, I'm sorry, so Lexus is manufactured by Toyota, right?
That's correct.
So in some vehicles, Toyota or Lexus vehicles are made by that manufacturer, are equipped with camera systems, is that correct?
Correct.
And again, in general terms, what, if anything, in relation to the camera system is it possible to collect from the vehicle controllers?
The camera systems in certain vehicles can record photos, like little grainy black and white photos.
And were you able to recover any black and white photos or photos of any kind from the defendant's vehicle in this case?
I was not.
Now, with respect to the sort of physical process of the downloading using this Toyota TechStream tool, can you explain to the jury sort of how that's physically done or what you're doing to the vehicle in order to download that information?
The same process, just different software as we would for the airbag control module. As I said before, we plug into the DLC port and then up that software program, and we follow the steps and we extract the information from the vehicle.
Now, the extraction of the Toyota TechStream data in this particular case, when was that accomplished?
For this one, I believe it was February 2nd, 2023.
So a year and a day after you had conducted the braking and acceleration test and inspected the vehicle in the Canton Police Department garage?
That's correct.
And so as far as the timing of that being February 2nd of 2023, why was that?
I was at the time of my initial inspection, I didn't really know much about TechStream at that point. So over time, I kind of learned about TechStream. And so once I learned about it, and I thought, is this relevant to our case? And I looked more into it and found that it is relevant. So.
And the Toyota TechStream, as far as that applicability or that tool, is that a relatively newer tool than the area of crash reconstruction?
It is getting fairly newer, as like it's getting spread out. It's getting bigger. It first got created on one vehicle in 2014. So it's been slowly trickling into the Toyotas and Lexus vehicles over time. But it's definitely gotten bigger within the past couple of years.
Now, with regard to this information, when you were then able to download that information, you received some data, is that correct?
That's correct.
And you mentioned that it goes, or it's measured sort of by triggers, is that correct?
That's correct.
And from the data that you were able to obtain from the defendant's vehicle, what type of data were you able to retrieve as it relates to the vehicle control history?
Yeah, so I mean, this had like a page and a half full of triggers that over the vehicle's time span that it captured.
And with respect to the triggers, how many triggers did it capture?
It's like a page and a half. I don't know exact numbers of how many triggers that was on each page, but there was, it's at least a page and a half full of triggers.
Your Honor, may the trooper refer to his notes in regard to that? The trooper, if I could direct you, I think it's page 9 of your report.
Okay.
And how many triggers was it, sir?
Can you count them?
Does he have to count them, Mr. Lally?
No, I don't think he has to count them. Sir, if I could direct you to paragraph 22.
Oh, yeah. So 22 separate triggers. Those are, so in my report, it says 22 separate triggers that occurred on odometer mileage 12665 to 12666.
And with regard to the mileage that you noted as far as being between miles 12665 and miles 12666, that's 12,665 to 12,666, correct?
Correct.
And what was the mileage that you observed on the vehicle at inspection?
12,665.
And at the time that you conducted this Toyota TechStream download from the vehicle, what was the mileage at that time?
12,666.
And there's also reference within the vehicle control history data in regard to something called a key cycle. Is that correct?
Correct.
And can you explain to the jury sort of what a key cycle is and what are the different things that could trigger a key cycle?
Key cycle is essentially, so it's from the ignition cycle. So a key cycle is essentially from when the vehicle's off, it's pressed on. It doesn't necessarily need to be running or turned on. It just needs to be turned on and then off again. And that'd be one key cycle.
Now, with relation to your analysis in regard to the vehicle control history, what, if any, role did the key cycle numbers, or what kind of role did that play in your analysis?
It shows me where, how far away they were from each other, the key cycles were.
And how far away in what terms?
So when I turned the vehicle on, when I did my testing, it showed me what key cycle was that I was on when I did those testings and the odometer mileage in relationship to that.
Your Honor, may I approach?
Yes.
So I'm showing you the documents. You guys go look at that, look up and finish. And do you recognize that, sir?
I do.
And what do you recognize that?
That is the table from the vehicle control history from my report.
And Your Honor, may I approach?
Yes.
I'm obviously introducing the minutes next exhibit.
No objection, Honor.
Okay. The 591.
Now, Trooper Paul, what's up on the screen is that the exhibit that you have before you.
Yes, it is.
Now, if you could, using the laser pointer before you, just direct the jury's attention to what we're looking at in this exhibit and what type of information where it's located within this exhibit.
Okay, so this is the vehicle control history. Every single point here, this is where the triggers are. This is the labels for each trigger. Odometer mileage is on this label here. These are the elapsed time and key cycles. I have noted through arrows here, these were when the vehicle was with us, and a lot of this is related to my testing with the vehicle. And these right before that were the triggers that were prior to those testings.
Within this table, sir, there are two triggers reported at odometer mile 12,629.
Yes.
And what's the key cycle associated with 12,629?
1,162.
Now, these triggers that are contained as far as the 12,629, that's prior to the.
Okay, you have to either come speak up even louder, Mr. Lally.
I will speak louder.
There's no microphone near you. That's the problem for the court reporter.
My issue is, Your Honor, there's no light over here.
All right, so let's turn the light on and then you can ask your question, then we'll turn the light right back off, please.
Thank you, Your Honor. My apologies. So that odometer mile, as far as two triggering events, at 12,629, correct?
Yes.
And that occurs prior to the 12,665, 12,666 during the course of your braking and acceleration test, correct?
Correct.
And the mileage difference between those two, did you do that math?
Yes.
What was the mileage difference between the two?
36.
And how many key cycles were different between your testing and that odometer reading of 12,629?
2 key cycles.
Now, as far as the, what if any information did you have and where did you get it in relation to the defendant's vehicle's path of travel prior to those odometer readings that you noted when you did your
Yeah. So yeah, I was told that where she traveled afterwards or prior to that. I was noted their locations, and I used those locations through Google to get a mileage for them.
May I approach, Your Honor?
Yes.
When you another document, do you recognize it?
I do.
And what do you recognize that to be?
Those are the Google directions. I put them in a table and put in my report.
And may I approach, Your Honor?
Yes.
I'm going to introduce you to the next exhibit.
No objection.
With the 592. Thank you.
So if you could, Mark, 2 minutes or now, Trooper Paul, do you recognize what's up on the screen as the next exhibit before you?
Yes, I do.
And these are, again, if you could explain to the jury sort of what we're looking at here and how you came to these mileage rules.
Yes. So when I got the directions, it showed that we got from 34 Fairview Road to 1 Meadows Ave. And when I put that address onto Google, it gave me suggested routes. So I put each suggested route on there and the time it took So I did that with every direction from One Meadows Ave to Waterfall, Waterfall to 12 Country Lane, and 12 Country Lane to One Meadows Ave, and then One Meadows Ave to 345 Country Hill Drive, North Dayton. So I did that for every single one and find suggested routes, so which is labeled in all these boxes here. And then at the bottom here, I did a total distance, and I did a min and the max distance of, the minimum was 36.1 and the max distance of 38.8.
All right, so I'm going to ask you to take that down for a minute, and I'll see counsel at sidebar, please.
Now, in addition to those distances there depicted in that exhibit, sir, have you also looked at a mileage or distance between, well, I'm sorry, the first up there was as far as 34 Fairview Road to One Meadows Avenue, is that correct?
That's correct.
And that gave you sort of 3 different routes to travel, is that correct?
Yes,
And the minute of the max was 2.2 to 2.6.
correct.
Now, if you were to add that as an additional sort of distance travel to the 36.1 to 38.8 that you had calculated, how much of a difference does that make?
Between the two min maxes?
Yes.
Only 2.7.
And as far as your analysis that we're about to discuss, adding in that approximate 2 points, whatever miles, how much of a difference does that make to your analysis and ultimate conclusions in regard to the VCH or vehicle control history data?
I was going later, but so the 36 is just within the realm that she could travel 36. The odometer mileage is the odometer mileage. So 36 is 36. That's what's on the vehicle. So within the realm of possibilities that the vehicle could travel 36 miles after the 2 triggers that are in this vehicle.
Now, with respect to that minimum max, as far as the 36.1, 38.8, what, if any, relationship does that have to the difference in the odometer readings that you observed between when you conducted the braking test and when you observed these 2 triggering events that you were talking about at the earlier mileage?
So no difference. The odometer mileage is the odometer mileage is 36.
And so I guess what I'm asking, sir, is the 36 miles, is that within the range of the 2 triggering events that you were just talking about?
Yes, it was.
Now, as far as within your report and your analysis, did you come up with sort of a label as far as these 2 different triggering events that you observed?
Yes, I did.
And that incorporated the mileage, is that correct?
Correct.
And that was, again, 12,629, is that correct?
Yes.
And as far as any further label that you put on it, how did you label it?
I labeled them as in when they occurred. One's 12,629A and one other one's 12,629B.
And with respect to the A and B, which one occurred first?
The A occurred first.
May I approach, Ron?
Yes.
Approach, Ron, you have another document asking you to review that before we finish.
Okay.
And do you recognize that?
I do. It's the data chart from the 12,629 miles A chart.
May I approach again, Ron?
Yes.
Almost seek to introduce the minutes of the next exhibit. Okay, so we've got before you what's now up on the screen. Do you recognize that as what's now being marked as the next exhibit?
I do.
Is if you could describe to the jury sort of what these rows indicate as far as what information is there, and if you could, using the laser pointer, direct the jury's attention to what, if anything, of significance you observed in this as far as 12,629 miles A.
Okay. So each row starting from the top is the vehicle control history time, which is the time that's recorded in the module itself or in the software that gets recorded as each time, and it's recorded as seconds. This time is the time from the start of the key cycle. So it starts off with 652.8, and each one is incremented in approximately half-second increments up to, let me show it, right here where the trigger, this is what's called where the trigger happened. So right here is where it kind of goes from 4.5 to 4.6, then it goes up to 5, then everything after that is about half-second increments from each other. Recorded 10 seconds of time, which is labeled in this one, total time of 10 seconds. And I'll put time from trigger, just kind of label it back to, here's the trigger right here, and that's the time between each one. Sorry if I can read this right. So right here is the vehicle speeds. The blue is just labeled because that's the speed. Zeros are labeled, the light blue is 0. So if I can read this. So it starts from, shows that the vehicle is traveling at 9.9 miles per hour. It's slowing down to about 0 right here, and then stops for that time, and then increases back, speeds back up to, it goes up to 6.2, and then slows back down to 0, and then back up to 1.7 to, I think it's 8.7. If I read that right. The next below for us is miles per hour to kilometers. This is the accelerator opening ratio, which is really where this trigger comes from, because the trigger is labeled as the accelerator pedal opening angle is medium to higher immediately after shifting to reverse, or I label it as R.
If I could stop you there just a second, sir. As far as the accelerator pedal opening angle, can you explain to the jury sort of what that term means and how that relates to sort of the operation of the vehicle?
So the accelerator pedal is, the part where everybody puts the foot on and gets the vehicle to go. So the pedal, so this is what's showing how far the pedal was actually pressed by the operator of the vehicle. And that gives you a percentage of that. So if it was, 0 is not pressed and 100% it's all the way down. So they label the trigger, I think 30% is medium to higher in this way Toyota labels it. So and that's where you'll see the trigger is around 31.5%. And also shows start from the beginning, goes from 0 and increases up to 50.5%. And that's 5 seconds. That's only, a little over a second past the trigger. And so it's 50% and then back off and then back onto the accelerator again, up to 34%.
Now, as far as this data is concerned for the VCH data from the Toyota tech stream, what, if any, information are you able to glean as far as directionality, as far as forward, reverse, left, right, things like that from this data? So
on this label right here, so it shows the shift position signal. 1 is forward and 2 is reverse. So this right here is showing the vehicle was in drive and going forward. and then the vehicle got shifted into reverse, and then back to drive again.
Now, from your experience and from your training when it comes to interpreting this type of data, do you have any opinion as to sort of what type of maneuver or what type of actions the vehicle was taking during the course of this triggering event?
Yes, this appears the vehicle was slowing down and making a U-turn. Because also the other thing into it, it shows steering signal, and the steering wheel showed that she was trying left and then right and the back left again, and also when she's on the brake switch.
And Your Honor, may I approach?
Yes.
The document that I've just handed you now, do you recognize that?
Yes,
And what do you recognize that to be?
it's the one the data chart from my report was labeled as 12,629 miles B.
So that's the second triggering event within this same mileage reading on the odometer, same key cycle.
Correct.
Your Honor, may I approach?
Yes.
Come on, please do for a minute. No objection.
Okay.
And true, Paul, you recognize what's up on screen now?
I do.
This is the BCH data chart from that same mileage or the second triggering event as far as 12,629 miles peak, correct?
Correct.
And again, this is in the same odometer range as well as the same key cycle as what was just up on the screen as far as 12,629 miles A, correct?
Yes.
This occurs after A, is that fair to say?
Correct.
Now, similar to before, when it comes to this BCH data up on the screen, if you could, using the laser pointer, demonstrate to the jury what, if anything, of significance you note with respect to this data.
So for this one, same label as before, just that the vehicle trigger time is, if I can see that, the trigger time is 1,142.2 seconds after key cycle. And this one shows all the same thing, 10 seconds of data. And it was good. So the vehicle speed on this one shows that she's slowing down. It's 13.7 miles per hour and gets down to 0. Then she's down to 0 for a while, and then the vehicle's speed increases up to 24.2 miles per hour at its max speed. Then it goes down to 23.6 as the last two labels. And accelerator pedal angle at this point at key trigger is 36.5 and increases up to 74.5%. And it stays around 74.5%, 74, 73.5, and 74.
Now, that's 74.5% as far as the pressure being applied to the accelerator pedal, correct?
Correct.
And with respect to that, 74.5, that's about 3/4 down, is that correct?
Yes.
Now, with regard to this data from 12,629 miles B, what, if anything, are you able to tell from this data as far as when that occurred in relation to 12,629A?
So they occurred about approximately 8 minutes. So 1269A occurred 8 minutes prior to the other one, and they both occurred on the same odometer mileage.
Now, with respect to the duration of the data that you were able to obtain from this one, specifically 12,629 miles B, what kind of duration of data are we looking at in this particular table of chart?
Say that again.
How long a period of time does this?
So this is from the start of key cycle, or this whole just this one?
Just this one.
Okay. So this is 10 seconds of data.
And with respect to that 10 seconds of data, as far as the 24.2 miles per hour, when does that occur within the 10 seconds of data for this particular event?
So 24.2, as I'll point out, is right here. It's actually around the 9-second mark.
Now, similar to the other charts for A that was up on the screen a moment before, is there an indication as far as the accelerator pedal opening angle?
Yes.
And what, if any, significance does that have, or what, if anything, does that indicate to you from this data on screen?
It shows that the accelerator pedal angle went up to 74.5%. So as out of 100%, it went up to 74.5%.
Now, with respect to direction out for this, what, if any, data is contained within this chart in respect to that?
Yeah. So on the bottom row, it shows the steering signal. It shows slowing down zeros like 0.5, 9, 13.5, 13.5. I think it's 13.50, 4.5. And that's, we're talking about steering wheel. How far does the steering wheel move from left to right? So that's the degrees of a steering wheel angle.
Now, as far as when the vehicle is shifted sort of from drive or neutral or park, or whatever it was, at some point, is there an indication in this data set on this table as far as when the vehicle was placed into reverse?
Yes.
And how far into this 10-second data set was the vehicle placed into reverse?
At 4 seconds, it's right here.
And so am I correct then that there is a 5-second difference between 4 seconds when it placed in reverse and 9 seconds approximately when it achieves that 24.2 miles per hour?
Correct.
Now, as far as the 74.5% pressure that's placed on the accelerator pedal, when is that reported in seconds in relation to the 10-second data set in this data?
74.5 starts at the 8 second.
Now, as far as this trigger is concerned, I understand from your testimony that the maximum speed is 24.2. Is that correct?
Correct.
And what is the vehicle speed recorded at the end of this 10-second data?
23.6.
Now, as far as the vehicle being in sort of different sets, as far as drive, reverse, things of that nature, what, if anything, did you observe within this data set as far as how it is at the beginning, how it changes at all? What happens with regard to that in the data set?
So this one shows that the vehicle was in drive. It starts off in drive. It's slowing down to 0, and it goes to 0, which is neutral, then goes down, then it goes into reverse. So it's going straight, it stops, then it's placed in reverse, and then goes back, goes in reverse.
Now, as far as the reverse is concerned, you indicated there's also some steering angles that are recorded with this data.
Yes.
And what, if anything, was recorded in this 10 seconds of data? Specifically, I'm asking from the time that it goes to reverse to the end of the set, the end of the data set. What, if anything, do you observe with reference to the change in the steering angle of the steering wheel?
It does not change much. It's only 13. I think the far it goes is left is at 13.5%. So that's only, I mean, if the steering was a circle, the whole circle is 360 degrees. So 13.5% is only, and it's still fairly straight in the vehicle and at 13.5%.
So from this data, this vehicle is backing up in the manner of about 5 seconds or so, in a fairly straight line, and achieves a maximum speed of 24.2 miles per hour, correct?
Correct.
And even at the end of this data set, the vehicle is still traveling approximately 23.6 miles per hour.
Correct.
Now, as far as the small deviations in the steering that you were testifying about, based on your training and experience, what, if anything, would cause that?
Well, the steering wheel was obviously caused by operator traveling only small amounts, up to here. So it's only just operator steering at those small deviations.
Your Honor, may I approach?
Yes.
Let me grab that one.
Yep.
And present you with another document. You recognize that?
I do.
And what do you recognize that to be?
It's a more of a closer up snippet of that document that I have attached to my report.
And Your Honor, may I approach?
Yes.
Sorry, hard practice. Call to introduce the next exhibit.
You can go ahead. You can go ahead and publish it if you're inclined.
Trooper Paul, who wants to leave it up on the screen as this next exhibit, if you could, using the laser pointer, just direct the jury's attention to what, if anything, of significance you observe in this portion of the data.
Yeah, so I circled in here if they dropped from 24.2 to 23.6, and also the steering wheel signal went from a left at 4.5 to a right 4.5, so positive to a negative. And also the same thing with the accelerator opening ratio kind of stays consistently at 74%.
May I approach again, Your Honor?
Yes.
I'm showing you another document.
Okay.
Do you recognize that?
I do.
What do you recognize that to be?
It's a vehicle control history distance chart I have attached, I calculated and attached to my report.
And may I approach again, Your Honor?
Yes.
Call to introduce the next exhibit.
Okay. Go ahead and publish it if you're inclined.
Paul, do you recognize what's up on the screen? It's now been marked as exhibit 596.
I do.
And again, if you could, using the laser pointer, let me ask you this first. As far as this table and this information up on the screen, I should have asked you this before. How was this table created, and what, if anything, does this illustrate?
Yeah, so this illustrates from the chart of 12,629B. I started from when the vehicle was placed into reverse, and when it immediately goes from 0 and travels up to 23.6. Just that's like the last part of that last chart we had.
And what, if anything, were you able to do as far as distance travel, and how were you able to determine that?
So I used the this vehicle speeds and the time, and calculated a distance that the vehicle traveled during this time.
And as far as the total distance traveled from the 0 to the 23.6 at the end, what was the total distance there?
97.35 feet.
And with respect to the vehicle's maximum speed, as far as 24.2 miles per hour that's recorded within this data set, how much distance had the vehicle traveled prior to achieving that 24.2 miles per hour?
62.51 feet.
Thanks. Now, Trooper Paul, with regard to, based on your training and experience, with respect to this type of data and crash reconstruction in general, this particular set of data from, who's the name again? From 12,629 miles B, what, if any, type of collision is that data set consistent with, and what?
Yeah, there's a point there where it appears to be consistent with a pedestrian strike.
And why is it that your interpretation of that data you feel is consistent with the pedestrian strike?
It's the sudden change of speed at 24.2 to 23.6 in a half second, while the accelerator pedal is still at a consistent 74%. And also the steering wheel angle goes left at 4.5 degrees and also goes right to 4.5 degrees and then goes back to left after that. So right at that spot is something that's consistent with the pedestrian strike.
Now, with respect to Mr. O'Keefe, the pedestrian in this collision, what, if any, data were you able to see or review in relation to your reconstruction analysis in this case? As far as Mr. O'Keefe, what, if anything, did you learn about his injuries?
Like what types of injuries he had?
Yes.
Yeah, there were blunt force injuries. I believe it was abrasions or lacerations, and blunt force injuries.
And the injuries that you observed or that you were informed about, you learned this from the medical examiner, is that correct?
Correct.
And with respect to the injuries Mr. O'Keefe was recorded as having sustained, according to the medical examiner, what, if any, relationship did those injuries have to you in relation to a pedestrian collision?
Sorry, say it again.
As far as the injuries that you were informed by the medical examiner that Mr. O'Keefe had sustained,
Yes.
what, if any, relationship did those injuries have in relation to a pedestrian collision?
They are consistent with a pedestrian collision.
And how so?
Due to, we can break down each injury due to the arm, the lacerations of the arm from the tail light, the dent where the scratches for his hand could be. Those are something that would be consistent with this, in this particular case, with striking the Lexus.
Now, specifically with reference to this case, what, if any, analysis did you conduct with regard to kinematics?
Yes, I did a kinematics analysis in my report. Kinematics deals with the aspect of motion.
And I'm sorry, if you could expand upon that just a little bit and explain to the jury sort of what a kinematics analysis is.
So kinematics analysis is, like I said, it deals with the aspects of motion. Pedestrian crashes get kind of labeled in certain types of how they interact. So in this particular case, I kind of labeled it as it's a forward projection crash with a side swipe. And what I mean by forward projection means that when a pedestrian gets struck by a vehicle, well, basically their principal impact forces are above the pedestrian center of gravity, as in this case where you get the higher back of the vehicle. When you get struck by something like that, it projects you forward in the direction of the vehicle. And in this situation where he gets more struck to the side of the vehicle on the taillight area, that it projected him to forward and then to the left due to this like more of a side swipe manner.
Now, with respect to the, you mentioned the height of the vehicle, as far as the shape of the back of the vehicle, what, if any, relationship does that have in regard to you sort of labeling this as a forward projection / side swipe collision?
Yeah, due to being pretty flat, it's not the front of the vehicle. We have the hood, and the pedestrian staying above the hood. It's the back of the vehicle. It's pretty flat and it's pretty higher up.
Now, with respect, you also made aware through your review of the medical examiner's report that there was injury to the back of Mr. O'Keefe's head.
Yes.
And based on your training experience in particular with pedestrian collisions, what, if any, significance did that have in relation to your opinion as to how Mr. O'Keefe interacted with the defendant's vehicle?
So when you look at the damage, he would have interacted with that left side of the vehicle. And when he got struck by the vehicle on the left side, it would cause his vehicle to rotate kind of counterclockwise. And then when that rotation, he could turn into his back, and his back could have struck the ground. I noted at the scene that there was asphalt curbing, which could have somewhere he could have struck his head in there, or somewhere along any of the pavement would have caused damage. Most forward projection crashes have damage on both sides of the body.
Why is that?
Due to them get projected forward, so they get hit from behind, they had damage to the back, and then when they get projected forward, they get damage to the front. So, I mean, in this case, he got projected and got spun counterclockwise due to where he got impacted the vehicle.
Now, with regard to the vehicle speeds, kinematically speaking, from your analysis in respect to that, what, if anything, can you say in relation to, just in general terms, as far as a pedestrian collision is concerned, how much of that vehicle speed would a pedestrian be assuming in the context of a pedestrian collision with forward projection?
Forward projection will have almost 100% speed post-impact. And more, like I said, in this case, it's more the fact that he didn't get 100%, like his center mass didn't strike the vehicle, so he would not have getting thrown 100% of the vehicle speed post-impact. His right side would have sustained the vehicle speed, and that would cause him to spin out. So as opposed to traditional forward projection, if he was right there in the middle of the vehicle, he would have projected forward, and he would have sustained, his full body would have sustained the vehicle speed.
Is that abnormal as far as the sort of forward projection type of pedestrian collision? What I'm going to ask is specifically to not having any contact with sort of the bottom of the vehicle or being run over or something like that. Can you expound upon that a little?
Yeah, due to the side swipe manner that projected him off the left, it wouldn't show that he would have been, the car would have ran over him, traveled over him, like traditional.
Yeah,
car
I'm
would,
going to ask you to slow down just a
Sorry.
little bit.
Sorry. Yes, so due to the situation in this scene where he got projected to the left and body rotated, it would have rotated away from the vehicle, and his body would not have traveled under the vehicle. As you do in a lot of traditional forward projection crashes, the vehicle would get projected forward ahead of the vehicle, and that vehicle could possibly travel over that pedestrian.
So that is not what you found in this particular pedestrian collision, correct?
Correct.
I know you mentioned it a couple of times, but if I could ask you to just expound a little bit when you're talking about center of mass and how that relates between sort of a pedestrian and a vehicle in a pedestrian type collision.
So pedestrians, almost every object has a center mass. Pedestrian is the same. So the pedestrian center mass is essentially to the half the body, and you would also put down is around the chest area, just below the chest area would be the center of mass for a pedestrian, and they all range based on height and body shape.
And so where on someone's body typically would a center of mass be located?
Usually just around the chest area, just below the chest area.
Now, if I could turn your attention, Super Paul, back to February 1st of 2022, when you were at the Canton Police Department, you mentioned that, or you testified earlier at some point that you went outside to an asphalt roadway surface and conducted some forward acceleration and rear acceleration braking tests, correct?
Correct.
Now, in addition to that, what, if any, other testing did you do with respect to that vehicle on that particular date in that location?
We checked the cameras, and in the back we did backup visibility analysis with the cameras in the vehicle.
And again, if you could, just in general terms, first, just describe to the jury when you say visibility analysis, typically speaking, what are you doing in a visibility analysis?
In the visibility analysis, we are trying to see what an operator would see in a vehicle. Looking for, in this particular case, we're trying to see if the operating vehicle would be able to see a pedestrian behind the vehicle. And also in this, where we have backup cameras, we're trying to look at the cameras and see what would the cameras pick up as we would go into reverse.
And in fairness to the defendant, at this particular time when this visibility analysis was conducted, it was during the daytime, is that correct?
That's correct.
Your understanding of the crash is that it occurred at night, correct?
Correct.
Now, as far as the visibility analysis, typically, would you be looking to recreate as close as you can to the conditions at the time the collision occurred?
In most typical cases, yes.
And why were you not able to, were you able to do that in this case?
We were not.
Why?
Due to was most, like I said, it's mostly done when we're trying to see what an operator would see a pedestrian. It's mostly done because it's an accident, but a lot of times when it's like an intentional act, visibility is not an issue in this situation. We were just want to make sure that the cameras worked and the backup sensors all worked in the vehicle.
Now, as far as this particular visibility analysis that was conducted in this case, how, if at all, was that memorialized?
It was recorded when the crime scenes. Trooper recorded it.
My apologies. Before I get to that, sir.
Okay.
I can turn your attention just back to the text screen just for a moment. Your Honor, may I approach?
Yes.
So I'm showing you a series of 7 photographs to ask you to look at those. First, I'm just going to ask you generally if you recognize those.
Yes.
And what do you recognize those to be?
It's the inside of the vehicle. Appears to be taking out the, showing that taking out the infotainment system.
What system?
Infotainment system.
And the last photograph there, what, if anything, is that the picture?
That is the module for the infotainment system.
And what, if any, involvement did you have in respect to this investigation in regard to the infotainment system?
I didn't have anything. That was Trooper Nick Marino did the infotainment system in this vehicle.
And you indicated earlier in your testimony that you had training as it relates to Burla, correct?
Correct.
And what, if any, relationship does Burla have with respect to the infotainment system?
They had tools to forensically diagnose the infotainment systems.
And if you know, are you familiar with whether or not that was able to be accomplished in this particular case?
It was not.
And do you know why not?
Because they had to go to, I think Burla didn't have the equipment, so they went to a.
Sustain.
Your Honor, may I approach?
Yes.
Now, as far as those photographs, they're an accurate portrayal of what you observed in the vehicle during the time that you were conducting your testing.
Yes.
Your Honor, I'll seek to introduce the next set of exhibits.
Any objection, Mr. Jackson?
I'm sorry, I was writing those. Those 5 photographs?
7.
No objection.
And Trooper Paul, do you recognize what's up on the screen and is now been marked as exhibit 597?
Yes.
And what part of the vehicle are we looking at in this photograph?
That's the steering wheel.
And Ms. Gilman, if I could have EEP3. And Trooper Paul, do you recognize what's now up on the screen and is marked as exhibit 598?
Yes, I do.
And if you could, using the laser pointer, direct your attention to what, if anything, of significance you observed in this part of the photograph.
That is the infotainment system.
And as far as the infotainment system, when you were operating that vehicle, what, if anything, was displayed on that screen within the infotainment system?
If you were in drive, it just had the radio navigation stuff. But if you're in verse, that's where the backup cameras and sensors would be.
And Ms. Gilman, if I could have EEP4, sorry. And Trooper Paul, do you recognize what's up on the screen as exhibit 599?
Yes, I do.
And what, if anything, are we looking at in this system?
That's the push button start, the ignition.
So that's how this vehicle is started. It's stopped essentially as a push button start. Is that correct?
Correct.
And Trooper Paul, do you recognize what's up on the screen as now marked as exhibit 601?
Yes.
If you could, using the laser pointer, direct your attention to what, if anything, you observe of significance in this.
Yes, that's the infotainment system. It's on. Shows satellite here. Looks like that's the navigation.
Now, if I can take you back just for a second to the VCH data and the kinematics of what you were identifying about just a moment ago. You had mentioned that with respect to the injury to the back of Mr. O'Keefe's head, that is consistent or could have been caused by striking his head on hard pavement and curbing. Is that correct?
Correct.
Now, as far as your training and experience in pedestrian collisions that you responded to and investigated on prior occasions, as far as weather, as far as the coldness of the grounds being frozen, what, if any, impact could that have as far as in relation to the injuries to the back of Mr. O'Keefe's head?
Objection.
Sustain.
Now, as far as the visibility analysis that you were conducting on February 1st, you mentioned that that was memorialized with photographs as well as video. Is that correct?
Correct.
And the video that was taken, sir, was that in the interior of the vehicle, exterior of the vehicle, or both?
Believe it might have been just the interior.
Don't start showing the 2 discs.
Okay.
You recognize those?
Yes.
And those are the recordings of the visibility or the braking and acceleration tests from February 1st, both interior of the vehicle, exterior of the vehicle. Is that correct?
Yes.
May I approach again, Your Honor?
Yes.
I'm going to introduce the next exhibit.
No objection.
Before we get to those videos, Trooper, may I approach again, Your Honor?
Yes.
So I'm showing you another series of lead photographs. Actually, I'll go through a couple you finished. And do you recognize what's depicted in those photographs, Trooper?
Yes, I do.
And what do you recognize those to be?
Those are photos from the backup cameras and sensor tests.
May I approach again, Your Honor?
Yes.
I'm going to introduce the next exhibits.
No objection.
Trooper, if you could, please describe to the jury what we're looking at in this photograph that's now been marked as exhibit 606.
Yes, this is the view from the operator as they would turn around and look to the back of the vehicle.
And Trooper Paul, do you recognize what's up on the screen and is now been marked as exhibit 610?
Yes.
And can you please describe to the jury what, if anything, we're looking at here?
Yes, that's the view inside the vehicle showing the infotainment system and the backup cameras on it.
Now, as far as the backup cameras on this particular vehicle, what kind of view was able to be portrayed, or what did you observe on the screen when you placed the vehicle on the first?
Yes, so this has this straight backup camera and also has a 360 overhead view of the vehicle.
And as far as the cameras within this vehicle are concerned, are we talking about one single camera, or how many cameras are encapsulating this 360-degree camera angle view?
It has the front and the sides and the rear cameras.
Now, if you could, using the laser pointer, just draw the jury's attention, direct the jury's attention to where you're talking about as far as the screen is concerned, depicting that camera angle view.
Okay. So the one on the left, that's the backup camera, and the one in the middle here would be the 360 overhead camera.
Now, in addition to what's depicted on screen right now, as far as the vehicle on the 360 overhead, As the vehicle travels, what, if anything, in addition, is depicted on that particular portion of the screen as far as the 360 overhead?
It shows a sensor, and also when that sensor shows up in the area where the object that it gets closer to.
And the sensor that you're talking about, how is that depicted on the screen?
It's a little red like blip or little bar that would show up on the camera itself.
And is that something that appears as you approach an object from either in front or behind or something else?
Correct. As you approach the bar will, blink and will get faster as you get closer to the object.
Now, with respect to the system overall, in addition to the visual cues depicted up on the screen, what, if any, auditory cues are also part of the system?
It will beep at you, and it will, as you get closer to the object, it will beep faster as you get closer to it.
And as far as getting closer to an object, the beeping that you're talking about, it increases in speed or rapidity, is that correct?
Correct.
And how does it, what, if anything, does it do as far as the volume of the beeping that you use?
I guess it would increase as it would get faster.
So it gets faster and it gets louder as you get closer to an object, correct?
Yep.
Now, with respect to sort of the middle of the screen here, up on the dashboard, what, if anything, do you observe there for the direct the jury's attention to what, if any, devices are up there right now?
Yes. So right here, this blue device, that's the V-Box Sport that attached to the windshield.
So that's something that you attached to the vehicle. It's not necessarily something that was in the vehicle when you began to operate it around.
Yes.
And Trooper Paul, if you could describe to the jury, or using the laser pointer, if you could draw the jury's attention to what, if anything, is significant to observe in this portion or closer up image of the screen in the center column.
Yeah. So this this is one on the left here is the backup camera, and the one in the middle is the 360 overhead camera. The bars and lines are showing the path of the vehicle.
Now, Trooper Paul, as far as during this visibility analysis that you conducted, you testified earlier that you were primarily concerned with sort of whether or not the cameras and the auditory and visual cues worked properly with this vehicle and the system, correct?
Yes.
And during the course of your running these sort of forward and back reverse acceleration braking tests, as well as visibility analysis, what, if anything, did you observe with relation to the functionality of the cameras and the visual and auditory cues?
Everything seemed to be working properly.
Now, when you were operating the vehicle on February 1st and you shifted the vehicle into reverse, what would then sort of occur with the screen in the center of the data?
It would change from the navigation to the backup cameras.
And how long a period of time did that take as far as you shifted from drive to reverse on a number of different occasions while you were conducting your test, correct?
Yes.
And so how long a period of time are we talking about between the time that you shift the vehicle from drive or another gear to reverse for those screens to then display both the rear backup camera and the 360 overhead view?
It's fairly instantaneous, very quick.
Now, at some point during the course of the visibility analysis specifically, what, if anything, did you place behind the vehicle during your visibility analysis?
It was like a punching bag dummy.
And where did you place that in relation to the vehicle?
Along the right rear.
And as far as that punching bag dummy was concerned, about how far up off the ground was the top of that?
I'm not exactly sure the exact height of it. Maybe my height is taller.
And with respect, your height, sir, how tall are you?
5'6".
So it was at least 5'6", if not taller. Is that correct?
Correct.
And with respect to that, placing it behind the vehicle, after it was placed behind the vehicle, at some point were you inside the vehicle?
Yes.
And when you were inside the vehicle and that was outside of the vehicle, what, if any, visual observations were you able to make with respect to its placement? And it's in the right rear passenger side of the vehicle. Is that correct?
Correct.
What, if any, observations were you able to make with respect to that item or exemplar that was placed out there?
It would have been visible in the cameras.
Now, with respect to the visibility analysis that was conducted with respect to that, let me ask you this first. When I say exemplar pedestrian, can you explain sort of what that term means and how it relates to a visibility analysis?
So an exemplar pedestrian is, just like you said, we used a punch bag dummy. It was something that we used in place of a pedestrian to act like a pedestrian.
Now, when that exemplar pedestrian was placed in the rear passenger side area of the vehicle, what, if any, obstructions did you observe as far as just from a visual perspective, sort of turning your head or looking at cameras or anything else as far as where that exemplar was placed?
There were no obstructions.
Now, if that exemplar was placed directly next to the vehicle versus feet away from the vehicle, what, if any, difference did you know as far as visibility was concerned?
Yeah. So if it was placed right next to the vehicle, you would be blocked by the back pillar of the vehicle. If you place it maybe like 5 feet away, you would be able to see the dummy in the cameras and also in the side mirrors.
So at a distance of at least 5 feet, it was fully visible from where you sat in the vehicle?
Yes.
Your Honor, with the court's permission, if we could, I would ask, I'm sorry, I'm not sure what exhibit numbers they are, but the 2 videos that were just introduced.
Okay.
And Ms. Gilman, if I can have the exterior video first. Ms. Gilman, if you could pause there for a moment. Well, with respect to just for orientation purposes, if you could explain to the jury sort of where we are in relation to the Canton Police Department and where it was that you conducted these tests.
Yeah. So this is a view from the back of the Canton Police Department. So as you look at the Canton Police Department, we'd be on the left side of the Canton Police Department.
And as far as the vehicle in question, if you could, using the laser pointer, just direct the jury's attention to where that is and sort of where it's going to be in relation to the camera.
Vehicle is right here.
Ms. Gilman, if you could press. If I could ask you to pause there for just a moment. If you recall, during these testing that you were conducting here with the acceleration, reverse braking, all of those, the highest speeds that you recorded during the course of that testing was 30 miles an hour. Is that correct?
Yes.
And the highest speed that was contained within that VCH data for the second or the B of those two data sets, what was the highest miles per hour there?
At 24.
Now, with respect to the braking in this vehicle, what, if anything, was this vehicle equipped with?
Had ABS brakes, anti-lock brake system.
And with relation to anti-lock brake system or ABS, what, if any, relationship does that have with regard to braking and what is then visible on the pavement?
It doesn't leave visible tire marks.
And why is that so?
Due to when the brakes, as the brake is about to lock up, it transfers over to another tire. So it kind of rotates between tires. So the tires never fully lock up and slide across the pavement.
Now, in relation to ABS not leaving marks on the pavement, what, if any, relationship does that have as far as the sound difference between ABS brakes and non-ABS brakes?
Yeah, the sound would be different because you would hear a car sliding across the pavement as opposed to just hard braking and engine slowing down.
As far as sort of screeching of braking and tire coming to a brake, what would you expect to hear with respect to ABS braking?
There will be no screeching of the tires.
And Ms. Gilman, if you could right from here. Thank you, sir. Your Honor, with the court's permission, may I publish the other video of the interior of the vehicle?
Yes.
Ms. Gilman, if you could just pause briefly. Again, to recall with reference to what's up on screen, if you could just using the laser pointer direct the jury's attention to the screen in the center of the dashboard, and just as far as what different parts of the screen are visible.
So right here is the reverse camera, 360 camera.
And as far as this particular portion of the interior of the vehicle, are we looking at what was done with regard to acceleration or braking tests, or are we looking at the visibility?
This is the visibility analysis.
Ms. Gilman, if you could please start. I could ask you to just bring it back to focus. Super Paul, as far as the, this is a closer up image of the screen that was visible in the center of the dash of the vehicle, is that correct?
Yes.
And if you could, using the laser pointers, may be a little difficult to see. If you could, using the laser pointer, direct the jury's attention to what, if anything, you observe on the screen while the vehicle's in reverse, is that correct?
Correct.
If you could, direct the jury's attention to what, if anything, you observe on the screen as the vehicle's in reverse with the exemplar pedestrian behind.
Yes. So this screen has now changed to a park assist screen, and it now shows a sensor for the back of the vehicle. And also same here, the sensor starts popping up in a yellow line for behind the vehicle.
And then in the actual camera view.
The actual camera view shows that's where our punch bag dummy was, and also shows where the sensor's backed up to on the bottom here.
And Ms. Gilman, for the record, this is about 34 seconds in. If you could press play from here. Now, Triple Paul, at some point over the course of your investigation, over the course of this case, did you become aware of ring videos from Mr. O'Keefe's residence at One Meadows Avenue?
Yes.
And specifically, have you had occasion to see a video depicting the defendant backing out of the garage as snow was coming down?
Yes.
I'm going to allow it.
Your Honor, with the court's permission, if I could publish to the jury with the witness on the stand, Exhibit 6, video number 153.
Objection, may be approached.
Yes.
Thank you. Be seated.
Okay. So, Trooper, we're going to have a voir dire of you, sir. Mr. Lally's going to ask you some questions. Mr. Jackson's going to ask you some questions. You'll be shown a video. Okay. All right, Mr. Lally.
Now, Trooper Paul, as I was asking before, with respect to have you had occasion to see a ring video from Mr. O'Keefe's house on One Meadows Avenue depicting the defendant or the defendant's vehicle backing out of a garage while snow was falling? Now, in addition to that, as you already testified to, you made observations of the defendant's vehicle in the Canton Police Department garage on February 1st. Is that correct?
Yes.
And Your Honor, with the court's permission, maybe play the video at this time.
Yes.
Your Honor, save time. I'll stipulate to the video.
I want to see it for purposes of this voir dire. And in fact, I'd like to see the version that the defendants have with the focusing in on the tire.
Understood.
Both. Go ahead, Ms. Gilman. You show yours, and then I'm going to ask for the defense.
153. Now, Trooper, from your observations from this video, at some point, this vehicle either comes close or makes contact with Mr. O'Keefe's vehicle. Is that correct?
Yes.
Now, in addition to your observations of this video and your observations of the defendant's vehicle, at some point, have you also seen photographs of Mr. O'Keefe's vehicle?
Yes.
And is your understanding that those photographs of Mr. O'Keefe's vehicle were taken by State Police Crime Scene Services on February 3rd? Is that correct?
Yes.
Now, with reference to your observations in this vehicle, what I'm going to ask you is in regard to the significance, the significance of the impact of the two vehicles. In respect to Mr. O'Keefe's vehicle, what, if anything, did you observe on his vehicle at that time?
At the photos are now.
Right now.
All right. There was snow on the vehicle.
And then with respect to the contact between the defendant's vehicle and victim Mr. O'Keefe's vehicle, what, if anything, did you observe to occur with relation to the snow based on the significance of the impact between the two?
The snow doesn't move.
And Ms. Gilman, if you could press play this.
All right. Can I see the other video, please? Yes, I think it's on. I know it's in evidence, but I think it's on your computer, your hard drive. All right. Thank you. Okay, could you turn the lights on, please?
Your Honor, if I could, there's just two photographs that I'd like to.
Sure.
Ms. Gilman, if I could have what's now been marked as Exhibit 549.
And before you do that, what is the exhibit we just saw through your IT person? What
Your Honor,
number?
it's the same exhibit. It has not been enhanced in any way. It was just magnified for purposes of this of showing. In other words, the magnification is not embedded in the video. It's the
Okay.
same video.
Okay.
We just magnified it.
Okay.
Here you go.
All right, thank you. Go ahead, Mr. Lally.
And Trooper, do you recognize what's up on the screen now?
Yes.
And what are we looking at? In which area of the vehicle are we looking at?
It's the rear. Sorry. John O'Keefe's car.
The driver's side, is that correct?
Yes.
And what, if any, relationship does this portion of the vehicle we're looking at here have in relation to the video that we just watched?
It was faced. Well, kind of see it
All right,
from.
what was the answer? I
It
didn't
was,
hear.
sorry. It was faced kind of the same way you see the back left rear corner of the vehicle as you do in this picture here.
And Ms. Gilman, if I could have what's now been marked as Exhibit 559. And sir, is this the same driver's side rear of Mr. O'Keefe's vehicle?
Yes, it is.
Now, as far as your observations of these photographs, what, if any, damage did you observe to Mr. O'Keefe's vehicle in either the last exhibit or this exhibit itself?
There was no damage.
Now, as far as the impact, let me ask, as far as the damage that you observed to the taillight area of the defendant's vehicle, what, if any, opinion do you have as to the amount of force necessary in order to cause that damage?
Objection.
We need a foundation on this.
So, Trooper, over the course of your, I'm sorry, how many crashes have you investigated over your time? As far as you know?
I've been primary on 196 crashes.
And I know I'd asked you before about pedestrian crashes. Fair to say most of the remainder, if not all the remainder, involves vehicles colliding with other vehicles.
Correct.
Now, with respect to that experience in relation to vehicle crashes, what, if any, training or knowledge do you have in regard to sort of physical forces of vehicles in a collision sequence and what kind of damage you would anticipate?
So obviously, the higher the speed, the more damage. The lower speed, the less damage.
And what, if any, from the observation that you made in that video and the observations that you made of the defendant's vehicle, what you observed in the video, was that consistent with the damage that you observed to the defendant's vehicle?
Objection.
So I'm going to allow this with voir dire. I just need to hear this information.
Understood, Your Honor.
It's not consistent with the tail light in this collision.
And why not?
For one thing, the collision, the tail light is, let's say, 42 to 50 inches off the ground. So that vehicle would have to have damage 42 to 50 inches off the ground because they would have to contact each other in the same distance from the ground, and there's no damage to that vehicle. So if the tail light breaks, it should leave some sort of scratching, maybe a dent, something on some sort of damage to that vehicle should have occurred.
And with respect to, I think you just answered it. So as far as Mr. O'Keefe's vehicle, what kind of damage would you expect from an impact significant enough to break the plastic on the tail light of the defendant's vehicle?
It'd be probably higher speed than what we saw.
For purposes of voir dire, I need to hear all of this. Go ahead.
A higher speed than what we probably saw in there. If it's not, it was minimal, maybe it would crack a tail light or something like that, but it wouldn't. I mean, the damage is different. And also, we have a bumper that's also in the way too.
And to that point, when it comes to a bumper, from a functional standpoint, what is a bumper and what does it do with respect to a vehicle and collision sequence?
The bumper is, it's basically meant as another cushion to absorb the impact to another vehicle, from one vehicle to another vehicle. It kind of sticks out to kind of also preserve whatever, the tail lights and everything else and damage on top of it.
So in order, from your experience as far as responding and investigating collisions, specifically collisions between motor vehicles, the speed that you observed the defendant's vehicle traveling in that video, what, if any, relationship does that have, specifically also as to the bumper, as to the damage that you observed the defendant's vehicle?
So if you look at the defendant's vehicle, there is a scratch mark that is along the left side starts from her bumper around the rear. That could be consistently with his hitting his bumper. That would be around the same height level. He has a little ridge there on his bumper. So that bumper could have been hit that little ridge. And also the bumper in itself here is a different material. Hers is a little lighter, like a glossy colored paint. This is more a duller flat finish. So it might have some why it would show up on her bumper more than it would show up on his bumper.
And finally, sir, in your opinion, the damage to the defendant's taillight, is that something that could have occurred or could have been caused by the crash or the contact of the vehicles that you observed in that video?
Objection.
No.
So again, this is voir dire, Mr. Jackson, going in here.
No.
And again, sir, why not?
For one thing, the bumpers, you have to go push through the bumpers in order to hit the tail light against the other vehicle. And there's no damage to that significant damage to a bumper in order to push back into the car.
And again, there was no snow on the vehicle. By that, I mean Mr. O'Keefe's vehicle that even came off the vehicle that you observed during the course of that contact between the two vehicles.
That's correct.
I have nothing further on.
All right, Mr. Jackson.
Did you ever put the two cars together?
I did not.
No, you didn't, did you? You didn't. You never tested whether or not the SUV would match up with the Traverse, did you?
What do you mean?
You just said, oh, look, one of them has matte finish, one of them has glossy finish. So it couldn't have happened, right?
No, I'm confused by the question. I'm talking about the tail light. We're talking about the tail light.
Yeah.
Are we talking about the tail light? We're talking about the bumper.
Yeah, we were talking about the tail light.
So one person at a time, you're both talking over each other.
You started talking about the bumpers.
Yes.
You said, well, one has matte finish and one has glossy finish, right?
Yes.
You said, well, you'd expect one of them to slide off of each other, and they could have done this and they could have done that, right?
Not slide off each other.
You were suggesting that the two cars wouldn't match up such that the taillight could make contact with any part of the Traverse. That's what you were suggesting.
I'm saying it didn't match up because there's no damage to the Traverse.
You didn't test whether or not the lens, the right rear lens on the SUV could match up to any part of the Traverse, right? And make contact, physical contact with it, right?
When I see a picture of the Traverse,
no.
when I see the
No,
picture of the
this is a voir dire. I need the information,
you
Mr.
asked me a
Jackson.
question.
Yeah,
I said when
yes or no question, Trooper.
I don't think so, but
Mr. Jackson, just for, there's no jury here. This is for purposes of what I have to rule on. The more information I have, the better off I am in being able to rule on.
Let me take a breath.
So this is you trying to keep the evidence out. So you want to give me the information.
Understood. Did you or did you not ever do a test where you backed the Lexus up against the Traverse?
we did not.
Did you or did you not ever do a test where you put the two cars together and measured them?
No.
Did you ever measure the taillight of the SUV, the black SUV, against any area on that Traverse?
No.
Did you ever do any force multiplier tests to determine the forces necessary to crack the SUV's convex taillight?
No.
Did you ever do any testing to determine whether or not a plastic taillight, under how much pressure a plastic taillight would need to be subjected before it would crack?
No.
Did you ever do any testing to determine whether or not if a plastic taillight came into contact with a metallic portion of another SUV, whether it would leave any mark?
I haven't done any testing. I've seen crashes where headlights have struck other vehicles. That's kind of where the experience comes from.
Fair enough. But I'm guessing that those crashes are probably different speeds and higher speeds. Not this, right?
I've had multiple crashes at different speeds.
So have you ever had a
Yes.
crash where you've investigated, the Massachusetts State Police has been brought in to investigate a crash where the car was going in reverse at about a half a mile an hour?
Half a mile an hour?
Whatever that was.
Are you saying the SUV Lexus going half a mile per hour?
Well, you're the reconstructionist. Give me an estimate of how fast you think that SUV was going at the point of contact with the Traverse.
Maybe like 1-2 miles per hour?
Okay, fair enough. Have you ever been called in to a crash, to investigate a crash, where the cars have collided at 1 mile an hour?
I've had pedestrian crashes that have been at a very low speed.
Okay, that wasn't my question. That wasn't quite my question.
Okay.
My question is, have you been called in to a crash involving two vehicles that make contact at about 1 mile an hour?
I have seen testing for vehicles at low speeds So next time I've been called to a crash, I go to fatality crashes, but I have seen testing for fields at low speed impacts,
Okay. How low speed?
like just the bump.
So like this?
Yes,
Did you see any damage?
yes. All right, well, minimal damage.
Right. In what circumstances? Minimal damage, like, I don't know, like a cracked taillight.
No, like just a little bit of rub off on the paint.
Right? Or you might see nothing, right?
Yes.
You've certainly seen circumstances in which two cars come in contact and there's absolutely no physical damage to either car, nothing observable, right?
Have I gone to
Sure.
crashes that I've seen no physical damage on a car?
Or just in common sense, just everyday life, where one car backs into another car at the Jiffy Lube, makes contact and drives away, and there's no damage.
Not normally. It's usually something with car and car impacts.
Like, what's the something?
A crack or a paint, something chip, scratches.
Right.
Yeah.
So if you put a piece of metal in that scenario, if you put a piece of metal, steel, right, against a piece of plastic, which one do you think is going to give way first?
You'll still see some damage to both vehicles at a speed.
Which one would give way first?
Between metal, depends what speeds. And what we're talking about, you're just saying plastic and metal. You're going to a pretty general broad plastic and metal
Triple Paul,
analysis here.
you admit, you got to agree with me, that there are circumstances in which low speed, very, very low speed contact between two cars can certainly leave damage on one and not damage on the other, damage on both, or no damage on either one. Observe.
Yes, I just said in that situation where the scratch on the side of her car
Right.
had a scratch mark and his doesn't appear to have anything.
And you said, I'm questioned by Mr. Lally, that certain circumstances like this could lead to a lens material, right, plastic material cracking.
Say again, like on least.
Just a few minutes ago, Mr. Lally,
I'm trying to answer your question. Sorry, yes.
Mr. Lally asked you a question a few minutes ago, and you indicated that something might show up on a bumper. Something might, something might, like a taillight, might actually crack, correct? In a low speed impact.
Until like my crack on a low speed impact?
Correct.
It might crack.
Okay, now, Mr. Lally also said you saw this video where the cars come close to or make contact, right? That's how we worded the question. Remember that?
Come close. Yep.
Which one is it? Did it come close or did it make contact?
I said it might. I don't know what if that scratch from the side is. It's something that's consistent with the height of the bumper. Like I said I didn't measure from side by side, but you can clearly see there's a scratch on the side, and that's something that looks like that would come back. So as I look at the bumper, I see the bumper and it has a little divot. And I look at her side of her car with that scratch mark. That kind of lines up a little bit of why that could be where that was from.
I thought you said there was no damage on that car, on the Traverse.
There is no damage, and that's why I went to why there's the two different paint materials there. That why one could have showed up on her car because it's that flat, the glossy paint on there, and it could have scratched on it. Well, you have something that's a little more rougher texture with like a flat, flat color on there. That wouldn't leave on there.
So you just described the circumstance in which two cars come in contact. You don't see any observable damage on one, and you do on the other. That's what
I suggested that when you said asked me a second ago.
Yes. With regard to the video, let's get back to the question that I asked, which was, in that video, did the SUV come close to, or did it come in contact with the Traverse?
Again, I don't know because I'm saying based off the damage that is something consistent with that. So most likely it did come in contact with the bumper to bumper, but I don't know definitively because there is no damage to his car, but it's something that could explain why there's a scratch mark alongside the right rear side of his car, for her car.
Did you see the tire move, sir? Did you see the wheel on the Traverse move in that video?
No, I couldn't see the wheel move.
I beg your pardon?
I didn't see it move. If I did, I didn't observe it moving. If it moved, it moved. I didn't observe it moving. I wasn't looking at the wheel.
When was the first time you saw that video?
I don't really know. It's been a little while,
Well, I don't know what a little while means.
like a year ago, I think.
Okay. So you saw the video a year ago. Did you put anything about that video in your report, which is, wherever it is, right here? I'm looking at your entire car's report. Did you put anything in this car's report about watching that video?
No, because I watched the video like after the report was done. And honestly, I watched it first time on court TV. So
So who, on court TV, during this trial?
like,
Prior here.
no, when it was on TV at some point.
When did you and Mr. Lally have a discussion about you testifying about this video?
That was a couple weeks ago?
I'm sorry, I couldn't
A
understand.
couple of weeks ago?
What's a couple of weeks ago? Is it 10 days ago?
2 weeks ago? 2 weeks ago?
Okay.
Two.
Where did you two meet?
At the DA's office.
Was that at your request or was that at Mr. Lally's request?
It was a pre-conference hearing, or pre-trial hearing,
Right. Well,
or pre-trial conference. Sorry.
done.
So
We're talking over each other. Try not to talk over each other.
I'm trying not either.
Let's both try hard.
Okay.
Who set up the meeting?
For my pre-trial,
Yes.
Okay.
Paul.
Adam Lally.
Who was at the meeting?
Right, sitting right here, Lieutenant Tully.
Lieutenant Tully, you, Adam Lally, Laura McLaughlin. I'm guessing Ms. Gilman was not there.
She was not there. Correct.
Did Mr. Lally show you this video at that meeting?
Yes.
Did he tell you that he intended to ask you some questions about this video at that meeting?
Yes.
Did he ask you whether or not you could render an opinion as to whether or not the impact you saw or lack thereof, whatever the case may be, was consistent or inconsistent with damage to the taillight?
Yes.
Did you tell him that you would give him such opinion if called upon at trial?
Yes.
Did anybody take any notes?
I don't know.
Were you taking notes?
Yes.
Where are those notes, Trooper Paul?
I think I just want notes on this specifically, but just make sure I had my everything checks and balances, and for what I want to talk about, what we're going to talk about.
Make sure you had what?
Checks and balances. Sorry.
Checks and balances.
Just make sure I'm well on the same page of what we understand what's going on in the trial.
You want to make sure that you're on the same page with Mr. Lally about what's going on in the trial.
Yes.
Did Mr. Lally take notes?
I have no idea.
You were watching him. He was writing something down.
I wasn't paying attention to his note taking.
Ms. McLaughlin was there. She taking notes?
I don't know.
You didn't see her either?
I don't know if there were people who are taking notes, writing stuff down, or what they're writing stuff down in relation to our little conference.
Did you give him an opinion? We've asked whether or not you were asked to give an opinion, and you said, yes, 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 I was.
Yep.
Did you give an opinion at that meeting about whether or not you believe, in your opinion, the contact between the SUV and the Traverse, the Lexus and the Traverse, could result in the damage to the taillight,
Yes.
What did you tell him in the meeting?
What we talked about already in the stand here.
Okay. So what you relayed to him was exactly what we relayed in this room.
Yes.
And he asked you, he told you that he was going to ask you to look at the video, correct?
Yes.
You're going to be asked a series of questions about that video, correct?
He told me the video, and he said, okay, this is the video. This is what they think the taillight was broken. And these are the pictures of his car that they take. So they asked my opinion on, do you think that's where a taillight would be broken?
And he told you, you need to make sure that you tell the jurors that could have happened in this impact, right?
He did tell me I had to make sure jurors, that's my opinion on, it doesn't appear to happen in that video.
Did he tell you that it would be helpful to the prosecution if you said that it would be, that it was inconsistent with the taillight break?
Objection.
I'm going to allow it. Did he tell you it would be helpful to the case if you said that?
No,
But you knew it would be, right?
I'm just stating what I saw on my professional opinion on what it is.
Got
If it looked like it was consistent, I would say it's consistent. If it wasn't consistent, it's not consistent. I'm not going to.
I'm sure that's what you would say.
Okay, so comments are not appropriate for the jury. They're also not very good for me, Mr. Jackson.
Did you formalize your new opinion? Because this is a new opinion, right? You've never been asked this opinion before.
Yes.
Did you formalize this new opinion in any kind of report, memorialize it in any way?
No.
Did Mr. Lally ask you to create a report of some sort that you can turn over to the defense so that we would know that you have a new opinion that you're going to testify about?
No.
Did you save those notes that you took about making sure that you were on the same page as Mr. Lally?
Yeah. Save my.
Where are they?
They're my report.
They're in your report?
Yeah, as I was writing a report, I just kind of highlighted stuff that I want to make sure I memorize and remember my report.
Okay. I'm talking about notes specifically about this video, saying this video and rendering a new opinion about this video.
No, I didn't have notes specifically about this video. I didn't write anything down saying I must do this on this video.
Did you write anything down about the new opinion that you would come up with related to this video?
No, I did not.
Yep.
And your opinion ultimately that you imparted to Mr. Lally in that meeting was that the car did not move and the snow did not move, correct?
Correct.
I think that's all I have.
All right. Did you want to follow up at all, Mr. Lally?
Oh, thank you, Your Honor.
All right. So, Trooper, you are all set for today. We will see you Monday morning.
Thank you.
Okay. All right. So you're moving to exclude this. I'll hear you, Mr. Jackson.
Your Honor, it's very clear that this is a blatant violation. Commonwealth has at least the obligation to provide us with any new opinions that any expert's going to testify to on direct examination. They've known about this witness for not months, for a year, for a couple of years. They've known exactly what this witness has memorialized in his official report. They knew that it was the only thing that we had was the official report. They met with him 2 weeks ago. This has become a pattern of conduct by the Commonwealth over and over and over. We're finding these witnesses getting on the stand, finding out that there's been a sort of preemptive strike in some sort of a prep interview where they're coming up with new opinions, new conclusions, new facts. It happened with Jennifer McCabe. It's a new fact about coming up, going to Michael Lank's house. It happened with Officer Sarah, coming up with a new determination about what was said or not said at the scene that we had never heard before. That was also a prep session of some sort, or I believe it was. And then this witness, literally, it's not even like just, was it light out or was it dark out? This is a completely new opinion based on evidence that we presented, both in or talked about in opening statement and have presented variously throughout this trial. And this officer gets on the stand and now has a new central opinion about whether or not we're right and that taillight lens can be cracked. That's something that should have at least been reduced to writing. And even if it was reduced to writing, it should have been excluded because it's a discovery violation. It's late. We don't have time to prepare for it. And we're caught off guard. I use the word at sidebar ambush, and I know that rankles the court, and the court doesn't like it, but that's exactly what it feels like.
Well, that's been used both ways here, right? So it's a word. Let's just take it out of here. Make your point. Okay.
I'll see if I can come up with a synonym for it.
Well, I
feel like
understand I understand your argument. So focus on just continue where you were, but no comment whether I like ambush or don't like ambush. It's a word I've heard a lot on both sides.
I understand, Your Honor. My point is the evidence that now is being sought should never be presented in front of you. We didn't have opportunity to get this in advance. It's at least been in the Commonwealth's possession for weeks. He took notes about it. He now says, well, I didn't take notes about that specifically. I don't believe that as far as I can go. I think he did take notes about it. He was shown the video. He provided a new opinion. Mr. Lally knew that he was providing a new opinion. And then the first time he discloses this opinion is in front of 16 jurors, 15 jurors. We would ask for its exclusion, Your Honor.
All right, Mr. Lally.
Yes, Your Honor. As far as a pattern, especially coming from counsel, I simply find it laughable. As far as Officer Sarif, I think what counsel was referring to was testimony that was in his grand jury testimony. It was crossed about whether or not it was in his report, but it was in his grand jury testimony. As far as Ms. McCabe is concerned, that was regarding reciprocal discovery that was given to the Commonwealth weeks into trial by the defendant. It was then shown to a witness, which is perfectly permissible. Counsel asked a question of Ms. McCabe on cross, and she was aware of the material based on the late disclosure of reciprocal discovery. So there's no violation there. As it relates to, and why I say laughable, Your Honor, is that I am still...
I don't like hearing you say laughable. Just
Understood.
stick to what the arguments are. And
With respect to this witness...
Hold on. Quit the finger pointing, name calling, things like that, please. I know it's been a long week. It's been a particularly long day, but just focus on what you want to argue to me.
And I apologize to the court for that, Your Honor. With respect to this testimony, it's well within his realm as a crash reconstructionist. This is a witness who's responded to and investigated hundreds of crashes involving damage to vehicles, simply making an observation of contact between two vehicles or reported contact between two vehicles on a video. The force is self-evident, and whether or not that force is sufficient to cause the damage that he personally observed on the defendant's vehicle is well within his expertise, and should be permissible as far as for this witness to be able to testify to.
What about the non-disclosure to the defense? Showing this video and asking for an opinion. What about that?
So, Your Honor, what I would say is I did not show this video and ask this opinion. This is a video that's actually the trooper mentioned to me that he had seen over the course of while the case was pending, probably over a year ago, that he had seen that video. What I showed him was the photographs of Mr. O'Keefe's vehicle and asked whether or not he observed any damage consistent with the damage to the taillight observing or popping up on Mr. O'Keefe's vehicle.
Why wasn't that turned over?
In hindsight, it should have been, Your Honor.
All right. So it's late. I'm not ruling here. I want to review everything. I'm not obviously taking any of the evidence home with me. I would like, if it's possible, for what your IT person did on the expanding, like he did this second time, maybe I missed it, but I didn't see the tire move this time. So I'd like that. I'd like that video. And I would like, what's the exhibit number here?
So Exhibit 6. Do you want just that video, Your Honor?
And the pictures of the cars, whatever was shown during this voir dire, I would like those emailed to me so that I can look at them this weekend while I'm deciding, or put them on a flash drive right now.
That's what I'm later.
I'm sorry, I can't hear you.
We'll do a screen report and get it to the court by email. We can do that. I just need an hour once we get back to the base.
Okay. All right, Ms. Gilman, will you burn what you have for me before we leave somehow?
You know, if I could, I just want to close one loop.
Okay.
What I was referring to with Ms. McCabe, I want to make sure that this is clear because this has come up a couple of times. The only thing I was referring to, or what I was referring to, is something older, but what I was referring to with Ms. McCabe is after Ms. McCabe testified, days and days and days after she testified and she was excused as a witness, then we got the report from Lieutenant Tully about the new information that she disclosed on the witness stand. In other words, she was cross-examined about it, etc. And then after she testified and was cross-examined and gone, then we got a report that predated her testimony. That was in the possession of the Commonwealth, or at least in the possession of Lieutenant Tully. That's what I was talking about. I just want to make sure that that's clear. We don't need to go into it any further.
Did you want to add anything to that, Mr. Lally?
No.
All right. So I'll see you Monday morning.
All right.
So the actually report during case down here should truth, all truth, and nothing but the truth, so help you God.
I do.
Morning, Trooper. All right, Mr. Lally, whenever you're ready.
Good morning, sir.
Good morning.
If you could just again, please state your name and spell your last name, sure.
Yes, it's Trooper Joe Paul. That's Paul.
And sir, if I could just take you back to a couple different portions of your testimony from Friday. With respect to the acceleration and braking tests that you conducted in the driveway area or outside of Canton Police Department, was that before or after Ms. Hartnett from Crime Scene Services Section had processed the vehicle?
After.
And so as far as anything that was removed by her, that was done prior to you conducting any of your tests, is that correct?
Correct.
Now, you've investigated approximately 191 crashes over your time in the cars unit with the state police, correct?
Correct.
Now, I'm going to ask you just some general questions with regard to a number of those crashes have involved motor vehicles, collisions with other motor vehicles, correct?
Yes.
Now, in general terms, with respect to motor vehicle collision, what, if any, you talked a little bit last week about sort of area of impact and point of impact, correct?
Correct.
Now, that's with regard to the roadway, is that correct?
Yes, it is.
So with regard to the vehicles coming in contact with each other, what, if anything, regarding damage would you expect or anticipate based on your experience in general terms when vehicles come in contact or touch with each other in a collision sequence?
Objection.
No, I'm going to allow it. In general terms, what do you look for?
So we look, well, it's two types of damage onto a vehicle. One's contact damage and one's induced damage. So when we look at vehicles, we are looking for what's caused contact damage. And the induced damage is basically, let me start from the beginning. So contact damage is the damage that is actually made direct contact with another vehicle. And induced damage is the damage that did not make direct contact. So for example, if you push in one piece of metal to make contact, the rest of the metal will make a rippling effect that would more cause induced damage.
And just again, in general terms, as far as vehicles coming in contact with each other in a collision sequence, what, if anything, would you expect or anticipate based on your experience to sort of transfer from one vehicle to another event?
It's possible when you transfer, you can have paint transfers that come from one vehicle to another. You got tire rub off that go from one vehicle to another. Scratches that would come from one vehicle to another.
And again, so just in general terms, when it comes to vehicles interacting with each other in a collision sequence, what, if any, role does the respective heights of those vehicles play in respect to contact damage or inducement?
Yeah, it depends on their heights and how they relate to each other. So that kind of shows if one vehicle's taller and smaller, it's going to show where the contact damage would be from one vehicle to another based on their height.
So based on respective heights, contact or induced damage could be in a different location from a bigger vehicle to a smaller vehicle, correct?
Correct.
Now, if I can turn you back to the tech stream analysis that you conducted with respect to the defendant's vehicle. Now, the two events that occurred. On that 1269 miles deep, there were two events that occurred within that trigger, within that mileage. Is that correct?
Correct.
And based on your analysis with respect to the odometer readings and the mileage, where is it? What is your belief as to where the vehicle was when those two events, being the 3-point turn and the backup straight for approximately 60 some odd feet? Where did those occur within the travel path of the defendant's vehicle?
So the first one with the 3-point turn, in this case, it appeared to be possibly onto as a cedar crest, which, because we know based on testimonies that she missed the exit to Fairview and had to make a U-turn onto Cedar Crest, and that would make sense to why they would occur with close proximity to each other. They're within the same odometer mileage and on the same key cycle.
And so that occurred 24.2 miles per hour for 60 some odd feet. Where would that have occurred geographically from your view of the odometer reading?
It should occur on Fairview.
Now, sir, based on the totality of your analysis and your investigation in this case, what, if any, conclusions did you come to as to how this collision sequence occurred or how this crash occurred?
Yes. Can I show my report for that, or should you want me just kind of go off it? Yes. Okay. We continue.
If you could, please.
Okay.
What, if any, conclusions did you come to through towards your investigation?
So on Saturday, January 29th, 2022, at approximately 12:45.
So you can look at your report, but you can't read your report.
I'm
So
reading my conclusions based on what they asked me to do. Okay.
yeah. So I can't hear you.
Sorry.
Okay. So just take your time, read your report, and then answer Mr. Lally's question. And if you need to look at your report, we'll see about that again.
All right.
Ask the question, Mr. Lally.
Based on the totality of your investigation, what, if any, conclusions did you come to with regard to how this collision occurred?
So this collision occurred on Saturday, January 29th, 2022, at approximately 12:45 hours. A 2021 Lexus LX 570 was traveling southbound on Fairview Road, in Area 34 Fairview Road.
Yes.
It appears that.
So,
I'm trying to hold it.
you know what? I don't, Mr. Lally, break this down. Ask
Yes.
simple questions so that the witness can answer your questions. We don't need a narrative.
From your investigation, what, if any, conclusions did you come to as to where this collision occurred?
So, all right. So on the night of Saturday, January 2022, at approximately 12:45 hours, a 2021 Lexus LX 570.
Can you slow down? Sorry.
So yes,
So forget all that part,
Okay.
Trooper.
All
Just answer the question.
Okay.
Where did it occur?
it occurred in Area 34 Fairview Road.
And who, if anyone, were the participants in this collision sequence?
The operator appeared to be Karen Reed, and the pedestrian was John O'Keefe.
And where was the vehicle located in reference to the residents of 34 Fairview Road?
It was located along the southbound travel lane and to the left side of the house as you look at it from the front.
And as far as the vehicle, what, if any, directionality did it head in, and what, if any, interaction did it have with Mr. O'Keefe?
So the vehicle was traveling in reverse along the southbound travel lane, traveling north.
And how fast was the vehicle traveling and over what distance?
The vehicle traveled up to 24 miles per hour and approximately 62 feet.
And at the time that the vehicle was traveling approximately 24 miles per hour over approximately 62 feet, what, if anything, occurred then?
The right rear of the Lexus struck the pedestrian John O'Keefe.
And post-collision, what, if anything, occurred with regard to Mr. O'Keefe?
Mr. O'Keefe was projected forward and to the left along the front yard of 34 Fairview Road.
And post-collision with Mr. O'Keefe, what, if anything, did the defendant's vehicle?
The Lexus continued traveling in reverse before they left the area.
Now, as far as the vehicle itself, from your inspection, what, if any, role did any mechanical aspects of the vehicle play in this collision?
There were no mechanical defects.
As far as your analysis of the roadway and other factors related to that, what, if any, role did they play in this collision sequence?
There were no roadway or environmental factors that contributed to this collision.
Now, sir, with respect to your investigation, what, if any, opinions did you draw based on your training and experience in regard to this collision and how it occurred?
May I look at my report real quick, just to make sure?
Yes.
Thank you. So throughout my investigation, this appeared to be a single car collision involving a pedestrian. The vehicle was traveling at a higher acceleration when Sorry. The vehicle accelerated at a high rate of speed before she struck the pedestrian John O'Keefe on the roadway and subsequently left him at the scene.
And with respect to the backup safety system that you observed in this vehicle and made use of in the course of your visibility analysis, what, if any, role do you, is it your opinion that played in how this crash occurred?
Based on the visibility analysis. So even if the camera systems were covered in snow, even the systems were defective anyway, and even the mirrors were blocked, an attentive and reasonable operator would not travel in reverse, especially at a high rate of speed. They would have cleaned the mirrors off. They would have made the cameras and systems, if they worked, if they didn't work, they would have done all this prior to accelerating in reverse.
The objection sustained.
Move to strike.
I'm going to strike that.
With respect to your observations during the course of the visibility analysis, the exemplar pedestrian that you placed in the right rear of the vehicle, was that exemplar pedestrian visible to you at the time that you conducted that visibility analysis?
Yes, it was.
Thank you, sir. I have no further questions.
Okay, cross-examination?
Thank you, Your Honor. So do you have any, do you hold any degrees in the scientific discipline of mathematics?
I do not.
Do you hold any degrees in the scientific discipline of physics?
I do not.
Do you hold any degrees in the scientific discipline of biomechanics?
No.
How about in engineering?
No.
How about in kinematics?
No.
What's the highest degree that you do hold, sir?
I have an associate's degree.
In what?
Administration of justice.
You mentioned kinematics on Friday. Do you hold any certificates in the specific area of kinematics?
Yes, it's covered in the basic crash investigation classes.
Okay, so you took a class, in other words, correct?
Multiple classes.
You introduced the idea of what kinematics is, right?
Correct.
You testified about that on Friday.
Yes.
Define kinematics. What's yours?
It deals with the aspect of motion.
It's a subfield of what broader field?
Kinematics?
Kinematics is a subfield of what broader discipline of science?
I'm not sure.
Physics, correct?
Yes.
And it describes how points and objects and systems of objects, how they move and how the rate they move and the rate of their velocity, correct?
It deals with the motions.
What's that called? The rate of velocity. What's another word for that?
The rate of velocity?
Correct.
I mean, it deals with motion. It deals with forward and also deals with speed. It deals with travel and speed. If something's moving, it also has a speed to it.
Right. The word you're looking for is acceleration, correct?
Sure.
What role does acceleration play in the field of kinematics?
What role does acceleration play in kinematics?
Right.
It talks about, like you just said, it talks about the speed and it talks about motion.
Is kinematics also known as the geometry of motion? Is that correct?
I have not heard that.
Never heard that. What's the difference between constrained and unconstrained motion?
Constrained and unconstrained motion?
That's what I asked.
Constrained motion. I can't recollect that at the moment.
Constrained motion is motion on a predetermined path, isn't it?
Yes.
Unconstrained motion is what?
When it doesn't have a predetermined path?
Free movement, correct?
Correct.
So remember that from your class?
For the most part, we don't go that in-depth, constrained and unconstrained.
Constrained and unconstrained, not restrained.
Sorry, unconstrained. Yes.
Kinematics uses algebraic formula to model these motions, right? The motions of these points, systems of points, correct?
Yes.
And it includes concepts like displacement and speed, velocity, distance, acceleration, which we've talked about, correct?
Correct.
And it looks at how these things, these values vary over a point in time or duration in time. Is that right? Do
Yes.
you actually understand the physics behind the study of kinematics?
Yes.
Or do you learn in class?
Yes, we had to go over the physics part of it.
On Friday, you said that this incident is a pedestrian strike from a vehicle. You reiterated that again this morning. Is that right?
Correct.
I want to be clear. That is your opinion based on your training and experience, correct?
Yes.
And on Friday, you said you based that opinion on the fact that you noted a half-mile-an-hour decrease in speed and a steering input of less than 10 degrees at some point in that reverse motion, correct?
I said it was consistent. That data point in general was consistent with something that you would see within data of a pedestrian striker striking something else. I do go in my reports, and I can't say that's definitively where a pedestrian was struck, but
I'm sorry.
it wasn't definitively. Sorry, in my report, I do say I can't say that is definitively where the pedestrian struck.
You cannot say.
Definitively, yes.
Okay, so you're going to have to slow down and speak up, okay?
You said, I just want to make sure I'm hearing you correctly, and I apologize.
Okay.
You said you cannot say definitively that resulted in a pedestrian strike.
That data point within the text stream data is what I'm talking about.
Okay.
That specific points, that time frame.
Because there's a multitude of reasons why when someone is driving in reverse, they might slow down by half a mile an hour, right?
It's when I say when it's consistent is because there's the other aspects of it is the fact that the accelerator is consistently strong.
Let him answer. Finish your answer.
So the accelerator is consistent at a constant rate, and then it just drops by half a mile, and the steering wheel all of a sudden abruptly goes to the right. That's what I'm talking about when I say it is consistent with a pedestrian strike. That's something that you would see. It's not going to be a huge change of speed during this collision.
You also note that at the time, it had begun to snow, correct?
Yes.
There would be snow on the lawn, right?
Correct.
There would be snow on the cars,
Yes.
snow on the trees,
Yes.
snow on the roadway.
Yes.
Snow on the roadway could impact how tires move over the roadway, correct?
In a way.
And obviously there are a multitude of reasons why somebody might input a 10-degree input on a steering wheel, correct?
Correct. That's why I couldn't definitely say it.
Right. So every time somebody slows down, going reverse or forward, and introduces a 10-degree input on the steering wheel, doesn't mean they're looking to hit a pedestrian, correct?
Correct.
You testified that you determined the area of impact by basically following, if I heard your testimony correctly, basically following the debris field from the body, from where you believed John O'Keefe's body's final resting place was, almost linearly to the furthermost piece of debris that was found. Did I get that right?
Yes.
In other words, you established what in your mind, or what you were told was his final resting place, and what you were told was the debris field. And you indicated that the furthermost piece of debris would basically be the area, right?
It's within that line. I didn't say that is the area impact where the furthermost piece of evidence is.
Right.
It's just the linear, like you said earlier, it's that linear. We're going that path. That's the path that he traveled post impact with the vehicle.
And that is on which that fact that you stated is on which what you. It's a terrible question. That's the basis for your opinion of where the area of impact was, correct?
Yes.
Let's take a look at exhibit, with the court's permission, 587. It's your diagram 3. I may approach you on this verb
Okay.
so you can see it. Your Honor, you publish exhibit 587.
Yes.
Okay. Sir, you see diagram 3 on board. You also have it in front of you, correct?
Yes.
It's easier for you to refer to what's in front of you because that's a little bit further away. Just let me know.
Okay.
The red arrows adjacent to the blue writing, where I'm highlighting right now, indicate basically the debris field changed lanes with jurors on Friday, correct?
Yes.
And then there's a point of an arrow that comes back to a wording that says pedestrian's final rest, basically right there, correct?
Yes.
And the debris field ends right in the middle of that spotlight, correct?
Yes.
All right. So that's the area of impact that you indicated to Mr. Wally you believe occurred because of the debris field and the linear portion of that debris field going from the pedestrian's final rest all the way out to that final little red arrow that says red plastic B in parentheses, correct?
Yes.
Can we have exhibit 492 published in the journal, please?
Okay.
While that's coming up, have you ever seen this?
No, I haven't.
Take a look just above the arrow. Your Honor, with permission, maybe highlight or magnify the area just above the arrow.
Okay.
You see that
Yes, I do.
right underneath fire hydrant, correct?
Correct.
What does that look like to you?
Piece of plastic.
It's debris, correct?
Correct.
All right. Can we go back with the court's permission to exhibit 87?
Okay.
Diagram 3. You see the fire hydrant?
Yes.
Fire hydrant's right there, correct?
Correct.
That's another, according to your scale, that's probably a good 30 feet from the pedestrian's final rest, correct?
Yeah, that's about right.
That is the furthermost in this diagram, the furthermost piece of debris on the diagram, correct?
Correct.
So now your testimony changed that this, in fact, is the area of impact.
No,
Why not?
because it's just a piece of debris. I'm talking about the path. You follow the path of debris field. Debris can move and change.
The debris doesn't fly backward, does it?
I'm saying you pointed to just the fire hydrant as the area impact for the debris, where that one piece of plastic was, saying that's the area impact is right next to the fire hydrant.
Are you asking me a question?
Yeah, that's what you said, right?
I'm asking you,
I'm making sure I'm understanding what you're saying, so I can answer the right.
Ask the question again, Mr. Jackson.
in fact, you indicated on Friday that your analysis of the area of impact was predicated on, based on, the furthermost piece of debris from the pedestrian's body that you were aware of, which is right there. Red plastic B, correct?
I said well, I said you said earlier with the linear equation. I mean, it might have moved it over more, but it's the debris, the start of that debris, and what that is. I can't say that's definitely the point of area impact or the point of impact.
You can't,
I cannot say that is the point of impact right there. You just kind of follow the linear path because they have to follow in a direct path that way.
Okay, so now your testimony is that's not the area of impact.
I never said that was the area impact. I said it's after that.
Trooper, we were all here on Friday.
Okay.
It's exactly what you said under questioning by Mr. Riley, wasn't it?
Objection.
Sustained.
Didn't you say on Friday that you determined the area of impact for Mr. O'Keefe, the point of impact, was red plastic B because that was the furthermost piece of debris you were aware of from the final point of rest for Mr. O'Keefe's body? Isn't that what you said?
I don't believe that's my exact words.
Okay, I'm not asking if it was your exact words. I don't have a transcript of it. I'm asking you, is that what you tried to impart to the jurors?
What I said to the jury, I said after that. That's the start of that's the last point of evidence that I had. I said the area impact is probably along the roadway after that point. I mean, like before it. We have to walk towards him.
I'm sorry, I keep doing that because I think you're done. Are you done?
I am done now. Sorry.
Now you're aware that there's a piece of debris, looks like taillight material, right under the fire hydrant, correct?
Correct.
If the area of impact, which you indicated on Friday, was where this red plastic B is, you would be wrong, right? Your analysis would be flawed.
No, because that's not what I said. I said it's along the roadway. It's going to be after that point.
Okay, so is the area of impact now where the fire hydrant is?
Objection.
Ask it differently.
are you now indicating, because now you realize that there's a piece of debris directly under the fire hydrant, are you now indicating that that's the area of impact where John O'Keefe's body was struck?
Objection.
Sustained.
Let's take a look at exhibit, with the court's permission, 279.
Okay.
Take a look at exhibit 279. I'm going to draw your attention to that piece right there, of plastic. You see it?
Yes.
You describe it for me. Just physically, what does that look like?
It looks like clear plastic with a little bit of red and the black on the top part.
Okay. Maybe in a triangular shape. Is that fair?
Correct.
Okay. Now, if we could go back to, with the court's permission, exhibit 492,
Okay.
and highlight just above the ruler. How would you describe that piece of material?
It looks like the same piece.
Does that, based on that, does that appear to be part of the taillight material that was found at the scene?
Correct.
Now, based on that, are you now suggesting, if we could go with the court's permission, if we could go back to 587, I'll stop jumping around just a second. I think we
Okay.
just get back to 587. Oh, sorry, the diagram. Now, seeing what you've just now seen in terms of that piece of plastic that appears to be from the taillight, does that appear to be under the fire hydrant, which is highlighted? Same piece.
Yes.
Based on that, does that change your opinion? Is that now the fire hydrant now the point of impact?
No.
Where's the point of impact now?
It's along the roadway. I don't know the exact point of impact. Can I?
So you don't know the area of impact.
I said the area impact is along the roadway after the debris.
Okay.
I mean, the only thing that would change, only thing that would change is maybe it was a little further away. But besides that, it's a linear field. I'm not talking about like one point. You've kind of followed the middle of the debris field, and that should be the path.
Well, if the point of impact is along the roadway, where along the roadway, you can show the jurors where along the roadway, in your expert opinion, was the point of impact.
It should be within, if you follow from pedestrian's fine rest here, just kind of follow it back. That's what I'm talking about, linear field. I can't.
So now you've indicated an area, I can follow your laser pointer, an area along here, correct?
Yes, somewhere in there.
All right, if I have my spotlight, is that, if I leave it right there, is that about where the middle of the spotlight, about where you believe the area of impact is?
It's within, I guess you can say it's within that area. I don't know, definitely there's something on the roadway that has a definitive point that says this is the area impact right here. It's within the roadway based on the evidence at the scene.
Okay. Mr. Paul, sorry, Trooper Paul, I'm asking you, based on your expert opinion and your conclusions, based on your full analysis, can you point me to within an area of 5 feet or so on the roadway where you believe the area of impact is? Is my spotlight basically highlighting the area that you believe, in your opinion, is the area of impact?
You have that laser pointer?
I do.
Why don't we let him show you? It'd be easier for the jury to see.
So what I'm trying to say is, so we follow the linear path back around this area.
Okay, can you,
And sorry, I'm trying to keep it straight as much as I can. Follow back to here. I can't say like if this definitely is, but it's possibly based on also vehicle damage to the back of the vehicle. So if we follow back to here, that could be a possible area impact.
so when you say that area there, just I want to be very clear for the record, that what you highlighted is an area basically just to the left of an X that's on the roadway, on the bottom of diagram 3, toward the lower part of diagram 3.
It's
correct?
You would use your circle almost kind of be a good area around.
Sorry.
You can use a circle around here. This would be around the area.
Okay.
Okay.
So using your scale, that scale is going from full left to full right. It's plus or minus 40 feet, right?
Which can't see it. So say again. Say the question.
That scale is 40 feet. Going full left, full right, 40 feet.
It's 40 feet. It's a 10-foot scale.
Okay, sorry, 20 feet. My mistake.
That was, yeah.
As observed. 20 feet. Okay. All right. So if you use that scale, can you estimate for the jurors? I'm just going to use this X as a starting point. Can you estimate for the jurors from this X that I highlighted? The pedestrian's final rest. What's that number? Doesn't have to be exact. Give me an estimate.
So I mean, it could be within 30 feet. There's also on my scale, this 2 and 3 is 50 feet from each other.
It's how much?
50.
50.
50.
So would you agree that from this X down here to the pedestrian's final rest, that's pro plus, that's probably a good 35, 40 feet,
I mean, I could try to use the scale. It is near the scale.
if you wouldn't mind. Do you need a piece of paper?
Yes, please.
With permission?
Okay.
Just one piece of paper.
Thank you. Yes, thank you.
You need a pen?
I got one. Thank you. It's around. It's approximately 30 feet.
Approximately 30 feet.
Yes.
Can you place, with the court's permission, can you estimate 30 feet in here?
Can I
Can you point to a place in the courtroom that looks like it's 30 feet from you?
Objection.
No. Next question.
Does the court have a diagram of a diagram of distances?
In this courtroom? No.
You indicated just now, and then I'm finished with this. Thank you. Thanks. You indicated just now, in answer to Mr. Lowry's last couple of questions, that in your expert opinion, when the SUV struck the pedestrian, John O'Keefe, he was, quote, projected forward and to the left, to the front yard to his final place of rest.
Yes.
So your expert testimony is that John O'Keefe was hit with the SUV and flew 30 feet.
Projected, I mean, like I don't say he flew all the way there. He was projected in that way. He got pushed forward in that direction.
Which, if he was rendered incapacitated, landed there, that's sort of fly there, right? He didn't walk there.
I mean, would you definitely flying like literally off the ground the whole entire time? Or,
Well, you tell me, you're the expert.
I mean, when we say projected, he gets projected and they usually have a landing phase and they land and they either roll or tumble to final rest.
Okay, how far do you think he landed? How far was it until he landed of that 30 feet?
I don't know. There's no indication of where his exact landing spot was.
Is there any evidence whatsoever that he landed and rolled?
And there was no evidence that he landed or rolled. Or no, rolled.
According to you, the evidence that you have in front of you is that you get hit, fly 30 feet, land where he ended up at his final rest, right?
Objection.
Sustained. Ask it differently.
Based on your expert opinion, you believe that he was projected through the air to his final rest place.
That's not what I was saying.
But you said there's no evidence that he rolled.
And there's no evidence that he flew through the air either.
Exactly. Right? Exactly.
Objection.
Sustained.
You said on Friday that in your experience, people tend to lose objects that are not strapped to them. Is that right?
Yes.
In other words, get hit by something, car, truck, bus, whatever, train, and if you have something in your hand, boom, you lose it, you drop it. If it's not strapped to you, correct?
Correct.
How do you suppose that Mr. O'Keefe, in your opinion, held on to that glass cup that was found right next to him over the course of 30 feet being projected?
Objection.
I'll allow it. Do you have a theory on that?
I don't know. I mean, it just could have been with him the whole way. I don't know. I wasn't there, so I don't know how the glass stayed with his body and went with him to the final rest.
So it's just common sense. You have to believe that it was in his hand. He held on to it the entire time he was being protected. Correct?
It's possibly, it could have been in his hand. It could have been stuck next to his clothing. Did
you say tucked in?
I mean, like, could have been next to his body. So when he projected, maybe the glass was with his body as it was also flying. So there's a number of reasons why the glass also got projected with the body while he was holding it.
I thought you said on Friday, and you disagreed with me, that people drop things and they're hit.
Yes, body not everything it tends to fly off. I mean, some stuff flies off, some stuff will stay on. It's not uncommon to find a piece of clothing and stuff, that you find at the scene.
Piece of clothing?
Like clothing, like shoes, like shoes and stuff like that to come off the body during a pedestrian crash.
Well, that's not what I asked.
I know, I'm just saying, you asked me, you said I'm just responding to what you said. And trying to make sure you understand what I'm saying.
No, I don't, but I'll ask another question. Shoes are strapped on by definition, right?
Yes, but it's very common for shoes to come off.
How about his cell phone?
Cell phone, yeah, it depends, depending on where it is.
Well, it was under his body.
Okay.
How do you account for that? He held onto his cell phone with one hand and held onto the cup with the other.
Objection.
Sustained. Ask it differently.
If the cell phone was found under his torso, under his body, what's your theory on how that cell phone ended up flying 30 feet?
It just did.
Just did. And somehow, as he landed, tucked that cell phone underneath his body so he landed on top of it.
It just did. That's the evidence at the scene. I didn't put the evidence there. So
Well, you didn't.
Objection.
All right. So jurors, I've told you before, lawyers cannot make comments. So disregard it. Mr. Jackson, don't do it
I
again.
understand. So
You understand, but don't do it. Your answer is always, I understand. Don't do it.
Yeah, sure. Cell phone in one hand, cup in the other hand, flew through the air. Right?
Objection.
Sustained.
You were informed of this incident on January 29th, 2022 at about 2:30 in the afternoon. Is that right?
yes,
At the time, you were working out of the CARS facility, which is located on West Grove Street in Middleborough. Is that right?
yes,
By the way, that's a facility that has multiple garages. Sally ports, I don't know if they're called Sally ports, but garage bays, correct?
the mechanic shop are there.
The mechanic shop
Yes,
is, if you're going to review, for instance, for purposes of reconstruction, if you're going to review a vehicle, is the vehicle placed in those mechanics bays?
no, not there. That's for state police vehicles.
Okay, so where are the mechanics bays? Sorry, reverse that. Where are the Sally ports where you do your analysis, your reconstruction, your review of the vehicle, inspections, things of that nature?
We don't have Sally port for that.
You don't have anything dedicated to that?
No, the only time we would use a Sally port is the crime scene would have some Sally ports that they would do to document their crime scene stuff. And I've gone there, they've done my inspections, but most of our inspections are done either at the tow yard or some type of facility for that.
Ultimately, was this SUV ever taken to the Middleborough facility?
Yes, it was.
Where was it placed?
There's a fenced in area inside it's a fenced in area
Is it outside or inside?
outside.
Okay. Did it remain outside in that fenced-in area the whole time?
I don't know the exact time. It was there for a while, then it got moved.
Where did it get moved to?
I'm not sure exactly where they moved it immediately after it left Middleborough.
Are you familiar with the Foxborough location?
Yes.
Does that have Sally ports or bays for inspection and evaluation?
It has garages in it, but we wouldn't use them. We don't normally use those garages for inspections.
Is it possible to use those garages for inspections?
It is possible.
Okay. It's happened before, correct?
I've not used the inspection in the garages.
But,
I'm going to ask you to keep your voice up and
Sorry,
speak
yes.
slowly.
but you know they could be used.
Sorry.
You know that those bays could be used for inspections or analysis or evaluation if needed, correct?
Yes.
Given the fact that the SUV that was being seized on January 29th was being seized as potential evidence, best practices would suggest that you want to get it in and out of the bad weather, the inclement weather, as quickly as possible, correct? You would want to subject it to continued forces from nature like rain, wind, snow, sleet, hail, right?
That would be beneficial, yes.
you're aware that the Foxborough location and the Middleborough location with the mechanics phase are all closer to Dighton than Canton, right?
Both Foxborough and
Foxborough and Middleborough are both closer to Dighton than Canton. In other words, you have to pass by, depending on which way you go, pass by Middleborough, pass by Foxborough to get to Canton.
so from where?
From Dighton, sorry.
So from Dighton.
Where the vehicle was seized.
Yep.
All going toward Canton. You pass by either Middleborough or Foxborough to get to Canton. Right?
I don't believe you pass by Middleborough to get to Canton, but you pass by Foxborough.
All right. The car was not taken to Foxborough, was it?
No.
Matter of fact, the car was taken basically double the distance all the way to Canton. That's how, correct?
Objection.
Do you know that? Is that double the distance?
I don't know the exact distance. I know it was in Canton.
And you know it's far to Canton.
From Dighton, yes.
Right. And you're also aware that, because you've been to the scene, assuming correct, the 3430.
Yes, I have.
And you've been to Canton, PD.
Yes, I have.
You know those two locations are about 3-4 minutes apart.
Yeah, I can say that.
When you started let me ask this a little bit different way. Before you began any review on this case, any physical review on this case or analysis on the case, you were told that there had been a crash, correct?
Yes.
You testified to that at the state court grand jury in this matter. Is that right? That you've been told in advance this was a vehicle pedestrian crash, and you were asked to analyze it, right?
Yes.
You wrote in your report that it was a single vehicle collision involving a pedestrian, and you were, quote, assigned to reconstruct that collision, correct?
Yes.
So when you began your analysis, to Paul, you were told conclusively by the lead investigator, Michael Proctor, that the deceased was hit by a car, and your job was to reconstruct it. Is that right?
Objection.
Okay, so there are lots of parts to that. Break it down.
Sure. Were you told by Michael Proctor to reconstruct this incident?
Objection.
So were you told that by Chief Proctor?
I was not.
Okay, next question.
Sure. Who were you given your instructions by
Instructions for what?
to reconstruct this incident?
I wasn't given instructions to reconstruct it. It's just I was assigned to it.
Right.
That was requested. My assistance was requested to reconstruct it.
That's my question. Who assigned you to it?
I talked to my sergeant at the time. He gave me the phone call.
And you were told some basics about that reconstruction, the event that you asked to reconstruct, correct?
Yes.
The information that you were told came from the case officer. Is that right?
Who's the case officer?
The information that this was a pedestrian vehicle incident, as opposed to motor vehicle incident, pedestrian bicycle, motor vehicle motorcycle. You were told it was a motor vehicle pedestrian incident that you were asked to reconstruct, correct?
Yeah, I was told that. Yes.
All right. And you had to be given some basic parameters of what that incident, how that incident occurred. The car was going in reverse. It's got a damaged taillight, things like that.
Some basic stuff. Yeah.
What I'm asking is, I'm trying to get to is, who gave you that information? Where'd it come from?
That the car was traveling in, like, which part of the information? You asked me several different things just now.
Were you given information from multiple sources? Or did someone give you a summary of what you were being asked to do at the very beginning?
Yep.
Who gave you the summary
The summary of the whole entire of what?
of the event that you were asked to reconstruct?
I was passed down when I got to the garage. That there was nobody that sat there and gave me the summary, like that I can remember. I was told that it was a pedestrian crash. I knew it was a Boston police officer involved. That this was a vehicle, and that it was traveling in reverse. That's all they had.
Okay. What I'm asking is, that's great. Thank you for the summary. Who gave you that summary?
I don't know if it was definitely anybody from the get-go that was like I talked to.
From where?
I don't know if it's anybody that I could definitely say that was the person. There was multiple people going around when I got there. I think I talked to Trooper Zach Clark. He was doing the crime scene. I think he was Zach Clark. He was the crime scene photos at the time. I knew him from past crashes. He just said this is the vehicle, and I think he kind of gave me a little bit of a lowdown on what the vehicle was.
Okay.
So
My question is this: when you got that, did you call it a lowdown? You gave you the lowdown?
he gave me information. Yes.
Right. When you got the lowdown, you were told Boston police officer was involved. The vehicle pedestrian incident. Car was going in reverse. Ultimately led to the death of the pedestrian. Struck the pedestrian in reverse. Correct.
Correct.
And you were assigned specifically to try to reconstruct that incident.
Yes.
Have you ever heard of the phrase confirmation bias?
I know the phrase. Yes.
You know what it means?
I can't definitely say what it means.
Developing a conclusion and then trying to find evidence to fit that conclusion. Does that sound right?
If you say so.
You noted in your direct examination that there were scratches on the passenger side rear bumper of the Lexus, correct?
Yes.
How exactly were you able to scientifically determine that any of those scratches were from an incident on January 29th, 2022, as opposed to any other time?
I didn't have anything else on the time. Is that those scratches happened prior to this collision?
I'm sorry.
I didn't have any information that those scratches were caused from a prior collision. And so when I looked at the evidence, I knew it was in that same area, the right rear tail light. So when I looked at it, it didn't quite fit the pedestrian thing. So when you showed me the video, or I saw the video like a year ago on Court TV, I said that could be.
You asked the question. So next, keep going. He's answering. Next
trying to-
question. Then
You guys
go
have
ahead.
scientific
Hold
thought
on.
the scratches were.
Hold on. Ask a
Sorry.
question, Mr. Jackson.
You know what normal wear and tear on a vehicle is, right?
Yes.
Bumpers get scratched myriad ways, correct?
Correct.
Get scratched in a grocery store parking lot, right?
Yes.
Shopping cart can bounce off the back of the car, scratch the bumper, scratch the side of the car, quarter panel, or something, right?
Sure.
I don't want to go through it, but there's thousands and thousands and thousands of ways that a car can get a scratch, correct?
Correct.
My question is, do you, as you sit here, do you have any scientific evidence that those scratches occurred on January 29th at approximately 12:45 a.m.?
What do you mean by scientific evidence?
Well, do you have any evidence whatsoever that you can point to that those scratches occurred on that date and at that time, rather than any other time in the history of that vehicle?
Like I said earlier, the video seems to appear that's what it looks like that could have been from.
Well, you said on Friday, let's talk about those scratches for a second. because
Yeah.
You testified Friday, you were pretty clear. You said that, let's see if I can find it exactly. You said, quote, the dent and scratches for his hand could be, those are consistent with striking the Lexus. Remember saying that?
Yes, on the tailgate.
Okay, so the dent and scratches you talked about on Friday, you said were from his hand.
Yes, hand in the glass cup.
Okay. Then are those the same scratches you're talking about in terms of the bumper?
No.
So,
What are you talking about the scratch on the side of the bumper that we've been talking about?
correct.
Okay,
That's what I'm
no.
talking about. Okay. Is there any way to scientifically date a scratch?
No.
If you go out in the parking lot right now, even as an accident reconstructionist, you walk out in the parking lot right now and look at a Toyota Camry sitting there. It's got a scratch on it. There's no analysis that you can engage in to date that scratch.
Objection.
So you can ask it differently, Mr. Jackson.
Is there any way that you could, in general, look at a scratch and say, that scratch is from such and such date?
Objection.
I'll allow
Nothing
it.
more.
I'll allow it.
You cannot say you can look at evidence and shows that it may have been older than what the newer evidence would be, but there's no way to say that specific date and time and that a scratch would came from.
Right. And it's possible that any or all of those scratches on the Lexus could have predated January 29th, correct?
No.
That's not possible.
The ones that are on from the taillight and the other parts of it
Scratches anywhere on the car.
depends on what you got to pick the other scratches. You got to show me other scratches on the car.
I'm saying it's possible, since you can't date the scratch, it's possible that any or all of those scratches could predate January 29th. It's a simple question, right? It's possible.
You're being pretty broad on your scratches here.
I'm not being broad. Let me ask it a different way. Let me ask it again. Is it possible that any or all of the scratches noted on that car predate January 29th?
Any and all of the scratches? See, that's what I'm saying. You're being pretty broad. Any and all scratches on the car
Answer that question.
that
It's
predate.
Objection.
I don't know every single scratch on that car. I mean,
Overruled. So can you answer that question?
no.
possible. Testify that you noted glass on the rear bumper of the SUV, correct?
Yes.
And you said something about that glass coming from the cup.
Correct.
You also said that you did not see anything on that SUV that could be the source of those glass pieces on the bumper, right?
Yes.
When you did your reconstruction and your analysis, were you informed that none of the glass pieces, not one of them, could be matched to a cup?
I don't know anything about I don't know that.
So if you knew that the glass pieces on the bumper do not match the cup, would that change your opinion
Objection.
about that glass?
Can you answer that question?
I cannot.
You can't answer the question.
It's what was told to me as evidence
None. By whom?
by the crime scene.
Who told you?
As crime scene that was there, it says it's glass in the cup. When I did my initial inspection, that's what it was on from.
That's not what you just said. You said that's what was told to me.
Yeah, by crime. No, I said by crime scene. While I was at my inspection,
Wait, what?
it was told to me by the crime scene when I was at my inspection, at the initial inspection.
So what you meant by that's what was told to me is the crime scene talked to you.
Yes.
Crime scene say anything else?
I don't know what else you want me to say.
Trooper Proctor tell you that those pieces of glass on the bumper are somehow associated with the cup?
No.
Just the crime scene told you.
Correct.
But if you knew that the crime scene is incorrect, and in fact those glass pieces don't match the cup, would that change your opinion?
Objection.
Sustained.
Would it change your opinion in any way if you knew that the glass pieces do not match the cup?
Objection.
I'll allow that. Can you answer that question?
No.
I'm sorry. No, no.
I don't. It's glass from a cup. It's glass. It's not. It doesn't belong to the vehicle.
Right.
It's glass.
But if I told you it didn't match that cup,
What?
would that change your opinion?
Objection.
Does that change your opinion?
Are we talking which cup? We never established which cup we're talking about.
How many cups have we been talking about, Trooper?
You said that cup. One from the scene. Okay.
That cup. I'm talking
I just want to make sure that we're on the clear path here. On the clear what we're talking about.
absolutely.
Okay.
Really sure.
All I said it's
It's found next to John O'Keefe's body in the snow at 34 Fairview on January 29, 2022. You got the cup in mind?
yes.
Okay. That's the cup. When I say cup, that's the cup.
Okay.
Would it change your opinion if I told you that the glass pieces on the bumper don't match that cup?
What's my opinion on it? All I said was glass from a cup. That's the only opinion I had. It's glass from a cup that was on a bumper.
Are you saying a cup?
A cup. A cup. It's not glass from the car. That was my opinion on it. I never said it matched to the scene.
You did.
I never said that in my thing. I said it's glass from a cup.
Okay. It's safe to say you didn't do any testing to determine the forces necessary to shatter a taillight on a 2021 Lexus 570, right?
I did not do testing.
Your report indicates, we talked about this a little bit, I'm going to go back to something we talked about earlier this morning. Your report indicates that John O'Keefe came to his final resting place about 7 feet from the roadway, and that's what you based your diagram on, correct?
Yes.
Who told you that number?
I measured it from a diagram.
You should say that again.
I measured it from the diagram.
Okay, what I'm asking is how did it get on the diagram? In other words, who told you that his body was 7 feet from the roadway?
Well, wait, I was told by Lieutenant Gallagher, Paul Gallagher, CAMPT. He told me this is where the body was found. So I used my devices to mark that location.
Okay, but before you used your devices, he just pointed someplace on the ground and said he was about here, correct?
That's correct.
Did Lieutenant Gallagher tell you that Lieutenant Gallagher never saw John O'Keefe in place at the scene? Did you say that?
No.
Did Lieutenant Gallagher tell you that the first officer on the scene estimated his body being approximately 15 to 20 feet from the roadway?
No.
If he had told you that changed your diagram?
Objection.
He told me this is where he's found. I marked that location. That's all it was.
And you marked basically every other piece of item. Sorry, that's a terrible question. Every other item you marked based on a distance from where you were told John O'Keefe's body came to rest, correct?
Yes.
Yeah, and that was by Lieutenant Gallagher just pointing at the ground, saying it was about here.
Correct.
Was there a single member of the team that was out when you were being shown where the body came to rest? Was there a single member of that team who actually said they saw John O'Keefe's body in place?
Objection.
I'll allow it.
What do you mean team? Canton PD?
Whoever was there. Who was there with you when you started doing your measurements, et cetera?
It's Lieutenant Gallagher. That's who.
Just you and him?
And myself, and I was training a trooper at the time. She was there.
You were training a trooper at the time?
Yes.
Okay, so it was my mistake. I assumed that there were several people out there. Just you and Lieutenant Gallagher.
Yes, that's why I was confused by the team.
All right. And again, Lieutenant Gallagher didn't tell you that he never saw John O'Keefe's body in place.
No, I don't think so.
You did document in your report that the items that you noted on your diagram that we just looked at a few minutes ago, those were found by the CERT team, correct?
Yes.
And you indicated in your report that the members of the CERT team located a single Nike sneaker that was noted on your report. Is that right?
Correct. Yes.
You also indicated that, quote, in the same area, 2 red plastic pieces and 1 clear piece of plastic of a taillight was discovered.
Yes.
So your report is clear that in total, the items discovered by the CERT team on January 29th were a shoe, right?
Yes.
A partial glass cup broken, correct?
Well, was that on there? I can't remember if that's on their diagram or if that's what I was told at the scene. But yes, yes,
You knew that the cup was found.
yes,
You were told the cup was found.
yes,
And 3 pieces of plastic, 2 red, 1 clear.
yes.
Not 5 pieces of plastic, correct?
Correct.
You then measured those items, is that right?
I didn't. What do you mean measure them? Like
Measured
at
them
this?
relative to John O'Keefe's final place of rest. 10 feet from it, 12 feet from it, we're going to go over those numbers.
Yes, I used their report to place those items onto my diagram.
So, and I'm going to get to that question in just a second. I want to make sure that we walk through it sort of methodically. You then use some calculation, some tool or something to measure distances. Like there's where I assume John O'Keefe's body was. There's a final rest place. I'm going to use that as point A, and then I'm going to measure from there and go 7 feet to where the shoe was found, or the first red plastic piece was found, or whatever, right?
Yes,
Who told you where the pieces were found?
they were in Lieutenant Tully's report. He put measurements in his report.
Okay. And you noted that the shoe was 9 feet.
Yes,
Put that in your diagram.
correct,
You noted that the glass cup was 1 foot from John O'Keefe's body, correct?
correct.
1 foot is about that long, right?
Yes, it was. They basically said I was found next to him.
Right.
Yes,
A piece of red plastic 7 feet from John O'Keefe's body, correct?
correct.
A clear plastic piece 10 feet from John O'Keefe's body, right?
Yes,
And a red plastic piece 12 feet from John O'Keefe's body, correct?
correct.
What part of his body were you measuring from?
Like center of mass.
So he's 6'2".
Yes.
Did Lieutenant Gallagher tell you where his center mass was?
No, I measured from. He just said he was here, so I tried to put like where his head, where his feet, and try to measure the middle between those two.
So ultimately, because Lieutenant Gallagher was not at the scene when he was found, Lieutenant Gallagher had to sort of guess where the body was found, correct?
Objection.
Sustained.
You had no photographs of John O'Keefe in place, correct?
Correct,
There were no establishing shots and there were no perspective shots, correct?
correct.
There were no relative shots, meaning this is relative to that. I can measure that and figure out distances, correct?
What, like from the picture?
Yeah, so you know how that's done in science, right? You want to find out a relative position of something, so you take 2 or 3 or 4 shots. You know that something is never going to move, like, I don't know, a flagpole. You can measure from there.
Sure,
You get cross coordinates, right?
sure.
Left and right, where the 2 coordinates match, that's where the item is, right?
Correct.
You know that was done, right?
From the pictures.
None of that was done to do your measurements.
I use, like I said, I use the measurements from, I measured on my diagram in itself, and I measured from those points off my diagram.
Right, but the starting point was a guess, wasn't it?
Objection.
Sustained.
Did you have to sort of guess at where you thought John O'Keefe's body was?
I didn't guess where his body was.
Did you guess at his center of mass?
Objection.
Did you guess?
I did not guess.
Next question.
You stated in your report that you Google mapped Miss Reed's path of travel. Well, let me ask you a different question. If I could withdraw that question with court permission.
Yes.
Your diagram has all those arrows pointing at specific locations, very, very specific, very thin arrows that point, correct?
Yes.
If you start off with an incorrect assumption about where John O'Keefe's body was, right? Hypothetically, if you were to start off with an incorrect assumption where John O'Keefe's body was, every single item that you note on that diagram would then be off as well. Wouldn't it?
Objection.
Is that true?
I mean, I guess hypothetically, depends on how off you want to be.
And the answer is yes, correct?
Hypothetically.
You stated in your report that you Google mapped Miss Reed's path of travel on January 29th based on what you determined to be, quote, it's likely the two, and you said that it's, quote, it's likely that the two events, meaning the triggering events, occurred at the same time the Lexus was at 34 Fairview at the time of the collision, correct?
Yes.
The first triggering event was what? Was it a 3-point turn or I thought I heard you say both.
I guess it would be more, 3-point turns, essentially. I guess it's a 3-point turn.
Okay.
Yes.
What did you say U-turn on Friday? I just want to hear that.
It could have been a U-turn. I mean, it's still turning around. So you got to make a U-turn when that's a 3-point turn or not, but it's still.
Okay, but I mean, not to be picky, but it's my job.
Okay.
A U-turn, traveling in one direction. Turn, right? Turning the wheel, never changing gear. And just reverse anything, just turn, right? A 3-point turn requires moving forward, stopping, changing gears, moving backward, stopping, changing gears, using a steering input, and moving off, correct?
Correct.
Well, those are two very different maneuvers, right? You agree?
It's, in a sense, I was trying to say she made a U-turn. Like you can say they made a U-turn. It's a 3-point turn. They're still making a U-turn. And I didn't mean it as like she literally had to make a direct U-turn. She was turning around. And obviously the diagram, but the trigger shows a 3-point turn.
Well, I mean, I guess you could have said reversing direction, right?
That would be a better way to say it, yes.
You didn't say that. You said U-turn. So are you changing your testimony from Friday that it was a 3-point turn, or could it possibly have been a U-turn?
It's a 3-point turn.
Okay, because you have evidence of the starting, stopping, changing gears, reversing, stopping, changing gears, turning.
That's correct.
So when you said U-turn, that was inaccurate.
Objection.
The objection sustained.
Let's get back to the path of travel when you began your analysis. How did you know what the Lexus's path of travel was that day?
I got the directions from Trooper Proctor.
And what did Trooper Proctor tell you in terms of the path of travel specifically? Starting point and an ending point, tell you the exact path Lexus traveled.
No, all I got was mostly just the addresses.
Okay, so if you've got 2 points on a map, and Trooper Proctor told you Lexus traveled from point A to point B, there are multiple ways to get from point A to point B. You agree with that, right?
Yes.
You pick one of those, right? The path of travel includes freeways, et cetera, right?
Yes.
But as you sit here, you don't know what her actual path of travel was. There could have been something different, right?
It could have been something. That's why I gave a range on my diagram.
Do you have any scientific evidence to establish what her actual path of travel is, or did you just guess at the path of travel?
I got the addresses from Trooper Proctor. I put them into the thing, and one of the possibilities of 36 miles. And that was after looking at all of them. At 36 miles is a possibility.
Right, understood. So that's what I'm trying to get to, Trooper Paul.
Okay.
That's one possibility. There's 36 miles,
Mhm.
one route of travel, right?
Correct.
There are other possibilities, right?
Yes.
So between and among the possibility that you picked and the other possibilities, you just sort of have to guess. And there's no science to it. You said, I'm going to pick that and put it in my report, right?
No, that's not how that works.
Okay, why don't you tell me how that works?
Her odometer mileage on the car from the download and the time we had the vehicle shows 36 miles. So when I plugged those addresses into Google, it came up as 36 miles as a possibility.
And you knew that there was another route of travel to the same location, correct?
What do you mean?
There were alternative routes of travel to the same 2 points, from and to the same points, correct?
Yes. Yes.
You could have tried to extract the location data from the street's cell phone to determine the exact route of travel, correct?
I don't know. I don't have access to do cell phone extractions.
So that answers my next question. You did not even attempt to do that, did you?
No.
You did attempt to analyze the key cycles for the Lexus in order to determine placement of that vehicle. You just talked about that with Mr. Lauer, right?
Yes.
I want to be clear for the jurors because most people have probably never heard of key cycles. A key cycle does not have any location data associated with it whatsoever, does it?
Correct.
It just shows you when a vehicle is turned on, the ignition is on, and off. That's one cycle, correct?
No.
Tell me what I've got wrong.
Key cycle, the car doesn't have to be turned on.
Say that again.
It goes from off to run. The engine doesn't have to be started to off.
Understood. So if it turns on, well, every single ignition is a key cycle. Every time the engine turns on, that's absolutely a key cycle. Once it's turned off again, right?
That gets recorded as an ignition cycle.
Right. So a key cycle can be an ignition cycle, but it doesn't have to be an ignition cycle. It also can be just turning the sort of accessory on, right?
The key cycle is to turn the accessories on.
All right. But it doesn't. My question was, when we started with this conversation, is it does not have any location data on it whatsoever.
Correct.
All right. So when you drive your car, you walk out, get in the car, turn the ignition on, start to drive, get your location, turn it off. That's one key cycle, right?
One ignition cycle.
But and I'm going to use the word key cycles because you use the word key cycles in your report. That's what we're talking about.
I'm using that because that's how the trigger was read.
That's how what?
The triggers were read on the text stream. That's how they read them. Key cycles.
By key cycles.
Yes.
I'm going to use that phrase key cycle.
Okay.
We're talking about the same thing. It's an ignition on, ignition off cycle.
Doesn't have to be on.
So you mean the engine doesn't have to be turned on?
Correct.
Right? But if you're seeing triggering events, not trying to be tricky here, seeing triggering events, the car's in motion, what does that tell you? The ignition's on or off?
The ignition's on.
Right. That's what I'm getting to. But it has no location data associated with whatsoever. It could be here, it could be in Wyoming. The car wouldn't know the difference. It's not to report the difference to you, correct?
On the key cycle,
Right.
on just the key cycle. The key cycle does not give out locations.
Say that again?
The key cycle does not give a location.
Right. So your analysis is trying to go from a known key cycle that you can figure out and then work backward from there to try to figure out where the car was on a particular ignition cycle or key cycle, correct?
I didn't use the key cycle to put it back.
Say that again?
I did not use the key cycle to place the car back in its location. The key cycles were, all I got from the key cycles is that they occurred close within proximity to the time we've had the vehicle, not basically saying that this was the location based off the key cycle.
Well, let's look at Exhibit 591 with the court's permission.
Okay.
Did you testify on Friday that this is a copy of the exhibit that was put in 591 as part of your report, correct?
Yes, it is.
And this is a chart that shows when move to this arrow. That arrow indicates top and bottom where your testing occurred, correct?
Yes.
And you move over to the left. That is key cycle what?
1164.
Right. So you've testified, and you can turn the lights on. You're all right. I don't mind if that stays up. You can turn the lights on. You stated in your report that there are, quote, 2 triggers recorded on odometer 12,629 and key cycle 1162, correct?
Yes.
These events were prior to the testing triggers on odometer readings 12665/12666 and at key cycle 1164. Is that right?
Yes.
Okay. So what you're saying in that report is the triggering events were 1162, going in reverse in order. 1162 comes before 1164. They're numerical. Is that right?
Yes.
Every single key cycle just tags another number on top of it, right? There's no formula.
Correct.
After 1 comes 2, after 2 comes 3, 4, 5, 6, and then move on, right?
Yes.
So by the time you got the vehicle, there had been 1,164 key cycles on the history of that car, correct?
Correct.
And you knew, you put in your report, or you know, that the triggering events that you see under 1164, those are yours,
Yes.
right? I mean, that's your testing.
Yes.
And you were very clear that the triggers that you recorded, that you talked to Mr. Lally about, were two key cycles before that,
Yes.
meaning ignition cycles at least, right?
Yes. There were 2 key cycles.
Stated in your report, well, let me finish one other point. You said that the mileage difference between these 2 triggers and the triggers that occurred while testing was 36 miles. You just said that, right?
Yes.
And the key cycle difference was exactly 2 key cycles, right?
Yes.
1164, 1163, 1162. That's the triggering events, right?
That's correct.
You also reiterated in your report in paragraph 23, 24, 26, and 29, and also in this exhibit in your CARS report, that the triggers occurred at key cycle 1162, right?
Yes.
You were assisted in your CARS report. I think you mentioned Trooper Zach Clark. Is that right?
Yes.
Trooper Proctor assisted to a certain degree, correct?
Yes.
Trooper Carol Lorini, is that right?
Yes.
Also, Sergeant Sean Good at Canton PD assisted as well, correct?
Yes, in a sense.
Did they all read the report before it was finalized?
No.
Did you have any supervisor read the report before it was finalized?
Yes.
And he agreed with the assessments in the report?
Yes.
So in summary, everybody that read the report and you who authored the report believed, and it's reflected in that report, that key cycle 1162 contained the 2 triggers that you're talking about, right?
Yes.
That's the 3-point turn, I guess now a 3-point turn, right? Changing direction, and then the reverse at 24 miles per hour, correct?
Correct.
And you even went on and testified to that exact thing under oath in front of the state grand jury, correct?
Yes. Wait, hold on. On the text streams?
On the key cycles.
Non-grand jury.
Okay. Testified to it on direct examination on Friday and again this morning.
Yes, correct.
If your testing occurred at key cycle 1164, that means you turned the engine on, the ignition on to start your testing, correct?
Correct.
And that triggering event that we see up there at 1164 initiated your testing, all right?
Yes.
So that 1164 is where you That's where there's no more unknowns, in other words. Right? You know exactly where the car is, who's in the car, who turned the car on, and what the triggering events were, and what they reflected, because you did it, correct?
Correct.
It's you.
Yes.
So that would be the cornerstone, basically, of your entire analysis, key cycles.
Say again.
The cornerstone, in
Like-
other words, the one known that is immovable, it's immutable, is 1164 began your testing. Is that right?
Objection.
Is that right? I'm going to allow the question.
Yeah, that's when the car was in state custody.
All right. So starting in 1164 and counting backward, before you started your testing, you know that the SUV had to be started, the ignition had to be turned over, and it was driven to the Sally Port in Canton at 5:31 p.m. from a tow truck on January 29th, correct?
I didn't know that.
You did or did not?
Did not know that.
Okay. Assuming that the car had to be started and put on a tow truck, that would be key cycle what?
I don't know how. I can't speak to the fact that recorded a key cycle at that time.
I can't hear you.
I can't speak to the fact that we record a key cycle at that time.
Okay. If the car was turned on and driven onto a tow truck, would that be a key cycle?
I don't know because these keys record different ways, so I can't speak to how or why it did not record on there. All I can speak to is that those are the key cycles. The odometer mileage is more what I was going after on this whole thing.
Super Paul, you just said unequivocally, when a car is turned on and then turned off, there's a key cycle.
I said when the car without the ignition on, that's a key cycle.
Right.
That's correct.
That's what I mean, when it's turned on, when the engine turns on.
That's the definition of what it is. I can't speak to why I didn't go on, why I did not record.
Well, let's talk about the ignition cycles.
Okay.
Before 1164. Okay.
Okay.
Obviously, the car had to get to Canton PD because you saw it there, correct?
Correct.
Assume for purposes of my question, the car was turned on, and there's a video of it turning on, driving up onto a flatbed tow truck.
Yes.
That would be ignition cycle. I mean, use your word. Key cycle, ignition cycle, 1163, correct?
Again, ignition cycle, key cycles are two different things.
Which one do you want me to use?
If you want to talk about key cycles, key cycles. You want to talk about ignition cycles, it's ignition cycles when the vehicle gets turned on. A key cycle does not mean to be turned on.
But every single ignition cycle includes a key cycle. You can't have an ignition cycle without a key cycle, correct?
Well, if you want to talk about this, use the key cycles or ignition cycles. I'm trying to make sure this gets out. I'm sorry. I'm trying to make sure that this gets put out the correct way.
Every ignition cycle includes a key cycle, correct?
In a sense,
By definition, it has to, right?
it doesn't have to. They record multiple different ways.
You can have an ignition cycle without a key cycle.
I don't know how it recorded, but it could happen.
Explain that. How could that possibly happen?
Because a key cycle is when it turns on, not engine running, and then turns off.
Okay, so work with me here.
Ignition cycle is when it turns on, engine running for 2 seconds, and then comes off.
Okay, so
Or the 2 seconds is not on long enough, it might not record one.
let's ignore the 2 seconds.
Okay.
That's not what we're doing.
Okay.
All right. Let's assume that it's an old-fashioned type of key.
Okay.
Halfway on, the electricity is on. It's like it used to be called ACC.
Yes.
Right?
Yep.
That's a key cycle, correct?
For that intents and purpose, yes. This vehicle's not a key cycle, so they're not a
If you
thing.
keep turning.
Okay.
And that turns the engine on, right?
It turns engine on, correct?
It's an ignition cycle, right?
Yes. Well, then turns off.
So ignition cycle necessarily includes the precursor key cycle, correct? Even though every key cycle might not include an ignition cycle. Would you agree with that?
In that scenario, yes.
Fine. Okay, with that definition, I'm going to talk about ignition cycles because I don't want to get confused about accessories. Just assume the engine.
Okay.
turns on, right?
Okay.
If you started your testing at 1164, then if the engine was turned on, thereby initiating a key cycle, driving the car onto a flatbed truck, and then hauling it over to Canton PD, that would be key cycle 1163. Not hypothetical, correct?
It could be.
Okay. Then going backward from there, if the SUV was, I'm sorry, let me add one event that I just forgot. It had to get off the tow truck in Canton and be driven into the South. Did you ever see that video?
No.
Being driven in?
No.
If there was a video showing that the car was actually driven into the Sally Port, that would necessarily be a key cycle, correct?
Possibly.
Okay, so that would be key cycle 1163. My mistake, I was missing one, right?
Okay.
Before that, if the car was turned on and driven onto a flatbed to get to Canton, that would be key cycle 1162 in order, correct? We're going back,
It's possible.
all right? Before that, if the car was started and the car was driven from One Meadows Avenue to Karen Reed's parents' home in Dighton, that would be another key cycle, 1161, correct?
They're possible.
Before that, if the SUV was started and driven by Miss Reed from the garage at John O'Keefe's house to Jennifer McCabe's house at 5:07 in the morning, that would be another key cycle, correct? 1160. Is that right?
It's possible.
And before that, if the SUV was started and driven by Miss Reed to the waterfall, from the waterfall to 34 Fairview at approximately 12:15 a.m., that would be another key cycle, 1159, right?
It's possible.
I want to be clear. The reason that these numbers skip in your diagram, they don't go directly in order, right? Not every single number is in order on this left-hand column, because this is only a diagram of when triggering events occur, right?
Yes.
Something unusual about the operation of the vehicle, correct?
Yes.
And it's clear that from the data, there was no triggering event at key cycle 1159, was there?
No.
So assuming the driving events that I just told you, right? Assuming for purposes of my question, that the driving events started at 11:59, driving over to 34 Fairview from the waterfall. Then driving at 5:07 in the morning over to Jen and Cave's house, 11:60. Then driving to Dighton, her parents' house, 11:61. Then the car being seized in Dighton by Trooper Proctor, 11:62. Then the car being taken off the flatbed and driven into Sallyport at Canton, 11:63. Your testing starts at 11:64. That would mean that at 11:62, that key cycle would include the time in which Trooper Proctor had possession of that car, correct?
No.
Assuming my hypothetical.
You're hypothetical?
Yes.
If that's hypothetically how it works, then yes.
Then what?
If that's hypothetically how it works, then yes.
On June 9, 2022, you were asked by a grand jury whether you knew or had done any scientific testing to determine the distance a body would actually travel struck by a vehicle. Remember that?
Not that specifically. Not in that way.
Do you remember answering that you had not, based, I'm just paraphrasing, that you had not done you hadn't finished your report yet?
Why don't you show him? He said he didn't remember it that way.
Take a look at middle of the page. Your answer starts at about line 12, but the question above it is probably informative. You were asked, does that remind you that you were asked by a grand jury if you could calculate how far a body would move having been struck by a vehicle?
Yes.
And you indicated, quote, yeah, there's certain calculations we can do with that. We'll figure out if you say if the car backed up, hit somebody, and then they go a certain amount of distance, and it's based on miles per hour, the speed of the vehicle, the striking vehicle, and stuff. Remember saying that?
Yes.
What did you mean by stuff?
I don't know.
You said that the calculations would be based on miles per hour and stuff. Did you ever do any stuff to test that? That's the grand jury's question.
No, we cannot calculate anything from this collision.
Say that one more time.
We cannot calculate anything from this collision.
Who's we?
I mean, sorry, me, the role me.
Well, you know Don O'Keefe's weight, right?
What's that?
You know Don O'Keefe's weight, 217 pounds, right?
Yes.
Did you know that?
I don't know his weight, no.
You know the weight of the vehicle?
Yes.
What's the weight of the vehicle, gross weight?
What's the gross weight?
Yeah.
I think it's approximately 7,300 pounds.
Were you able to calculate the mass of the vehicle?
I did not calculate the mass of the vehicle.
Well, you told the grand jury that you were planning on doing that kind of stuff to calculate how far a person would travel being struck at that speed with a car of that weight. You didn't do those calculations?
No, because the calculations would vastly underestimate the speed of the vehicle.
You testified, again, my report isn't done yet. I'm going to look into it. I'm looking into all that stuff, end quote, correct?
Yes.
There's that word again. It's been more than 2 years since that statement at the grand jury. Is your report finished?
Yes, it is.
Did you engage in any of those calculations?
I looked into it. This type of collision I would not be able to use the formulas for this type of collision.
Let's talk about those formulas. How would you calculate how far a body at rest would travel after being struck by an object in motion? How would you calculate that?
In pedestrian collisions, I use the Searle formula, Searle throw formula.
What formula?
Searle.
What does that mean?
It's a type of formula that we use for a calculation of post-impact
So
or speeds of pedestrians.
that includes certain principles of physics to calculate that, right?
What do you mean?
I'm sorry?
What do you mean by certain forms of physics?
There would be physics calculations that would be required to figure out how far a body at rest would move having been struck by an object in motion.
Right.
That's a basic principle.
Yeah, I guess you could say though.
All right. Can you describe for the jurors exactly what calculations you would need to employ to determine how far a body at rest would travel having been struck by an object in motion?
So in this scenario, in this collision, it's more of a side swipe. So he did not sustain, he did not get enough speed of the vehicle post impact with the vehicle to be able calculations. His center of mass was offset from the vehicle. So we would vastly underestimate his speed. So that's why I did not do a formula. If he was more in line with behind the vehicle, he would have been projected forward, and using that projection forward, when he would have been able to get more closer to the actual speed of the vehicle during that post impact travels.
Well, that presumes a couple of things, Paul. That presumes that he was quote unquote sideswiped, right?
Presumed?
Presumed by you. You didn't see how he was hit, did you?
Based on the evidence, it appeared to be a side swipe.
That's your opinion.
That's just reading the evidence.
You're saying that the principles of physics as we know them today in modern mathematics is thwarted by a sideswipe?
Objection.
Is that what you're saying?
The calculations that are out there, you can get a speed, it'll just underestimate the speed.
You would have to know what the initial momentum of the object is that's in motion, correct?
Of what object?
The truck, Paul.
I would have to know that speed.
Yeah, you'd have to know what the initial momentum is, not speed, momentum. There's a difference.
Okay.
Right? Do you agree with that?
No.
you wouldn't have to calculate what the initial momentum is of the object in motion to determine the distance of the body at rest would move?
Well, in that sense, that's what we're talking about. I'm trying to find the speed of the vehicle. That's usually what we're trying to do.
Right, okay, well, let's put the speed of the vehicle aside. Let's talk about initial momentum. What's the formula for calculating initial momentum?
There's different types of momentum formulas.
Well, there's actually one type of momentum formula. It's to calculate momentum.
Objection.
Sustained.
To calculate momentum, there's a singular,
So sustained. Ask it differently.
isn't it true, Paul, that there is a singular calculation for determining initial momentum? That is P equals M times V, where P is the momentum. You're solving for that. M is mass. You multiply that by velocity. Is that right? Pretty simple.
You wouldn't use that in a pedestrian collision.
Oh, because the pedestrian's somehow magically out of the realm of physics?
Objection.
Sustained.
Is a pedestrian out of the realm of physics and calculations?
No, it's the weight differential between the pedestrian and the vehicle.
So if the vehicle is too heavy and the body is too light, you can't calculate the initial momentum of the vehicle?
Yes,
Got it. Where'd you learn that?
it's in my math class. Since we don't use momentum for vehicle to vehicle.
Math class?
The crash reconstruction classes I have taken.
Got it. Would you need to apply the theory of conservation of momentum in calculating these data?
Do I need to calculate the conservation of momentum?
Or calculation, the conservation of momentum?
Yes,
You know what that is? There's an equation for that as well, right?
yes.
You know what that is?
Not off the top of my head, but yes.
Based on the basic principles of physics, is the total momentum of the collision greater or less than the total momentum after the collision? Total momentum before the collision, is it greater or less than the total momentum after the collision? Basic question.
What type of collision?
Paul, they're exactly equal in all respects under the principles of physics, right? That's the theory of the conservation of momentum. Momentum doesn't change. It's
Yes.
transferred from one body to another,
Yes,
correct?
correct.
Why didn't you say that to the jurors?
Objection.
Sustained.
Paul, if you were qualified to, quote, look into all this stuff, you would probably know these answers, wouldn't you?
Objection.
Sustained.
Are there any other calculations that you need to figure out the stuff that you were talking to about with the grand jury?
Objection.
Sustained.
How about calculating the final velocity of the objects after the collision? Would that be important?
What objects?
That would be John O'Keefe's body, sir.
I don't,
Object you claim was flying through the air 30 feet.
Okay,
Objection.
sustained.
How about calculating the displacement using kinematic equations? Would you be able to do that?
the displacement of the body.
In order to calculate how far the body would move based on the mass of the object striking the body, could you use displacement using kinematic equations?
So like I said before, the side swipe, he would not have gotten 100% of the vehicle, 100% of the speed of the striking vehicle. It would have vastly underestimated this vehicle. You can hit a person and side swipe them, spin them off to the side, and have that and get SP from those calculations.
So you're saying that the discipline of physics cannot figure out how far John O'Keefe's body would move, but you personally figured out that he would have flown now somewhat, or been projected somewhat 30 feet.
Objection.
Sustained.
Are you saying that the principles of physics are incapable of determining with the proper calculations how far John O'Keefe's body would have moved given the collision at issue?
Objection.
Is that what you're saying, Trooper?
No.
Okay, next question.
Well, you just said because it was a side swipe, all these calculations, these physics calculations are inapplicable, right?
I'm saying it would underestimate the speed and the distance.
The truth is, Trooper Paul, you have no idea what all these physics calculations mean, do you?
Objection.
Sustained.
You've not been trained in physics formally, have you?
Yes,
You have been,
it's incorporated into the classes.
right? You have a few classes that use the word physics, but you haven't been formally trained in physics.
Objection.
Sustained.
You haven't been formally trained in kinematics, correct?
It's in the aspects of all our crash reconstruction classes.
You haven't been formally trained and hold no degrees in biomechanics, do you?
I do not have a degree in biomechanics.
In fact, basically what you did in this case was calculated emission cycles. And you got those wrong, right?
Objection.
Sustained. Come on, Mr. Jackson. Ask the appropriate part of the question and you'll get it.
Let me ask you this. Based on your reconstruction, nearly 2-year investigation, exactly how was that taillight shattered? Explain it to us.
How does it tell it? What do you? It gets so the taillight in this case was shattered when it was struck John O'Keefe's arm.
Exactly what part of his arm?
Based on what I saw for his injuries, was from the upper part of his arm down.
Was his arm out? And just struck the arm on a hinge? Was it in front of him? You did the reconstruction?
It looked-
Here's exactly how his body was positioned when he was struck by that.
So it looks like his arm was more kind of like this. If I can try to get that.
You're indicating out by his side, correct?
Yes.
All right. And the taillight would have struck his arm, right?
Yes.
Not his torso.
Yes.
Okay. So the full mass, the full weight of that truck hit him basically at the elbow. Is that right?
No,
Missing his
no.
torso.
But I said it from upper part of the arm
Right,
down.
that
Yeah.
elbow and the biceps.
I didn't see anything that shows an indication that this lower torso was struck, but
Okay. So his torso,
it's not saying it could not have been a possibility, but I just didn't see anything.
so his torso was spared from being hit, but the arm took the brunt, the full force of the vehicle, correct?
Like arm and shoulder. Yes.
And you said he then did a spin, like a sort of pirouette,
he got spun around possibly the way he struck, it looked like he could have turned around counterclockwise.
Okay. So if it turns around counterclockwise, is he turning around in the air counterclockwise?
Yes, initially.
So it gets hit on the upper biceps, shoulder area, and down to the forearm, right?
Yes.
By an unbroken taillight, right?
Yes.
In other words, it's nice and smooth. Nothing, no shards of plastic or anything broken at the time that made contact with his arm, right?
Correct.
Okay. So how does his arm get up?
Because when his arm struck the taillight then cracked, and as the car driving past him, the taillight could scratch it.
Got it. So he gets hit by the car, not his torso, just the arm. The taillight cracks, and as it passes by, his arm stays with it long enough to get striations, those scratches that you see, those lacerations. I'm sorry, those abrasions that you see, right?
In a sense, yes.
And at the same time, he does a pirouette and flies 30 feet to his final point of rest.
I don't know if he did a pirouette.
Well, I'm using the word pirouette. He spun around.
He started rotating counterclockwise. I don't know how far he ran counterclockwise, but he started rotating. According to that, would push him to rotate counterclockwise. Whether he went counterclockwise all the way to his back toward the ground, it seems like a most likely possibility.
Did you account for the fact that his arm is on a hinge?
Is what? Say again?
Did you account for the fact in this scenario that you just told the jurors that his arm is on a hinge?
On a
His
hinge.
shoulder?
Okay.
Okay. So, the arm got hit. Did his arm just swing?
I said arm and shoulder area, so his arm could have been considered part of it.
Even if his shoulder got, the upper,
Okay.
pointing to his upper biceps.
Mhm.
Right? There's no injuries on his shoulder. Not a single one. Not even a bruise. Right?
Like I said, it looked like to me it was from up here. I don't know how far I can up back here, but it was up here.
Well,
So
you're the one that talked about his injuries on his arm.
yes.
That's limited to about mid biceps, to about mid forearm, correct?
Okay.
Right?
Yes.
No injuries on the shoulder, no injuries on the torso, no injuries on the ribs, no injuries on the back, correct? Is that right?
Yes.
So your theory is you got hit on the arm, took the brunt of the force from the taillight on the arm, stayed with the vehicle long enough for the taillight to explode, basically to shatter. Then these striations get on his arm, abrasions. Does a pirouette, spin, counterclockwise, he flies 30 feet in the air to his point of rest.
Yeah, I have to probably go faster than that though.
That's you said he hit his head on the curb.
I said that's one of the possibilities of when you look at the roadway as he gets spun around kind of clockwise. It's a possibility that the curb is there. Any blunt force object on the ground the ground is pretty blunt.
Well, except in your scenario that you just told us, he flew through the air onto the light dusting of snow, grass, and dirt.
I didn't say through the air.
Say that again.
I didn't say he got thrown through the air.
Okay, I'll use your word. You got projected.
Projected doesn't mean it's not incorporating just throw. Project just means you get pushed forward. There's two parts of that. There's the air, then there's the ground. Like I said earlier, the tumbling, the rolling, whatever that part of the crash would happen. Projecting is just what we call what happens to a pedestrian post impact with a crash.
Okay, so a couple questions. If his arm, elbow, took the brunt of that entire impact, how do you account for the fact that he didn't suffer a broken bone?
I don't know.
How do you account for the fact that he didn't have a fracture?
Objection.
Sustained.
How do you account for the fact that he didn't have a bruise on the arm?
That's sustained too.
Your approach.
Yes.
May I inquire you?
Yes.
The truth is, Paul, you know, having investigated auto pedestrian accidents in the past, that John O'Keefe's injuries do not look anything like an automobile pedestrian accident, do they?
Yes, I do.
Isn't it true, Trooper Paul? You came to these opinions and conclusions because Trooper Proctor told you to come to these opinions and conclusions in furtherance of his investigation.
That's not true.
That's why you have these opinions and conclusions that just don't make sense, correct?
That is not true.
And you're just trying to fit a square peg into a round hole.
Objection.
Sustained. All right, jurors will take morning recess.
All rise for the court, please.
And I'll see counsel at sidebar about scheduling. All right, Mr. Lally, whenever you're ready.
Thank you. Now, with regard to your testimony as far as that triggering event, or the two events on 12,629B, you testified that that was consistent with a pedestrian collision. Is that correct?
That's correct.
Again, if you could tell the jury, why is that consistent with pedestrian?
The one specifically with the speeds and everything that we're referring to.
22 miles per hour in reverse, about
Right.
62 feet.
Okay, yeah. So why I think that's consistent with a pedestrian strike is because the sudden change in the speed, it drops down by 0.5 mile per hour. The accelerator pedal is staying constant at the same percentage, and the steering wheel angle also turns to the right.
Now, your overall opinion is based on what you did as far as your construction, correct?
Yes,
Other information that you had at your disposal in formulating your,
like from other reports and stuff.
yes,
Yes,
and that would include physical evidence, is that correct?
correct.
And that would include witness statements, correct?
Sustained as to form.
What, if anything, else would that include?
The roadway evidence, witness statements.
In witness statements, would that also include statements of the defendant?
Correct.
Are you aware that the defendant indicated in a statement to troopers that she conducted a three-point turn in the area of 34 Fairview Road?
I'm going to allow that question.
Yes.
And what you observed in that triggering event is that from that mileage, is that consistent with the defendant's own statement?
Yes, it is.
Now, let me ask you a little bit, if you could, again, for the jury, clarify the difference between what you termed as an area of impact versus a point of impact.
Yes, an area impact is broader. It's a bigger area. Point of impact would mean something as obviously right there. That would be the area impact.
If I could ask, the cell phone that was located under Mr. O'Keefe's body, that location, is that also consistent with the linear path that you were testifying about earlier?
Yes, it was.
And do you know whether or not that cell phone was in his hand or in his back pocket or somewhere else?
I do not know.
As far as let me ask you this. You were shown some photographs of some tail light pieces near a fire, correct?
Yes.
As far as the area of impact, that was, from what you determined, that was Mr. O'Keefe's sneaker, is that correct?
Yeah, it was within that. When I would have had for no initial evidence, I said the area impact was a star in that area prior to the
I'm
sneaker.
sorry,
Sorry, so what I was saying was the area impact was prior to the area the sneaker was. It was in that path, just prior to that area.
And why did you determine that it was in that area?
Because that was the first point of evidence.
And first, I'm sorry, just first point of evidence in relation to what and sort of how the evidence was configured as it was evident to you.
That was pointed to me. It was the first point of evidence away from, for the first evidence at that time that knew away from the pedestrian.
May I approach the witness, Your Honor?
Yes.
Sir, I'm showing you what's been marked as Exhibit 58. Do you recognize what's depicted in that photograph?
Yes.
And Your Honor, with court's permission, if I publish that to the jury.
Okay, what exhibit number is it?
58.
Thank you.
And to recall, do you recognize what's up on the screen?
Yes, I do.
What do you recognize that?
There's 34 Fairview at the left side, and this is the fire hydrant.
And as far as these photographs and the photographs shown to you by Mr. Jackson on cross-examination, do you know when those photographs were taken?
I do not know specifically at what time those were taken.
You don't know if those photographs were taken on February 3rd, 2022?
Objection.
Is the objection sustained?
Now, Trooper, if you could, using a laser pointer, I know you've done this on the diagram, but if you could use a laser pointer with regard to what's on the screen as Exhibit 58, direct the jury's attention to where you believe the area of impact to be between the defendants, Alexis and Mr. O'Keefe.
It's probably somewhere out here.
And as far as that linear path that you were talking about from the area of impact, where did that go from and where did that go to?
So from, I think it's from like this way.
Let's go, you can take that. May I approach this for Trina? Now, Trooper, if you could explain to the jury as far as what you were describing as Mr. O'Keefe's post-impact movement, starting sort of with the point of impact between himself and the SUV to the point where he comes to final rest on the wall.
Yes. So he was struck along the right side in the area of his arm, and then he was post-impact with the Lexus. He rotated counterclockwise and eventually hit the ground and came to final rest.
And the ground, based on your understanding of the weather conditions, was frozen at the time. Is that correct?
Objection.
Sustained. Watch the form, Mr. Wiley.
Yes. So as far as anything in your testimony about Mr. O'Keefe's actions, does that involve pirouette?
No.
So there's a rotation, is that correct?
Correct.
And as far as 30 feet in the air, do you have any opinion as to whether or not he flew 30 feet in the air?
I don't have any evidence that he would have flown 30 feet in the air.
And so as far as from your training experience when it comes to pedestrian collisions, are you able to determine or calculate how much distance someone is in the air and how much distance someone sort of rolls or tumbles to their final resting position?
Say it again.
From your training experience,
Yes.
based on this collision, are you able to determine how far Mr. O'Keefe was traveling in the air versus how far he traveled tumbling or rolling after he hit the ground?
I do not have a calculation for this specific style of pedestrian crash due to the side swipe. So if I did, I could use the formula. It would just vastly underestimate the speed of the vehicle.
Let me ask you a little bit about it. You're talking about the Searle pedestrian throw formula, correct?
Correct.
And that's something developed in the course of physics specific to Reconstruction by someone named Dr. Searle, correct?
Correct.
And that's S-E-A-R-L-E, is that correct?
That is correct.
And with respect to Dr. Searle's formula, why is that inapplicable in side swipe collision versus some other type of collision?
Because it takes in, it's looking for more. It's not so much the formula; it's how much projection efficiency that would occur. How much percentage of the speed of the striking vehicle would have happened. In order for the formula to work, the more of the body would have struck the vehicle, the more efficient the outcome would be in the speed.
In the center of mass that you were talking about, sort of in the collision sequence, what, if any, role does that play in regard to your ability to do that calculation?
It would just, like I said, it would underestimate the speed of the striking vehicle due to a center mass not within the rear of the vehicle.
And not to twist your words or anything, but as far as when you say underestimate, that would not be an accurate reflection of the defendant's vehicle speed, correct?
Correct.
Now, you asked some questions about the glass and indicated that there are a number of reasons why the glass would travel with him, being Mr. O'Keefe. Can you explain what those are?
Yeah, the glass could have struck the vehicle also in the same way. It could have still been attached to his hand and still gone with him in the same way. It could have been attached to his body in midair. That's the multiple ways that the glass would have stayed with him.
Now, and speaking of collision sequences, particularly collisions involving multiple vehicles, vehicles are affixed with bumpers, correct?
Correct.
What's the purpose of a bumper on a vehicle?
To help absorb the.
Scope?
Yes. Yeah.
Sustained.
Your Honor, if I may, I don't believe it is.
So why don't we come to side?
Oh, I'm sorry, again, Trooper. If I could ask you, what is the purpose of a bumper on a vehicle?
It's there to help absorb energy from a collision.
And with reference to the scratches that you were asked about on the vehicle on sort of the right rear quarter panel, what, if any, relationship does bumpers or their interaction have, to your opinion, as it relates to that?
Sorry, say it again.
Back to what you just testified about bumpers, you were also asking questions about scratches on the right rear quarter panel of the vehicle, correct?
Correct.
And what, if any, relationship does the bumpers on the vehicle and sort of their intended purpose have with relation to the scratches that you observed?
So the bumpers on the side was more of this wasn't more of a direct on hit with the bumper. It was more of the side scraping of the paint of the bumper.
Now, the presence of Mr. O'Keefe's DNA on the taillight, is that consistent with a pedestrian collision?
Yes.
Now, as far as the glass not matching, are you aware that the lab's actual findings were that the glass on the bumper and the glass on the roadway was not found to be consistent with each other? Is that your understanding? If you know.
I don't know.
And were you also aware that the lab's finding was that the glass on the bumper was consistent with the glass on the road?
I'm not sure what the lab said.
Now, in order to construct your diagrams, your testimony, I believe, was that you had used cert diagrams in the process of that. Is that correct?
Yes.
And if I could turn back to that 12629B, the mileage from the TechStream data.
Yes.
The 3-point turn that you observed and the 24.2 mile per hour straight line for approximately 62 feet, how far apart time-wise within that particular triggering event were those two incidents?
8 minutes.
And as far as any of the other TechStream data that you observed, was there any other triggering event that included a 3-point turn?
No.
Now, as far as the defendant's path of travel, is it your understanding that that was obtained from a multitude of different witnesses?
Yes.
Now, with reference to, you were asking questions about the defendant's cell phone, as far as GPS locations, were you aware that the defendant's cell phone wasn't able to be accessed until by law enforcement until 2023?
Sustained.
Were you aware that the defendant's cell phone had GPS locations turned off on the defendant's cell phone?
Objection.
I'll allow that.
I was not aware.
Now, as far as placing the vehicle during that triggering event, 12629B, did you use key cycles to put it back at that location at that time?
No, I didn't.
What did you use?
I looked at the odometer mileage
And why would you look at the odometer mileage over the key cycles?
because I can physically see the odometer mileage at the vehicle at the time of my inspection.
And why would, well, let me ask you this, in your opinion, as far as that is concerned, sort of backtracking to a specific location, which is more reliable, the odometer or the key cycles?
I would say the odometer mileage.
And why is that?
Like I said, you physically see it when you're in the car, and I know that's the odometer mileage that it's reading on the dashboard.
And every key cycle, is that necessarily reported within the TechStream data?
No,
And why not so?
it only records stuff that related to the triggers.
They don't what?
They only record stuff that is related to the triggers.
Okay, thank you.
As far as counsel's hypothetical with regard to the key cycles, is it your opinion that that hypothetical is accurate or inaccurate?
Inaccurate,
And why so?
because you also add the odometer mileage onto the key cycle. So those key cycles and odometer mileage are on the same trigger, and plus the data seems consistent with everything else that's going on with this collision.
Now, fair to say that you were not outside of 34 Fairview Road on January 29th, sometime around 12:20 to 12:30 a.m. Is that correct?
That's correct.
And so fair to say that you don't know exactly how Mr. O'Keefe and/or Glass or anything that he's holding interacted with the defendant's vehicle at that time?
Objection.
I'll allow it. Is that true?
I do not.
And so based on your training and experience and the number of pedestrian crashes that you've investigated, again, if you could, one last time, just describe to the jury how you believe the vehicle interacted with Mr. O'Keefe and why.
Objection.
Sustained. Asked and answered.
With reference to what you've described as far as the interaction between Mr. O'Keefe and the vehicle, why is that your opinion?
Objection.
I'll allow that.
Based on the evidence from the vehicle, based on the injuries to John O'Keefe, the tail light appears to be broken and it's sharp plastic pieces that could have ripped his arm, and also the dent with the scratches above it is consistent with a hand holding a glass and the glass on top smashing on the vehicle and the hand smashing the vehicle. You can see there's a line between scratches and a dent there.
Very briefly, I just want to make sure I clear something up about key cycles. You're not suggesting that every key cycle in the history of cars on this page, correct?
That's correct.
I'm pulling up Exhibit 591.
Okay.
That indicates key cycles that have triggering events, correct?
Yes.
Triggering events are something that the manufacturer includes. It's basically a list of items that will be a triggering event, correct?
Yes.
It's a list of items basically for mechanics to figure out if there's some unusual driving or unusual event with the vehicle, correct?
Yes.
But the key cycles go in order. They're numerical, 1 through whatever.
Correct.
And the hypothetical that I gave you on cross-examination, with those driving incidents, each one of those would represent a key cycle, correct?
So in your hypothetical, I mean, assume that it should create a key cycle, but that you can't just say that key cycle is from that because I didn't just use key cycles. I used the odometer mileage on top of it. So you have to have key cycle and odometer.
But interestingly, though, when you testified on direct examination, you said your analysis, this was on Friday, or the weekend. By the way, over the weekend, did you watch anything on, I don't know, YouTube or any social media?
No,
Nothing.
no,
No. Did you have any conversations with Mr. Lally about these key cycles and problems?
no,
Did you have any conversations with anybody about the issues with the key cycles?
no.
Did you realize at some point between Friday and today that I was probably going to ask you some questions about key cycles?
Objection.
Did you realize that yourself?
I assumed you were asking me loads of information.
So on Friday, you didn't mention that your analysis was based on mileage, did you?
Objection.
Sustained.
On Friday, did you mention that your analysis was predicated on mileage?
Objection.
I'll see you at sidebar.
May I inquire?
Yes.
Paul, on Friday, you indicated pretty clearly that your analysis was based on the key cycles, starting at 1164 when you started your testing, and 1162, which was the key cycle you claimed on Friday was at 34 Fairview.
It wasn't based on it. That's how I describe it. I said key cycles. I based it on they were close within proximity to each other, but I've always said it's key cycles and odometer mileage plus all the information within the triggers themselves. So it wasn't just one or the other.
And you said on Friday that once you started your testing at 1164, it was 2 cycles earlier that had the triggering events, meaning 1162, that you claimed were at 34 Fairview.
Yes.
But in the hypothetical, if there were 4 events, 4 driving, 4 key cycle events between 1164 and 1159, it could not have occurred at 1162, correct? 34 Fairview. In my hypothetical.
In your hypothetical, if it recorded a key cycle, then your hypothetical is correct.
Right. And last question, if you got the route of travel incorrect, if your presumption of the route of travel was incorrect on that vehicle in the days earlier, then your mileage would be incorrect also, correct?
Mileage from what, the odometer or from
The odometer reading.
the odometer reading is odometer reading? It's 36.
My point is your analysis that's based on the odometer reading, 36 miles here, 12 miles there, 2 miles here, 5 miles there. If you got the route of travel wrong and the route of travel was different, your assumptions about the odometer readings would be incorrect as well, correct?
So what I'm
You got the path of travel wrong.
I purposely put down a range on my Google images showing, because I couldn't tell you her definitively route of path for every single way, but I know that it's possibly a possibility that she could travel 36 miles within those locations that she traveled post leaving Fairview Road.
Or if that mileage was put on at key cycle 1162, then that would mean that the vehicle would already be in Massachusetts State Police custody, right? These are the proctor's custody.
Objection.
So that's beyond the scope.
That's all.
All right, Mr. Lally?
Just very briefly. The range that you came up with for the defendant's path of travel, does that fit with the path of travel, the odometer reading, putting the defendant's vehicle in the area of 34 Fairview Road when it does a 3-point turn, and then 8 minutes later when it travels 24.2 miles per hour in a straight line in reverse for approximately 62 feet?
Yes.
Nothing further.
All right, you are all set.
Thank you, Your Honor.
Step right in. Step for me. You say the face.
You tell us what the evidence of the court and jury in the case now hears the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, Mr. Jackson, whenever you're ready.
Thank you, Your Honor. Doctor, could you state your full name and spell your last name for us, please?
Daniel Michael Wolfe, last name spelled Wolfe.
Dr. Wolfe, what do you do for a living?
I am the director of accident reconstruction at a company known as ARCCA, ARCCA.
And what is ARCCA exactly?
So ARCCA is a forensic engineering consulting firm. We have a variety of disciplines that include human factors, biomechanics, crashworthiness, accident reconstruction, just to name a few.
Based on your title, it sounds like you're the director of the entire accident reconstruction format for ARCCA, correct?
That is correct.
What sort of contracts does ARCCA routinely engage in?
So we do a lot of work in civil litigation. So we work with insurance carriers, law firms, but we also consult with and do projects with the federal government as well as the National Hockey League on player safety. So we're involved in a number of research projects as well.
Is there other clientele that seeks out ARCCA for accident reconstruction or biomechanics or human factors issues?
In terms of beyond the parties that I just listed?
Commission, the U.S. Department of Defense.
Yes, the military, yes, the Army.
Tell me a little bit about the work that you've done for the Department of Defense.
Well, that was before my time, but I'm aware of projects that dealt with working on vehicles that were over in the Middle East, where they basically designed energy-absorbing seats because there was injuries when the vehicles were going over IEDs.
Is ARCCA known both nationally and internationally? Is it recognized as a leader in accident reconstruction issues?
Yes.
As the director of accident reconstruction at ARCCA, do you specialize in both accident reconstruction and the human factors that are associated with such reconstruction where necessary?
Yes.
Can you give me a synopsis of the professional discipline of what is accident reconstruction?
I think a simple definition in my mind would be the application of physics, engineering, science, and mathematics to collision events. I always like to think of it as if you open up a puzzle box and you dump the pieces out, and you've got a bunch of pieces, and you're trying to piece together the evidence to see how everything fits to get a clear picture.
And what is the application of human factors to that process?
So to give you an example of human factors in the field of accident reconstruction, so I do a lot of nighttime visibility and conspicuity work. So to give you an example of that, let's say a driver's driving down the road at night. There's a pedestrian that's crossing the road. So we want to have an understanding based upon that pedestrian's clothing, the headlights of the vehicle, any potential artificial lighting in the area. When does a driver recognize that individual on the roadway? And then we can also look at literature to have an understanding of how do drivers respond based upon the hazard they're presented with. So there's different response times depending on the hazard. So it's going to be different for a pedestrian crossing the roadway or a driver responding to a vehicle suddenly stopping in front of them.
Dr. Wolfe, as an accident reconstructionist, do you investigate and reconstruct both passenger vehicle issues, commercial vehicle issues, motor vehicle, pedestrian issues, all of the above?
Yes, I see all types of accidents.
And how long have you been doing this work with ARCCA?
A little over 7 years now.
What education, training, background qualifies you to perform the duties that you just described for the jury?
Back in 2012, I received a Bachelor of Science in Engineering from James Madison University, along with a minor in mathematics. Some of my courses while at JMU included courses in physics, statics, dynamics, kinematics, material science, along with your other engineering sciences. Subsequent to my undergraduate degree, I then went on to the University of Delaware to pursue my PhD in electrical and computer engineering with a concentration in electromagnetics and photonics.
What additional training or experience do you have as it relates to accident reconstruction in addition to the formal education and the PhD?
Certainly. So in addition to my undergraduate degree and my PhD, I've continued to take courses through Northwestern University in crash reconstruction. Some of those courses have included human factors, lighting. I've taken courses on electronic vehicle data, photogrammetry, three-dimensional laser scanning. So I've continued to take courses subsequent to graduating.
Do you also hold any accreditations in terms of accident reconstruction?
Yes, I'm accredited by an organization known as ACTAR, which is the Accreditation Commission for Traffic Accident Reconstruction.
Are you trained in photogrammetry?
Yes, sir.
Is that to determine vehicle crash incidents or the circumstances surrounding them based on map scenes, evidence from photographs, things of that nature?
Absolutely. So photogrammetry is the science of extracting information, if you will, out of photographs. So things dimensionally about an object spatially without ever actually physically seeing the object or inspecting it.
So you don't have to be at the scene to effectively and scientifically reconstruct it to your satisfaction?
No, not at all. And quite frankly, to be honest with you, in my world in civil litigation, oftentimes by the time a case comes across my desk, it's, the accident happened 5 years ago. Some I've even had 10 or 15 years ago. So getting access to the vehicle at that point, it's going to be a long shot.
Doctor, are you a member of any professional societies?
Yes.
Describe those, please.
So I'm a member of the Society of Automotive Engineers, SAE. I'm also a member of the National Association for Professional Accident Reconstructionists, the Optical Society of America, and also the Illuminating Engineering Society.
How many cases would you say in your experience in your career have you reconstructed or attempted to reconstruct, you or your team members?
I don't actively track that. If I had to estimate at this point in my career, it'd probably be well over 1,000.
And how many of those 1,000, I know you don't have a number specific, but how many of those 1,000 would you say involve pedestrians as well?
Several hundred. As I mentioned earlier, a great, excuse me, a great deal of my work is in the field of lighting and visibility. So there's a direct correlation between time of day and pedestrian incidents. We see a rise in the evening and night hours just due to drivers having difficult ability to try to perceive and recognize individuals. So I certainly see a lot of pedestrian collisions in my casework.
You've done testing or research as it relates to the kinematics and the interaction between pedestrians and vehicles.
Absolutely. So we do a number of tests at ARCCA to look at the interaction between pedestrians and vehicles. One of the ones I know I did most recently where we were evaluating a vehicle essentially rolling over a pedestrian. So we wanted to understand the vehicle dynamics as well as the interaction between the pedestrian and the road surface. So we conducted testing at ARCCA to evaluate that.
Does ARCCA have any other disciplines other than just accident reconstruction?
Absolutely. So as I mentioned earlier, we have crash worthiness. So again, that's where you're going to be looking at the safety of a vehicle. How does it perform in a crash? We have human factors, failure analysis, premise liability, and biomechanics.
As an accident reconstructionist, doctor, do you or have you studied or tested the forces that are at play between objects interacting, a human being interacting with a vehicle, for instance?
Yeah,
That's part
absolutely.
of what you do.
Yes, sir.
Describe that.
So we use hybrid instrumented dummies at ARCCA for our testing. So if we want to have an understanding that an occupant in a vehicle, the forces that they might experience, or for any metaphor, again, if it's an instance where you have something that ends up falling on someone's head and you want to have an understanding of the forces involved in that, we perform testing with hybrid dummies.
Have you ever authored any peer-reviewed papers in the field of physics?
Yes, sir.
Describe those for me.
So I have a number of papers in the field of lighting and optics. I have a recent publication that deals with Toyota and Lexus vehicle control history records as well.
Is that called Toyota Vehicle Control History, 7 Braking History Recording Characteristics?
Yes, sir.
All right. Was that specific to dealing with vehicles and their interaction with other vehicles and or pedestrians?
It involved looking at the various triggers that system is capable of recording. And specifically, it was looking at what triggers a sudden braking event. So we were able to determine that those triggers, the sudden braking event is triggered when a driver, I should say the vehicle, reaches...
May we approach?
Now you're...
Yes, you can move on.
You've been qualified in other courts to testify as an expert in the area of accident reconstruction, is that right?
Yes, sir.
You were not hired by the defense in this case, correct?
That is correct.
At the time you did your expert review, Dr. Wolfe, and your consultation, you and I had never met.
That's correct.
You did not know who I was.
I did not.
You'd never met Ms. Little?
No.
Mr. Unetti?
No.
In fact, you'd never heard of this case.
That's correct.
You were hired by another agency not connected in any way to the defense, is that right?
Correct.
And not connected in any way to the Commonwealth, is that right?
Correct.
So your analysis and your conclusions and your opinions are completely independent of the defense and the Commonwealth in this case, is that right?
Objection.
Sustained. Mr. Jackson, you can ask it differently.
When you did your analysis and conclusions, well, let me ask it this way. You finalized your report, you and your team, correct?
Correct.
That report is contained in a multi-page document that was submitted following your analysis and your opinions and conclusions, right?
Correct.
The defense didn't have anything to do with that, correct?
Correct.
You never met us, didn't know who we were when you did this.
Correct.
You never met Mr. Lally, didn't know who he was when you did this.
Correct.
So your analysis, opinions, testing, and conclusions were requested by a completely separate agency.
That is correct.
Goes without saying, but I'm gonna ask it anyway. You haven't been paid by the defense,
You have not paid us anything, no.
and you don't work for us.
That's correct.
As a matter of fact, I've never asked you specific questions about your testing before today.
That is correct.
Your work product, the report that you provided, was provided both to the defense as well as the Commonwealth. Is that right?
That's my understanding, yes.
And you were equally available to both sides.
In terms of them reaching out?
Correct.
Yes,
And I called you ultimately after receiving your report, asked if you join us and testify, correct?
that is correct.
Were you and your team asked to undertake a review for purposes of accident reconstruction of the case that's now pending before the court?
Yes, sir.
Was your team asked to do this by the agency that ultimately retained you, not us?
That's correct.
Who at ARCCA was assigned to the team who would ultimately undertake this job of accident reconstruction?
It was myself, Dr. Andrew Rentschler, and Scott Klein.
What was Dr. Rentschler's role in this case, as it's distinguished from your role in the case?
Certainly. So Dr. Rentschler is a biomechanical engineer, and ultimately he assessed whether or not there was a mechanism for the injuries of Mr. John O'Keefe.
And what was your focus? If he's talking about the injuries to Mr. O'Keefe, what was your focus in your reconstruction and your analysis?
I would simply say it was looking more at the damage to the vehicle.
Okay, so in terms of your team and the responsibilities of each of the team members, you were more focused on the damage to the SUV. Dr. Rentschler was more focused on the injuries suffered by Mr. O'Keefe, correct?
I think that's a fair characterization, although with the caveat that we worked together as a team. So we weren't isolated kind of in those areas, not speaking to each other. We certainly worked together on the analysis.
Understood. Were you provided or did you review certain materials in furtherance of your consultation in this matter?
Yes.
What were you provided?
We were provided photographs of the incident location. We were provided photographs of the Lexus. There were a couple of incident reports that we received. I could look at my report for the full list, but those are the ones.
You can go ahead and do that, Doctor.
Do you have the report with you?
Yes, sir.
I have a copy of it. Is this faster?
Sure.
May I?
Sure.
How many categories of materials were you provided?
Provided, it would be approximately 10.
Could you list those off of the jurors, please?
It would be the Norfolk SPDU homicide death report, the Commonwealth of Massachusetts Department of State Police crime scene report, OCME dispatch removal report, photographs of the incident location, videos of the incident location, photographs of the 2021 Lexus LX570, photographs of recovered evidence, crash data retrieval report from the 2021 Lexus 570, report of autopsy, and autopsy photographs.
Based on these data that you were provided, were you able to satisfactorily, to your mind, satisfactorily engage in the consultation that you were hired to do?
Yes.
And come up with some opinions and conclusions based on scientific certainty?
Yes.
Did you review scene photographs of the alleged incident?
Yes, sir.
What information were you able to glean or gather from your review of the photographs from the scene?
So from those photographs, I was able to identify there was fragments of transparent red, clear plastic. There also appeared to be pieces of chrome and black plastic. I also observed what appeared to be glass fragments along with a black drinking straw.
Did you also review some videos?
Yes.
That was out at the scene, maybe a leaf blower?
Correct. It appeared to be daytime, yes.
Okay. What did you note about the photography at the scene of the items that were being photographed?
Well, I think one thing that comes to mind is it was a little bit difficult to follow the evidence, so to speak. So typically, when I go out and do an inspection, especially of a fresh incident, let's say I've got a debris field or I've got tire marks, what I like to do is kind of step into the scene, if you will, where you take global perspective shots and then you step into a specific piece of evidence so that you can, at a later point in time, identify where that evidence is. I noted that in a lot of these photographs, I didn't see a whole lot of that stepping in. It was essentially just zoomed right into where that evidence is, but not really having a great understanding of where was it relative to all the other evidence.
Or when it got there?
Correct.
Based on your review of all the materials that you described for the court, did you get an understanding of what the Commonwealth's theory of the case is, specifically Mr. O'Keefe was struck by the Lexus SUV?
Objection.
Sustained.
Did you come to understand that the allegations before the court were that Mr. O'Keefe was struck by the vehicle?
Objection.
Sustained. Ask it differently, Mr. Jackson.
Did you perform an accident reconstruction specifically focused on determining whether or not damage to the Lexus was consistent with hitting Mr. O'Keefe?
Yeah.
Also focused on whether or not the injuries to Mr. O'Keefe were the result of being hit by a vehicle?
Yes.
Okay. During your analysis, did you note the damage to the vehicle?
Yes, sir.
Describe that, please.
So the primary damage was to the right taillight. It appeared to be fractured with the majority of the lens cover, so that clear and red plastic covering missing from it. In addition to that, if you're looking at the back of the vehicle, to the left of that, in the area above there's also another tail lamp assembly on the lift gate. So above that assembly, there was a small dent along with some paint chips on the bumper, more so on the wraparound section as it kind of curves around to the right side of the vehicle. There appeared to be some superficial scratches as well in that area.
Was there any other damage or deformation that you were able to glean from your review, the photogrammetry, damage to the Lexus, the bumpers, the panels, the quarter panel, the sheet metal, anything like that?
No, the rest was remarkably intact.
Is it common in vehicle pedestrian collisions that there's some sort of bumper displacement and or sheet metal deformation that's concomitant to that?
Absolutely. Assuming a pedestrian is positioned in a normal upright position, you certainly would expect to see damage to the bumper. In a lot of cases, what happens is, the bumper is just clipped on. So again, the force of that impact will oftentimes cause the bumper to kind of become unmounted or unclipped. You certainly could see deformation to body paneling, such as the lift gate or the quarter panel as well.
Is that especially true at higher speeds, meaning above 15 miles per hour or so?
Oh, absolutely. Yes.
Was there any apparent damage to the Lexus that appeared consistent with any kind of pedestrian interaction that you saw?
No, it was really confined to just the taillight, a very isolated portion of the vehicle.
During your review and your investigation, did you note information concerning items that were supposedly found on the bumper?
Yes.
What was that?
I believe it was noted there was 2 apparent glass fragments located on the top bumper cover.
What's the significance of the presence of those items or the lack of materiality of those items in your view?
Well, again, I think this, going back to the scene evidence, again, we knew that there was glass fragments, what appeared to be from a drinking glass at the scene of the alleged incident.
Is there any glass consistent with the glass that was supposedly found on the bumper in the taillight housing, the taillight mechanism, anything from the car, from the Lexus, that would account for that glass?
Okay, I think I understand. So the taillight itself is not comprised of any glass. It is all plastic. So that damage, or I should say that glass on the top bumper cover could not have come from the right taillight.
Now, based on your review of the information that was provided to you, did you undertake any testing of that vehicle? I'm sorry, any testing concerning the damage to the vehicle?
Yes, sir.
All right, can you describe what that testing was?
So we performed, again, this is with Dr. Rentschler and I working together on this again. We performed projectile testing to the tail lamp with a drinking glass as well as a hybrid head form.
Let's take those one at a time. How would you describe the drinking glass test?
Certainly. So again, from our review of the evidence, we knew that we had an isolated portion of damage to Lexus confined to the taillight. So we know that we're dealing with potentially a small object that could have created that. Looking at, again, the evidence in terms of the scene photographs, we know that we have a damaged drinking glass at the scene in the vicinity of the fragments of the taillight. So the theory that Dr. Rentschler and I put forward is potentially an individual threw this drinking glass at the back of the Lexus, causing the taillight to fracture. So,
I'm going to interrupt you right there. You and Dr. Rentschler formed that theory and wanted to test that theory, correct?
yes,
You were not told that theory by the defense because you've never met us.
correct,
You were not told that theory by the Commonwealth. You've never met them, correct?
correct.
Your theory was the product of simply having some facts extant in the data, that a broken drinking glass, a broken taillight, let's put them together and figure out if the drinking glass could be responsible for the taillight and vice versa.
Absolutely, yes.
And that was your determination of, well, we were given instructions to reconstruct this, let's look at every single angle, correct?
Absolutely. And I will note, as part of the engagement with the entity that retained us, we were asked not to do any outside research or investigation of the case. It was to be based solely on the evidence that we were provided.
Okay. As a matter of fact, and importantly, while you were doing your testing, had you ever even heard of the Karen Reed case?
No.
So getting back to that testing, and I interrupted your flow, you were looking at whether or not the glass could have produced the damage to the rear taillight that you saw, correct?
Correct.
And what did you do in furtherance of making a determination about whether or not that was possible?
Certainly. So myself and one of our lab technicians at ARCCA, we designed and developed a pressurized air cannon. So it was capable of firing a projectile such as a drinking glass at the taillight. So it essentially, you think of it kind of as a giant cannon, but it had a barrel, and then there was a valve that would open rapidly, and directly behind that was a pressurized vessel. And depending on the pressure, the PSI of that vessel would determine essentially the speed at which that glass would be projected into the taillight.
So you literally built a cannon?
Yeah, it's pretty awesome.
Tell me what the results of your testing was with this pneumatic cannon that would fire the drinking glass.
Certainly. So we performed 2 different tests in terms of speeds. The target speeds were 30 and 40 miles per hour.
Why was that?
Well, so with consultation with Dr. Rentschler, he indicated that that is a reasonable speed at which an adult male or an individual for that matter could throw a drinking glass at the taillight.
Had anybody up to that point, anybody told you any specific, let me see if I can rephrase that. Had anybody indicated that there was any evidence whatsoever that John O'Keefe had thrown the drinking glass at the taillight?
No.
Was this another example of you and Dr. Rentschler and your team just exploring sort of every possibility and working a little bit in the blind?
Objection.
Sustained.
What was the reason that you decided, or you and your team decided, that you wanted to approximate how a grown man could throw a glass at a taillight?
Well, I think we wanted to have an understanding is when a projectile such as a drinking glass interacted with the taillight, would we get damage on the test taillight that was consistent with that of the subject taillight?
Understood. So based on your theory, were you able to approximate the damage on the taillight?
Yes.
Describe that for us.
So as I mentioned, we ran 2 tests. The target speeds were at 30 and 40 miles per hour. And there was a little bit of variability in terms of what our target was and what we actually achieved. So the achieved speeds were at 31 miles per hour and 37 miles per hour. So there's just depending on how the glass leaves the barrel and some of the rotation can affect some of the speed. or ultimately the end result speed to that. So what I will say, though, is that with the 37 mile per hour projectile into the taillight, we noted and observed that there was damage that was consistent with that of the subject tail lamp, and that the test tail lamp had the majority of the outer lens fractured and missing, broken into pieces, as well as some underlying damage to some of the internal components as well.
Are you saying, well, let me ask you a different question. You were able to replicate the damage to the taillight using a pneumatic cannon firing a glass at 37 miles an hour directly at the taillight, correct?
Correct.
All right. And that would also shatter the glass too, correct?
Correct.
Did you do any testing about whether or not that damage to the taillight could be produced by a person simply holding a glass and being hit by the car driving in reverse?
We didn't do any testing of that, and primarily because, again, if we're looking at the arm and its total length, right? We only have a narrow damage pattern, which on the taillight, if you think about where where it meets the lift gate into where it starts to wrap around to the side of the vehicle, it's only about 6.5 inches in width.
All right. When you fired the glass into the taillight was static. In other words, it was not going to move. It was immovable, correct?
Correct.
All right. So the glass is hurling through the air at 37 miles an hour and hits the static object that's resisting, and that smash is what produced ultimately the taillight damage that you were able to replicate. Is that right?
Yes.
If a person were holding in his hand the glass, and the taillight were to hit that hand, the hand would not remain static, correct?
Objection.
Sustained. Ask it differently, Mr. Jackson.
If the taillight were the taillight would make contact with a person holding the glass, would that replicate what you did in terms of your firing a glass into the taillight? In other words, are they apples and apples?
No, I don't think it would be the same.
Okay. Why is that?
Well, as I mentioned earlier, again, the damage to the back of the Lexus, again, is confined to just that roughly, again, we're talking about the taillight itself, that 6.5 inch section in width.
Right.
So it's inconsistent with the total length of the arm, and certainly from discussion with Dr. Rentschler, inconsistent with the injuries to the arm.
So given everything in your investigation was revealed concerning this testing, are you saying that the taillight was damaged by John O'Keefe holding a drinking glass that was hit by an SUV?
Objection.
Sustained.
In all the information that you provided, you were not provided anything that suggested that John O'Keefe threw a glass at the taillight. Correct?
Objection.
Sustained.
Your approach.
Yes, just, yes.
What information, if any, were you provided that suggested that John O'Keefe threw a glass at the taillight?
No information.
What information, if any, were you provided that suggested that John O'Keefe may have a pneumatic cannon with him?
I'm not aware of any information regarding that.
All right. You also did some testing concerning a drop test. Is that right?
Correct.
Tell us about that drop testing.
Certainly. So again, through discussion with Dr. Rentschler, it was my understanding that Mr. O'Keefe had a skull fracture on the back of his head. So we wanted to do an evaluation of the interaction between the back of a head. In this case, we used again, talking about that instrumented dummy again, we used the instrumented hybrid head form to perform a drop test to evaluate the forces of an interaction between a taillight from the Lexus and the human head.
What height did you choose to perform this drop test?
7.5 feet.
Why'd you choose that height?
Well, if you calculate it through physics and the acceleration due to gravity, that would equate to an impact speed of 15 miles per hour at that height.
And what was the significance of 50 miles per hour?
Well, that was essentially kind of a starting point for us, if you will. So I will tell you that in reverse, 15 miles an hour is fast. I don't know if you've ever looked at your speedometer when you're pulling into your driveway, reversing into a parking stall. Most people probably don't go more than 5 miles an hour or so. So 15 miles an hour in reverse is fast, especially when we're talking about, it's my understanding it was nighttime. There was winter conditions, potentially wet or icy roads. So again, that speed is going to be what I would say on the high end for going in reverse. So also in addition to with respect to kind of just the nature of that speed, it's my understanding through discussion with Dr. Rentschler that at 15 miles an hour, you start to see significant injuries to the human body when it makes contact with a vehicle. And I think one last point is that we needed to pick a speed where, again, this is kind of just us brainstorming, where we would have damage to the taillight, right? It would fracture it, but it wouldn't completely obliterate it. So we knew if we chose a speed, for instance, of 40 miles an hour, we know we're going to completely essentially explode the taillight. But if we do 1 mile an hour, we may not do anything to it, right? So we kind of had to pick a middle ground to again, cause damage to the taillight.
What was your conclusion following that testing? What was your conclusion with regard to whether or not it was consistent or inconsistent with the damage to the truck? The taillight was consistent or inconsistent with making contact with John O'Keefe's head at or above 15 miles an hour?
So strictly speaking to a damage perspective, the 15 mile an hour interaction between the hybrid head form and the test tail lamp produced significantly more damage than that of the subject vehicle. So that indicates that, again, the damage on the subject tail light was less than that of the test tail light.
So if I were to ask you whether or not there would be more or less damage to the taillight if you increase the speed to 24 miles an hour, what's your conclusion?
Well, you're talking about significantly more kinetic energy. So if you just think about it from, again, a kinetic energy standpoint, kinetic energy is equal to 1/2 times the mass and the velocity square. So if you're squaring that velocity and you're going from 15 up to 24 miles per hour, you're going to get a significant amount of more energy associated with that. Probably, I could pull up my calculator, but you're probably looking at 2.5 more times energy than the 15-mile-an-hour test.
Which means 2.5 more times the damage to the taillight,
Certainly.
which you did not see in your review of the materials, correct?
Correct.
So what is your opinion or conclusion as to whether or not the damage to the taillight was caused by striking John O'Keefe's head?
From a damage standpoint, it was inconsistent.
I want to shift gears back to the injuries that you saw concerning Mr. O'Keefe's arm, his right arm. During the course of your investigation, did you look at photographs and investigate the injuries to his right arm?
Yes, sir.
What's the width of the taillight, specifically from where it meets the lift gate on to the left side? I'm sorry, to the side of the vehicle, right side of the vehicle.
To the right. So yeah, as I mentioned earlier, that is about 6.5 inches. Again, it starts to wrap around to the right side. So really, it's even though the taillight continues, it's not projecting out on the back end where it's again wrapping around. So in terms of the width that is facing the rear, if you will, it's about 6.5 inches.
And you noted that there was a dent and some paint chips that you identified above the lift gate, correct?
Correct.
How far away from the right side of the vehicle were those scratches and that dent?
Approximately 20 inches.
What was the significance of that distance?
Well, again, to go back to your question about, I think if somebody was holding a drinking glass, right, and their arm was extended to cause that damage, or if it's theorized that those dents and chips were from that. Again, the thing that sticks out to me is that you have essentially the Lexus taillight.
So ask another question.
What's the significance of whether or not there was damage between the dent and the taillight? In other words, that 20-inch area. Was it dented? Was it torn in any way?
So in terms of, again, if we're talking about, again, looking at the back of the vehicle and we go to kind of where that right tail lamp just meets the liftgate, as I mentioned, there's another lamp assembly on the liftgate itself. There's also a chrome trim piece above that, and then certainly the body paneling to the liftgate itself. And I think what stood out to me is that between that dent and the fractured taillight, there was no observable damage to that area, which I would have expected had an arm been positioned there.
Can you calculate, or could you calculate, or did you calculate the amount of force that would be required to strike a person just only on the outstretched portion of his arm in order to project him a number of feet, for instance, 30 feet in one direction or another?
Okay, I just want to make sure I objection.
Take a distance out of it. Break it down.
I'll ask you the same question, but without the 30 feet.
Okay.
Were you able to calculate, or could you calculate the force that would be required to strike a person on his outstretched arm hard enough to spin him around and project him a number of feet?
If you're talking about only an interaction between the arm and the back of the vehicle, no, there wouldn't be any projection. Again, if you think about this, the arm weighs about, again, with Mr. O'Keefe would be about 11 pounds. So you still have, another 200 plus pounds being held down by gravity, and the force is only acting on the arm. So essentially the arm would be accelerated, but the whole body, because the center of mass is not being struck, would not be projected.
Is the absence of damage that you described between the dent and the rest of the vehicle, with the exception of the taillight, is that consistent or inconsistent with striking an outstretched arm of a human being?
Objection.
I'll allow that.
That would be inconsistent in my opinion.
May I have testimony, Your Honor?
Yes.
And what is your opinion, Doctor, as to the amount of damage that you would expect to see at 15 miles per hour or above on the taillight if, in fact, that vehicle were moving in reverse and were to strike something on a human body, for instance, an elbow or an arm?
Objection.
I'll allow that.
I'm sorry, can you repeat the question?
Probably not.
Sorry.
I'm trying. Physics, that's why. From your testing, what would you expect to see in terms of the damage to the right rear taillight if, in fact, that taillight were to make contact with a part of a human body, for instance, an elbow or an arm, at 15 miles an hour or above? What would the level of damage be as compared to the damage that you actually saw?
Well, if we compare it to, again, looking at the drop test that we did with the hybrid head, which weighs about 10 pounds. So again, if we're talking about now a human arm that's comparable in that same weight, we certainly would expect to see a comparable level of force and damage. So as I mentioned, if the arm is outstretched across the right tail lamp and into the liftgate section, I would certainly expect to see deformation to that body paneling, even potentially the tail light on the liftgate itself and that chrome piece as well. Based on the entirety of your investigation, your entire team's investigation, all the testing that you did, all the biomechanical testing and the engineering and the physics testing that you did, in your expert opinion, was that taillight damaged by striking John O'Keefe on the head?
Objection.
Sustained.
In your opinion, was the taillight damaged by either striking Mr. O'Keefe in the head or the arm?
Objection.
Sustained.
Can we approach?
Yes.
You are muted.
May I, Your Honor?
Yes.
Last question, Doctor. In your expert opinion, based on all your testing, is the damage to the taillight that you saw consistent with striking a human head?
No.
In your expert opinion, is the damage to the taillight consistent with striking a human arm?
No.
Thank you. That's all I have.
All right, jurors, we will take our morning recess.
Morning, sir.
Good morning.
Now, you, in conjunction with, Dr. Rentschler, is that correct?
Dr. Rentschler, yes.
So you, in conjunction with Dr.
Keep your voice up, Mr. Lally.
Yes. You, in conjunction with Dr. Rentschler and Dr. Klein, wrote a report in regard to your analysis, correct?
Correct.
And doctor, that report was issued on February 12th, 2024. Is that correct?
Correct.
And in the first paragraph of that report, the last two sentences, you or whoever the author of that particular portion indicates, this analysis is based on information currently available to ARCCA and is only to be issued in its entirety. However, ARCCA reserves the right to supplement or revise this report if additional information becomes available. Is that correct?
Correct.
And that's pretty standard as far as your industry is concerned. You can only work with the information that you're provided. Is that correct?
Certainly.
Now, in this instance, you were provided 10 things, and then there were 4 additional things that either you or the other doctors had reviewed as far as literature or things of that nature. Is that fair to say?
Correct.
And the 10 things that you were talking about were reports, an initial crime scene report, medical examiner dispatch removal report. Is that correct?
Correct.
Photographs of the incident location. Is that correct?
Correct.
And how many sets of photographs of the incident location were you provided with?
In terms of the number of photographs?
The number of photographs. Or were there different sets of photographs?
Yes.
And how many sets?
I don't recall off the top of my head. I know that there was a series that were taken during the daytime as well as ones taken what appeared to be in the early morning hours.
And you were also provided video from the early morning hours. Is that correct?
From what I recall, I think it was daytime, but yes.
Photographs of the vehicle, photographs of recovered evidence. Is that correct?
Correct.
CDR report from the 2021 Lexus LX570. Correct?
Correct.
Autopsy report, autopsy photographs. Is that correct?
Correct.
And then some other things. Those will be the 10 things that you were provided with, and then there were 4 other things that you reviewed or part of your team reviewed. Is that correct?
Correct.
Now, in regard to there's a section in your report called Review of Materials, and it talks about photographs and glass fragments and plastic fragments and things of that nature. Correct?
Correct.
You also talk about a black drinking straw that was recovered on scene. Is that correct?
Correct.
However, there's no mention in the report about Mr. O'Keefe's shoe or Mr. O'Keefe's hat. Are you aware of those items as well?
Yes.
And are you aware that Mr. O'Keefe's shoe was actually found dug out from the snow, sort of flush with the curbing in front of the area where his body was found?
Yes.
Now, over the course of your work as a crash reconstructionist, and again, I don't mean this in any way, shape, or form, but I'm just curious. Typically, you're reconstructing or you're looking at someone else's reconstruction in relation to something that occurred in the past, correct?
Not always, no.
Well, my question is, sir, how many times have you actually been on like a live suit where the vehicle was still in place of final rest, where there are bodies in place of final rest, have you ever been to see where those sort of conditions existed?
Certainly. We have a rapid response team that essentially we've been on site on the day of or the week of the incident, yes.
Now, how often is that?
Not nearly as often as, like I said earlier, we primarily do litigation work. So again, by the time we're retained, obviously the scene has been is no longer present.
Scene's been cleared, items have been removed as far as evidence or other things. That's mostly what you deal with, correct?
Sure.
And as far as the hat that we were talking about before, is are you aware that that was recovered as well, same day as the drinking straw on February 3rd in the area where the body of Mr. O'Keefe was discovered?
In the area of the front yard, yes.
Now, you have some familiarity through working as crash reconstructionist with pedestrian collisions, correct?
Correct.
Is it common or uncommon for in the course of a pedestrian collision, for a shoe or glasses or a hat or something to fall off of that pedestrian in the collision sequence near where the area of impact occurs?
Well, I think that depends on the interaction between the two. If it's more of a side swipe type interaction, if we're just talking about an arm, for instance, contacting the vehicle, no, I would not expect the shoe to come off. If it's something where the entire body is interacting with the vehicle, then yes, there's a greater likelihood that something like a shoe will come off, yes.
So that is consistent in general terms with a pedestrian collision of a shoe coming off, correct?
Again, based on the interaction between the two. I wouldn't say it's a blanket statement that, again, in all pedestrian interactions, you will have a shoe come off.
And that's not the question I was asking. So what I'm asking is it generally consistent with pedestrian collisions that a shoe may come off during the collision sequence near the area of impact?
Shoes can come off in a pedestrian impact, yes.
Now, again, you were testifying earlier about the damage to the Lexus being isolated in the area of the taillight, correct?
Correct.
And that was based on the information that you were providing, correct?
Correct.
Now, with respect to any of the materials that you were providing, was there anything in the materials that you were provided that indicated that just the arm or an outstretched arm of Mr. O'Keefe interacted with the vehicle?
No.
And based on your review of any of the materials that you were provided, was there any information stating that Mr. O'Keefe had been struck in the back of the head by the taillight assembly of the Lexus?
No.
And based on any of the materials, let me ask you, based on any of the materials that you provided, were you aware that Mr. O'Keefe is on video exiting from the bar minutes before crash occurs at approximately 12:11 a.m. holding a cocktail glass in his right hand?
I'm not aware of that video.
Now, other than the materials that we just went over as far as the 10 things that you were provided, you weren't provided anything else, is that correct?
That would be correct.
And so sort of the questions that you endeavored to answer, those were questions that you didn't know from any of the materials that you were provided, is that correct?
If I understand your question correctly, there was nothing in the material that indicated the questions we were to answer, if that's what your question was.
That is my question. So there was nothing in there, is that correct?
Correct.
I may have a moment, John.
Yes.
You talked a bit about, you have some extensive background in human factors, correct?
Correct.
And as far as visibility, in particular, have you ever conducted a visibility analysis?
Absolutely, hundreds of times.
And you talked a little bit about conspicuity, is that correct?
Yes.
And part of conspicuity, at least one of the factors, would be a reasonable expectation of, in particular, when you're talking about a pedestrian. Part of the conspicuity factors would include sort of a reasonable expectation that a pedestrian would be in the path of the vehicle. Is that fair to say?
I don't understand your question.
When you're talking about conspicuity or visibility analysis, in particular, you're talking about something called PRT or perception reaction time, correct?
Well, that occurs after recognition. So first, a driver has to recognize that there's a pedestrian there before they can actually respond to it. So once they've recognized the pedestrian, then you start the perception response time where, again, the driver has identified what the hazard is. They're making a decision about what to do. They might be moving their foot from the accelerator pedal to the brake pedal. So again, kind of that's the action or the time frame in which a driver is undergoing action to potentially mitigate the collision.
And perception reaction time, that's a pretty commonly used industry sort of standard as far as crash reconstruction goes, correct?
Well, I would say that it's used in the field of accident reconstruction, but as I mentioned earlier in my testimony, there isn't a blanket number in terms of perception response time. As I mentioned, it's based upon the hazard that the driver is presented with. Again, if you've got a pedestrian crossing the roadway, that's going to be one particular perception response time based upon studies and naturalistic data versus a driver suddenly stopping in front of you, right? It's not the same perception response time in every scenario.
No, understood. There's different variables that may affect that as far as someone's age, as far as the lighting that's available, other things. Is that correct?
Sure.
And one of those things might be the reasonable expectation of a pedestrian being present in the roadway as you're driving along, correct?
Expectancy can play a role, yes.
In expectancy, what we're talking about is sort of the disparity or the difference between driving along a country road where there's no houses for miles and miles versus an urban area where there's crosswalks every 15 feet, correct?
Sure.
Now, in that expectation of privacy, how high would that be if we're talking about a pedestrian that actually exited from the vehicle that then strikes?
I don't understand your question.
Let me ask you this. If the operator of the vehicle has a passenger who then exits the vehicle and goes towards the back, would there be a high reasonable expectation that the pedestrian would be located in that area?
I don't know if I would classify it as high.
What would you classify it as?
I honestly don't know that I have a classification to it.
Now, you never looked at the defendant's vehicle in this case, correct?
Correct.
Are you aware that the defendant's vehicle is still in police custody and available for inspection?
I'm not aware of that.
Did you ever ask to look at the defendant's vehicle?
No.
Now, a typical pedestrian strike, for the most part, involves a pedestrian in front of a vehicle as it's coming down the street. Is that fair to say?
That can be one type of interaction, yes.
Is that more prominently seen as far as your field than rear collision?
I would say that's fair.
And there are various types of sort of interactions that the pedestrian can have with the vehicle in order to cause and sort of sustain injuries. Is that fair to say?
What I would say is that there's certainly, in terms of how the pedestrian interacts with the vehicle, in terms of whether they're being wrapped onto the vehicle or projected forward, certainly there's different types of interactions, yes.
So there's like a wrap and forward projection type of collision sequence. Is that correct?
Those are two common, yes.
There's also something called a fender vault. Is that correct?
Correct.
And sort of how or where that pedestrian is positioned with relation to the vehicle is somehow or somewhat determinative of the injury sustained. Is that correct?
It can be, yes.
Obviously, you're going to see different injuries if someone fender vaults and goes over the top of the vehicle versus someone who is projected forward from the collision sequence with the front of the vehicle.
Just to clarify, again, in this matter, I was not assessing injuries. That was Dr. Rentschler. I don't have an opinion.
What I'm saying is based on your experience, so that you understand that there's a difference in the injuries that you might expect based on the type of interaction that a pedestrian has with the vehicle.
Yes.
And then if someone is wrapping forward projected and then the vehicle overruns that person, there'd be a whole other host of injuries that you'd expect to see based on being overrun by the vehicle, correct?
There could be, yes.
Now, the testing that you did with respect, these are essentially experiments that you're doing, correct?
That's fair, yes.
And am I correct in saying that in scientific experiments or in the world of scientific experiments, there are certain things called variables that you're trying to account for? Is that correct?
I would say that's fair, yes.
And essentially what you're trying to do is control as many of those variables as you can in order to best replicate whatever the conditions were at the time that what you're testing to see actually occurred. Is that correct?
Correct.
Now, what, if anything, did you do to control variables in relation to temperature?
So one of the things we did with all of the tail lamp assemblies that we tested is that we preconditioned them to approximately 28 degrees, that they'd reached a steady state temperature before we subjected them to the impact testing.
And where in your report does it say that?
I don't believe that's explicitly stated.
Is it implicitly stated anywhere in your report?
Again, I'm telling you, that's part of what we did for the testing.
I understand that's what your testimony is, but you wrote a report, correct?
Right, and I don't know that I detailed every single part of the test. Again, we summarized it.
Understood. So what did you do to control any variable as far as wind?
Well, when you're talking about a projectile such as a glass, again, that's being projected at 37 miles per hour, again, there would be probably minimal effects in terms of the wind.
Even if there was a blizzard going on?
Again, what we're going after here is ultimately conducting a test such that the drinking glass arrived at the location of the taillight. So if you're trying to say that, okay, he threw it this way and the wind blew it towards the taillight, sure, that could be a possibility.
And sir, I'm not trying to say anything. I'm just asking, are you aware that there was a blizzard and that there were wind gusts up to 37 miles per hour during the time that this collision occurred, and that's not accounted for in your test?
Were you aware of that, sir?
I'm aware that there was inclement weather at the time, yes.
Now, with respect to what type of glass did you use?
So we used a rocks drinking glass. So that's a glass that has a thicker base and a shallower sidewall.
And so what I'm asking, so was it cocktail glass, was it pint glass? What kind of drinking glass are we talking?
A rocks drinking glass.
And how tall is that rocks drinking glass that you use?
If I had to estimate, I think it was about 3 or 4 inches tall, probably.
And the thickness, did you measure that as far as the thickness of the bottom of the glass?
No.
Was the thickness of the bottom of the glass thicker or more thick or less thick than the top of the glass?
Are you talking about this in comparison to the sidewall of the glass?
Talking about in comparison to itself. So you have a glass, this rocks glass. Was the bottom thicker or the top thicker?
The sidewall would be taller, if you will, than the base.
And so when you're projecting this thing out of the device that you created, the whatever it was, are you facing sort of the top of the glass where you would be sipping out of, or the bottom of the glass at the tail?
So in the testing, the interaction between the taillight and the glasses was primarily between the base and the taillight.
Now, with reference to actually a little bit about the video, and you weren't aware of Mr. O'Keefe exiting from the waterfall bar at 12:11 in the morning, about 15, 20 minutes before he struck by a vehicle. You're not aware of that?
I'm not aware of that.
Now, with reference to that particular establishment, was there anything stopping you or the other doctors that you were working with from going to that establishment, finding out what kind of glasses they had, getting an actual cocktail glass from that establishment?
I had no idea that video existed.
Did you even know that Mr. O'Keefe was at a bar before he was struck by the vehicle?
I believe that in one of the incident reports we reviewed that there was, I think, a narrative about that they had been at a bar drinking, yes.
How is it that you determined where on the taillight assembly to aim?
So we looked at the fracture pattern, and what it appeared to be that it was emanating from basically where the clear portion meets the red cover. We kind of saw that the fracture pattern emanated from that, so that's where we targeted it.
Now, when you did this testing as far as the sort of breakage or the pieces that came off the taillight, is it fair to say that they were of sort of different shapes and sizes of broken pieces?
Sure.
Consistent with the broken pieces that were found on the scene near Mr. O'Keefe's body?
Yes, I would say that's fair.
Now, I know you may not be the person for this, but just as far as you reviewed some of the autopsy report and medical findings in regard to Mr. O'Keefe, correct?
Correct.
And the injuries to Mr. O'Keefe were primarily on the right side of his body, correct?
Correct.
So there were injuries to his right arm and forearm, elbow area, correct?
Correct.
There was bruising to his right hand. Do you recall that?
Yes.
There was an abrasion to the outside or the posterior of his right leg near his knee. Do you recall that?
I don't know that I recall that off the top of my head.
And do you recall sort of the skull fracture or the laceration that immediately outside of the skull fracture was on sort of the right back of his head?
Yes.
Now, from the reports that you reviewed, were you aware that when Mr. O'Keefe's body was discovered by the defendant and two of Mr. O'Keefe's friends, that the defendant was the only one who could see him in the conditions?
Objection.
Sustained.
As far as the lighting was concerned in that area where Mr. O'Keefe's body was found, are you aware there was no overhead street ambient lighting or anything like that?
Objection.
I'll allow that.
I'm not aware of that.
And you didn't do any visibility analysis or anything in relation to this case, correct?
That wasn't part of my scope in this case.
Well, as far as part of your scope, did you define that you indicated earlier that there were questions that you didn't find in the materials that you actually conducted experiments to prove or disprove, correct?
Well, again, the entity that retained us in this asked us to evaluate whether or not the damage to the vehicle and the injuries to Mr. O'Keefe were consistent with the interaction or in interaction between the two.
So you were at least somewhat restricted in the scope of what you could do based on the parameters given to you by the agency that hired you. Is that fair to say?
Sure.
Now, as far as any statements by the defendant to investigating troopers either that afternoon or that morning when Mr. O'Keefe's body was discovered, were you familiar with any of those?
Objection.
I'll allow that.
I'm not familiar with.
Sure.
So, doctor, with regard to the defendant's statements at any point, were you did you review materials or were you made aware that the defendant said to multiple people on scene, I hit him, I hit him, I hit him, I hit him?
I'm not aware of that.
Now, within the report that you and the other doctors submitted, there's an indication that if either Mr. O'Keefe's arm or head had interacted with the taillight, there'd be some expectation that either blood or DNA would be contained on that taillight. Is that correct?
I believe, yes, that was stated in the report.
And at any point were you made aware that Mr. O'Keefe's DNA actually was recovered from that taillight assembly from the defendant's vehicle?
No, I was not.
Now, as far as forensic reports, what, if anything, were you provided in reference to that, other than the initial crime scene report?
Are you talking about specific to the scene or forensic reports to the body?
Forensic reports specific to the evidence that was recovered from the scene and from the defendant's vehicle.
Only what would be listed in the report.
Now, you indicated one of the materials that you were provided and reviewed was the EDR, event data recorded data.
The crash data retrieval report, yes.
Now, we've shown anything as far as a crash reconstruction report from a trooper from the state police?
No.
And the EDR data that you observed, did that contain any sort of usable data?
There was no events recovered on the black box.
And with respect to there being no events recovered on the EDR or the black box in a pedestrian collision, is that unusual?
It is not.
And why not?
Well, because you're talking about, excuse me, a very large weight difference between the vehicle and the pedestrian. So ultimately, what the vehicle is constantly monitoring is acceleration, which gets back to a term called delta V. So when the vehicle doesn't experience a big delta V, typically the threshold for a non-deployment event where you're not firing airbags or any safety mechanisms, but the vehicle wakes up and says, hey, there was something that I potentially hit. It's usually at a threshold of about 5 miles per hour. So again, given the weight difference, we usually don't see delta Vs that high with pedestrians.
And is that in some respects because what the EDR and what the safety restraint systems are designed to protect is the occupants of the vehicle, correct?
That's fair, yes.
I mean, there are more innovations as far as vehicles that are more modern or released earlier that have certain pedestrian or protections for other vehicles, but primarily what they're focused on is the occupants of the vehicle, correct?
Correct.
Now, at any point in time, were you shown any tech stream data, Toyota tech stream data from the defendant's vehicle?
No.
So you weren't shown any data indicating that the defendant's vehicle was being operated in reverse.
The objection sustained. Next question.
So with regard to the defendant's statements, were you also not told that the defendant told several people that she had just gotten into a fight with Mr. O'Keefe right before she dropped him off at 34 Fairview Road?
So that's sustained.
Now, with regard to pedestrian collisions, you're familiar with sort of the physics term, I'm presuming, Doctor, as far as like center of mass.
Yes.
And what kind of role does the center of mass for a pedestrian play in relation to the center of mass of a vehicle as far as how the two interact?
Well, it depends again on the vehicle structure. And again, when you're talking about where's the hood height, the bumper height, and the CG or the center of gravity of the pedestrian, that again will kind of dictate how they interact with between the vehicle and the pedestrian.
Now, typically, a typical pedestrian collision, again, that we were speaking about before, is in relation to a pedestrian struck by the front of the vehicle, correct?
Correct.
And so in a typical pedestrian collision, that involves more of an assumption of the velocity of the striking vehicle than you would see occur in sort of a side swipe. Is that correct?
I'm sorry, can you repeat the question?
In a typical pedestrian collision, that would involve more of an assumption of the velocity of the striking vehicle by the pedestrian than you would see in a typical side swipe collision. Is that correct?
If I understand your question correctly, yes. If the vehicle is striking the center of gravity of a pedestrian as opposed to just, for instance, a limb, yes, the center of gravity of the body will be accelerated up to that speed.
Now, with respect to the defendant's vehicle, again, you never actually looked at the defendant's vehicle. Is that correct?
It wasn't necessary.
And did you look at the actual taillight housing from the defendant's vehicle?
I had sufficient photographs of the taillight.
Did you ever look at the actual physical broken pieces of the taillight from the defendant's vehicle?
Again, I had sufficient photographs that documented the fragments and pieced them together.
And you're aware, at least, that the fragments that were recovered on scene were then sort of put back together and overlaid over the taillight housing that was taken from the defendant's vehicle?
Yes.
And through any of the pictures of the photos that you observed, did you ever see a piece of metal protruding underneath the broken and shattered plastic pieces from the taillight?
I believe it was a plastic chrome piece.
Now, when you were doing the testing as far as shooting the drinking glass of the taillight assembly, that taillight assembly was sort of held there by vice grips or something like that. Is that correct? It wasn't actually physically attached to a vehicle that you were shooting at?
That's correct.
Now, as far as that, you're familiar with, there was a piece of a broken drinking glass that was recovered from the same area of where Mr. O'Keefe was found. Is that correct?
Amongst the fragments of the taillight, yes.
And are you familiar with Mr. O'Keefe's DNA being present on those pieces of the exterior of a broken drinking glass located near his body?
I don't believe so.
Now, as far as Mr. O'Keefe's clothing, his fingernails, are you aware that there was DNA of Mr. O'Keefe and no one else recovered from both his fingernails and from a variety of areas of his clothing?
Objection.
Sustained.
Now, from the crime scene reports that you reviewed, are you aware that there was human hair that was located on the right rear quarter panel near the dent that you were talking about?
Objection.
I'll allow that.
Yes.
Are you familiar or are you aware that subsequent mitochondrial DNA testing found that the mitochondrial DNA profile for that hair was consistent to a probability of 99.895% with the mitochondrial DNA profile of Mr. O'Keefe?
I'm not aware of that.
Now, were you also aware that the broken drinking glass with Mr. O'Keefe's DNA on it was found to be consistent with broken drinking glass pieces that were found in the street?
Objection.
I'll allow that.
Can you repeat the question?
Were you aware that the pieces from the exterior of the broken drinking glass found near Mr. O'Keefe's body with his DNA on it were then found to be consistent with pieces of broken drinking glass that were located in the street of 34 Fairview Road?
Yes.
Were you also aware that pieces of glass that you were talking about from the defendant's bumper were found to be consistent with pieces of glass recovered from the street in front of 34 Fairview Road?
Yes.
Were you aware that there were microscopic pieces of red and clear plastic, about a 16th of an inch by 16th of an inch, that were recovered from Mr. O'Keefe's clothing that were then found to be consistent with the tail?
No, I don't believe so.
Now, as far as, again, you weren't provided with any sort of reconstruction report from a Trooper Paul from the state police?
No, I was not.
You're not aware that he took measurements from the ground to where certain items were on the vehicle?
Objection.
The objection sustained. He didn't see the report. Sure.
Now, Doctor, in the course of your analysis or review of materials here, were you ever provided with a video of the defendant backing out of a garage and making contact with Mr. O'Keefe's vehicle in his driveway at about 5:07 in the morning on January 29th?
No.
Now, as far as from your review and your testing and everything that you did in this case, if a collision occurred at a lower speed, say 1, 2, anywhere from 0 to 5 miles an hour, would that create the damage to the taillight that you observed in this particular case?
At that speed, no.
So there were about 10 items that you were provided that you reviewed, is that correct?
Correct.
And a number of different items that I just asked you about that you weren't provided with or you weren't aware of, correct?
Correct.
And again, in your report, in the very first paragraph, you indicate, however, ARCCA reserves the right to supplement or revise this report if additional information becomes available, correct?
Correct.
I have nothing further.
All right, Mr. Jackson.
Thank you, Your Honor. Very briefly, Dr. Wolfe, you were asked on cross-examination a couple of questions about hair, DNA on the outside of the taillight lens, the taillight housing, and glass material. Do you recall that?
Yes.
Does any of that change your opinion about your opinions and conclusions in this case?
Objection.
I'll allow that.
Absolutely not.
What is your conclusion as to whether or not the damage to the vehicle and the injuries to the human being are consistent or inconsistent with the vehicle arrest?
Objection.
Sustained. All right, Dr. Wolfe, you are all set, sir.
Thank you.
Step right up, you got step on. Remain standing, face the clerk.
Please also the evidence recorded during the case now here to the truth, the whole truth, and nothing but the truth, so help you God.
I do.
May I inquire?
Yes.
Doctor, could you please state your first and last name, spelling your last name for the record?
Certainly. Andrew Rentschler, Rentschler.
And what do you do for a living, sir?
I'm a biomechanical engineer and accident reconstructionist.
And who do you work for?
I work for a company called ARCCA LLC.
How long have you been in that position as the, working for ARCCA? First of all?
I've been with ARCCA for about 16 and a half years now.
And you indicated that you're the director of biomechanics and human factors. Is that right?
I am. I'm a vice president and the director of biomechanics for the Midwest Division.
Can you tell us what education, training, and background qualifies you to perform your duties as the director for biomechanics and human factors?
Sure. Well, I got my BS in mechanical engineering with a minor in biomedical engineering from Carnegie Mellon University in 1995. I then went on to get my master's in bioengineering and biomechanical engineering from the University of Pittsburgh in 2002. And then I went to get my doctorate or my PhD in bioengineering and biomechanics from the University of Pittsburgh in 2004.
Doctor, do you specialize in research and analysis to evaluate specifically the study of the relationships between crash injuries and crash forces?
I do, yes, sir.
And when I say crash injuries, we're talking about to human beings.
That's right. Injuries to human beings, whether it be in a crash, motor vehicle accident, slip and fall, industrial, any type of setting where there's an injury to the human body. I evaluate basically that event and the mechanisms responsible for producing those types of injuries.
Doctor, does it also include the study of and understanding of human kinematics?
It does, yes.
As well as human tolerances?
Yes, sir.
We all know what tolerances mean. What does kinematics mean?
So kinematics is really just the motion of the human body, and it's the study of the human body, how the body moves under different circumstances, whether you're in a car that's struck from behind, what direction will your body move, slip and fall, how will your body rotate and move. It's really looking at the motion and the response of the body.
Are you certified by any professional associations?
I have a PhD. There's no professional licensure for biomechanical engineering. PhD is the highest basically certification you can get. And I'm also a member of SAE, Society of Automotive Engineers, as well as the American Society for Mechanical Engineers.
Have you received additional training and education in further beyond your PhD and the associations that we just talked about?
I have, yes, sir.
Can you describe, without going through all the detail, describe the kind of continuing education that you engage in?
Well, I attend seminars and in professional classes with respect to biomechanics as well as accident reconstruction, but looking at new technology and research with respect to injuries. For instance, motor vehicle accidents, if there's new safety measures such as airbags, seatbelt pretensioners, auto detection devices on vehicles. So really kind of staying up to date with the current research and literature that's out there.
So your specialty, your subfield, if you will, in terms of your engineering degree and education is literally in accident reconstruction and the effect that accidents and incidents can have on the human body. Is that right?
It is, yes. And biomechanics is really, it's looking at injury to the human body. So, we use traditional engineering principles and apply it to the body because an injury is just an engineering problem. Instead of looking at a piece of steel that if you know the dimensions and size and you apply a force, it'll bend and break. We look at the human body. How much force does it take and how does the force have to be applied to get a humerus fracture or intervertebral disc injury or any type of injury? There's specific forces and mechanisms you need to produce those injuries. And that's what I do as a biomechanical engineer.
Is there a difference between a biomechanical engineer and a doctor?
There is, yes.
In terms of injuries?
Yes.
Tell us about that.
So we really approach injuries from two different directions. Someone has an injury, you go to the doctor, you go to the hospital, the medical doctor will diagnose that injury, determine the best way to treat it, and determine what the prognosis is. As a biomechanical engineer, I look at that injury from a different direction. Here's the injury. Well, how did that injury occur? What type of loading did you need to actually produce that injury? How much force was required? What happened to your body to actually cause that injury to occur? So we approach it really kind of from two different areas. And certainly the doctors diagnose the injuries and determine what they are, and then the biomechanical engineer will come in and we'll look at that injury. And not only how's it produced, but ultimately our hope is to mitigate and prevent injuries from occurring, whether in motor vehicle accidents, sports settings, industrial settings, and anywhere there's an interaction with the body and the environment, we want to try and make it safer for individuals.
So you're not diagnosing an injury as much as you are trying to figure out the mechanics and the forces behind the injury. Is that right?
That's right. I'm not a medical doctor. I wouldn't diagnose an injury, but given an injury, I understand the mechanics of how that injury is produced and what you need to actually cause that injury to happen.
Are you also published in the field of biomechanics and or engineering?
I am, yes, sir.
Can you describe that?
When I did my graduate work at the University of Pittsburgh, I worked at a place called the Human Engineering Research Lab, and it was associated with the VA in Pittsburgh as well as the University of Pittsburgh. And so we looked at people with disabilities. Well, one of the big things that we did, or one of the major points, was people in wheelchairs. So if you have to propel a manual wheelchair, you put a lot of stress and force on the arm, the shoulder, the elbow, the hands, carpal tunnel. So we look at the injuries that are produced during those types of events. How can we reduce the force acting on the body for someone like that? So it's looking at, again, how the body responds, how we can set up a chair differently to actually reduce the amount of force someone might experience doing that type of an activity.
Have you qualified as an expert in the past in the area of biomechanical engineering and human factors?
I have, yes.
In furtherance of, let me ask it this way. Were you asked to engage in an analysis, ARCCA, to be engaged in an analysis of the incident that is currently before the court?
I was, yes, sir.
Did you produce, or did your team produce a report about your opinions and conclusions, including the testing and methodology that were behind those opinions and conclusions?
We did, yes.
You were not hired by the defense in this case, correct?
No, we were not.
You were not hired by the Commonwealth in this case.
That's correct. We were not.
When you started your analysis, you didn't know who we were. You did not know who the Commonwealth was.
That's correct.
You never heard of Jeremy case.
I had not, no, sir.
You were contacted by my office after you provided your report, correct?
That is correct, yes.
Were you ever contacted by the Commonwealth?
Not that I'm aware of, no, sir.
And you and I never discussed the substance of your testimony, correct?
That's correct. We have not.
Would you consider that your analyses, your conclusions, and opinions in this case are completely independent of any party in this room?
Objection.
Sustained.
You've not been paid by the defense, is that right?
I have not, no, sir.
and you do not answer to us in any way.
I do not. That's correct.
You indicated that you and your team were asked to undertake a review of the circumstances. What exactly did you review in coming to your opinions and conclusions and performing the tests that you performed?
What we looked at, there was police reports with respect to the incident, medical records for Mr. O'Keefe, as well as the autopsy report, photographs of the evidence in this case involving the Lexus, the tail light, the incident scene where the evidence was found, as well as some other documentation.
And you also worked with Dr. Wolfe, who just left the courtroom, correct?
I did, yes.
Did you two have sort of a distinct role in, although working as a team, a distinct role in making determinations and conclusions about the incident?
That we did. There was a distinction. Certainly some of our work overlapped, but there was a distinction with what each of us actually did and performed with respect to this case.
Following your review and your investigation and analysis, did you make any determination as to whether any of the injuries suffered by Mr. O'Keefe in this case were consistent with producing the damage that was seen on the SUV?
I did, yes, sir.
What did you base your opinion on?
My opinion was based on certainly the medical records, the description of what the injuries were, the damage that we have to the Lexus, primarily the right rear tail light cover, as well as we performed testing to evaluate the strength of that tail light cover and look at the damage associated with different types of impacts. And also to look at the overall evidence of where everything was found, where Mr. O'Keefe was found, what the injuries were, how they may or may not have occurred based on the damage we have to the vehicle.
So did you look specifically to find whether or not you could determine the forces required for Mr. O'Keefe to suffer the injuries that you saw in the records, medical records, et cetera?
I did, yes. I determined in my analysis whether there was sufficient force with that damaged taillight and interaction with that taillight to produce any of the injuries that were listed or diagnosed in the autopsy report and the medical records.
What, generally speaking, what injuries would you expect to see in a vehicle-pedestrian interaction at, say, 24 miles per hour?
Objection.
I'll allow that. Just generally, Dr. Figueroa, please.
Yes, Your Honor. So 24 miles an hour, once you get up to that speed, you start to see fractures. You see significant ligament and tendon damage. I mean, usually about 15 miles an hour, 15 mile an hour impact is where you start to see damage to, for instance, the leg and the knee. At that speed, you're going to produce, if you impact the vehicle, you're going to produce upwards of 1,000 pounds of force on the body, depending on what part of your body impacts the vehicle. So certainly at 25 miles an hour, you start to see significant injuries occur.
Is that true for any part of the body that is struck, whether it's center mass or extremity? 1,000 pounds of force because of the speed of the vehicle?
Well, force is equal, Newton's second law, force is equal to mass times acceleration. So the acceleration is going to be the same. It depends on the mass of whatever body part's being hit. So from the testing that we did at 15 miles an hour, we used a head form, which weighs about 11 pounds. And that produced almost 1,000 pounds of force, a little under that for the head. So anything that weighs 11 pounds is going to produce almost 1,000 pounds of force. The heavier the object, if you get hit center mass, that's going to be even greater force because that's more mass than just 11 pounds. So the acceleration is the same for each body part. It just depends on the weight of the body part and how heavy it is to determine the force that's actually exerted on the body.
Did you review, in furtherance of your conclusions and opinions, did you review records that indicated injuries to both a head as well as an arm, right extremity, right arm?
I did, yes, sir.
Taking those one at a time, is the injury to the head that you saw consistent with having been struck by a vehicle at 24 miles per hour?
It is not, no, sir.
Can you explain why that is?
There's a couple of reasons. First of all, and the main reason is that to get the injury, it was a fracture at the occipital region of the head, which is basically on the back bottom part of the head. So in order to have that part of the head contacted by the tail light, you would somehow have to have a configuration or be standing in a manner that the rest of your body doesn't get hit because there's no other significant injuries to the body. If there's enough force to cause a skull fracture, then there's going to be certainly enough force to cause injury to the rest of the body. So first of all, you have to determine how could you configure somebody could actually be standing to have only the head impacted, the back of the head. And even if that was the case, if somebody positioned themselves in such a manner to have that occur, you're still going to see other injuries related to that. For instance, with the cervical spine, over 1,000 pounds of force acting on the head, you're going to get significant cervical injuries, fractures, disc injuries, tendon and ligament injuries. So the fact that we only have that head injury and only damage to the occipital portion of the skull is inconsistent in this case with being struck by that tail light. And then there's also the evidence that we saw when we did the testing. At 15 miles an hour, where we dropped the head form, so that would be akin or like a vehicle backing up at 15 miles an hour hitting the head, we had more damage to the tail light in that test than what we saw with the subject tail light cover. So if you're going 24 or 25 miles an hour, even faster, you're going to see even greater damage, greater fracturing of that rear tail light. And we just don't have that in this case. So both the physical evidence as well as looking at the biomechanical aspects of it are inconsistent with that head injury occurring due to impact with the rear of the Lexus.
Shifting to the arm, are the same forces at play if instead of the head making contact with the taillight, it's an outstretched arm, for instance, at the elbow area of a human being, a person 73 inches tall weighing 215 pounds?
Objection.
The objection sustained. Ask me differently.
Sure. Shifting to the arm, are the same forces at play if instead of making contact with the head, you make contact with an arm, an outstretched arm?
They are. I just explained the force is mass times acceleration. So if the arm weighs the same as the head, you're still going to get that same force, almost 1,000 pounds.
Does the arm weigh the same as the head?
It does, actually, almost identical, because your arm, just one of your arms, including the hand, forearm, and upper arm, is about 5% of your total body weight. So for someone who weighs 216 pounds, that comes out to about 10.8 pounds. So your arm, basically your whole arm, is about the same, weighs the same as your head.
So is your analysis the same then? If the arm, close to an 11-pound arm, made contact with the taillight traveling at 24 miles an hour, at 15 miles an hour, would you expect even more damage to the taillight at a higher speed?
Objection.
Allow it. Watch the leading.
Yes, you would. If it's higher than 15 miles an hour and you have an arm actually striking that taillight, you're going to get even more significant fracturing, more damage to that taillight at a higher speed than what we saw.
So was the taillight damage consistent or inconsistent with striking an arm?
Our findings was it's inconsistent for a number of reasons, but it's inconsistent with striking the arm. Yes, sir.
Okay. I want to shift back to the head injury that you saw. Was the head injury that you saw consistent with falling backward in a standing position onto a rigid surface?
That's certainly one of the possible scenarios. That would create the injury mechanism. You fall backwards, strike your head on concrete. That can produce thousands of pounds of force on the head. And so that's certainly a scenario where you could produce that damage. If someone was standing, they fell backwards and struck their head on the roadway or on the curb or a hard surface.
So I was going to ask, you think you may just answer my question, those kinds of force multipliers require a hard and rigid surface or not?
They do, yes, sir.
So grass and dirt would not produce the same sort of force?
Grass and dirt, no, that would certainly not produce the same amount of force as hitting your head on concrete.
And if it was grass and dirt with a little bit of snow on the top of it, what effect is that?
That's going to dampen and lessen the force even more so.
What injuries, I want to shift back to the arm. I know I'm going back and forth, but bear with me. Talking about the arm, if presuming a strike at, say, 24 miles an hour on just the arm, what kind of damage would you expect to see on the arm, irrespective of the vehicle?
You're going to see significant damage on the arm, especially if it hits at that taillight. Enough force to actually cause fracture of that taillight, that force is going to be concentrated at an initial point. And you're going to see at that point, you're going to see probably the most damage to the arm and to the skin there. So remember, at 15 miles an hour, that's about almost 1,000 pounds. So 24, 25, it's even greater. So that amount of force on the arm, certainly you're going to see extensive subcutaneous lacerations, bruising, contusions. You're going to see most likely fracture of the arm as well. You're going to see significant damage. Just imagine having your arm out and being struck by a car at 25 miles an hour. There's going to be significant damage, more so compared to simply the abrasions that were diagnosed and documented on the arm in this case.
You did look at multiple photographs of the arm in this case, of the John O'Keefe's arm in this case, right?
I did, yes, sir.
All right. Were the injuries that you saw on John O'Keefe's right arm consistent with having been struck by a vehicle in the manner that you just described?
Objection.
That's the same, Mr. Jackson.
You reviewed injuries specific to John O'Keefe, correct?
I did, yes.
Taking that as a hypothetical, would the injuries that you saw, generally speaking, hypothetically be consistent or inconsistent with having been struck by a car at 24 miles an hour?
Objection.
Sustained.
May we approach?
Yes.
If you were to presume, for purposes of my question, that an arm was struck by a vehicle, taillight traveling at 24 miles an hour or thereabouts, would you expect to see patterned abrasions with no bruising?
Objection.
Or just, what would you expect to see?
What would you expect to see?
So again, I would expect to see significant trauma to the skin, to the bone, to the tendons. I wouldn't expect to see just abrasions, pattern abrasions. I mean, abrasion by very definition means that it's trauma to the skin, which is created through rubbing or grinding or friction. So it's basically something rubbing against the skin that basically wears away that top layer of skin. It's not blunt force trauma. If you have blunt force trauma, that produces a contusion or a bruising. It's not a laceration type injury where you have a cutting injury that actually produces a cut or a significant laceration. It's really just rubbing along the skin. So that would be inconsistent. If you have an arm that's actually struck at 25 miles an hour, you're going to have significantly greater damage, especially if there's a taillight that shatters. So you have the taillight coming in, it's hitting the arm, and it's moving forward into the arm. So if that actually caused fracturing of the taillight, then parts of that taillight are going to be pushed into the arm and likely embedded into the arm as the vehicle continues forward and pushes the arm out of the way. I didn't see any of that. Basically just superficial abrasions, which all appear to have a similar amount of force. There's not a difference. That's the other thing. If you had a taillight shatter and explode on an arm, you would have some areas where you would have very deep contusions or lacerations, others lighter areas. But when you look at the abrasions that were noted in this case, they all appear to be of the same force, generally the same direction, and the same severity, which would be inconsistent, in my opinion, with being struck at 25 miles an hour.
Generally speaking, do you look for consistency in size of an object striking a body and the injury that the body suffers from being struck by the object?
Absolutely. Yeah. I mean, size is a big part of it, certainly. Yes.
So did you do any measurements of the size of the taillight, the width of the taillight that was shattered?
Yes.
And what was that width, if you can recall?
I think the width we looked at was maybe 6 inches or so.
In review of your, in coming to your opinions and conclusions, did you look at the arm of John O'Keefe just sort of laid out, straight out?
I did, yes, sir.
Did you see where the injury started and stopped, or began and ended, however you want to put it? in terms of size?
Yes, I mean, it started from the upper arm and then extended down into the forearm, which was greater than 12 inches of length, where you see those injuries and those abrasions occur.
Did you come to any conclusions or opinions concerning the size differential between the taillight and the injuries that you see?
Objection.
Sustained.
Generally speaking, would you expect if there was an injuring event that the size of the injury would be consistent with the thing that produced the injury?
Yes, generally speaking, you would certainly expect that. And again, you would normally and usually be able to see an initial point of contact, because that's where the most force is going to occur, where it causes that taillight to break. So you would have an area of severe damage, and then it would extend out likely to the edges of where it would contact the rest of the taillight.
From a biomechanics and or a physics standpoint, engineering standpoint, is it reasonable if someone is standing with their arm extended to be hit by a moving vehicle at say 25 miles an hour and the center mass of the body to be projected?
Objection.
Ask it differently.
Is it consistent in your view with engineering principles and physics principles that you know if an arm is hit, extended, not the body, just the arm is struck, for the body then to be projected?
Objection.
I'll allow that.
It's not, no. So if we have contact, your arm's down, we have contact to the arm. I mean, first of all, it's a ball and socket joint, so the arm can move independently of the rest of the body. So with enough force, even if you're contracting your arm and trying to hold it out as tight as possible, it's going to overcome that muscular contraction and basically just move the arm. But secondly, it all depends on your center of mass. The center of mass is kind of the equilibrium point of your body, of where your weight's distributed. And for most normal people, the center of mass occurs at your umbilicus or your belly button. So wherever your belly button goes, that's where your body's going to move. They teach this to football players, right? If you're a defensive back and the running back comes around the corner and it's you against him, they tell them, or they teach them, to watch the waist and watch the belly button. It doesn't matter what your head or your arms do or what their feet do. Wherever their belly button goes, that's where they're going to go. So that's what you want to tackle. So even if you had your arm straight out, again, we said it would move because of the joint. But let's assume you had a metal pole sticking out of your arm, out of your body instead of your arm, and that metal pole gets hit. What's going to happen to your body? It's just going to spin around, right? Because it's producing a moment arm, which produces a torque on the body. So your body's going to basically spin. In order to get the body, the complete body, over, for instance, 10, 20, 30 feet into the yard, you need a force acting at the center of mass. You need an external force pushing the body that way. And that's not going to happen if you just hit the arm. It's not enough force. It's not the right mechanism to actually cause the body to somehow move that far over.
Assuming that a body was struck with enough force at center mass to project that body 20, 30 feet, what injuries would you expect to be produced on that body?
Objection.
Sustained.
If you did have a body that was projected a distance, what injuries from a car, what injuries would you expect to see on the body?
Objection.
I'm going to see you at sidebar the last time on this.
May I know?
Yes.
Doctor, do you have my question in mind? You need me to repeat it?
Maybe repeat it, yeah.
Easy for you to say. Assuming that a body was struck at center mass with enough force from a vehicle traveling at whatever speed to project the body off the ground, would you expect to find injuries on that body?
You would, and you would actually see that there's specific injuries, because let's say you're standing forward and you get hit on the right side with a vehicle. You're going to get injuries and damage to the right side of the vehicle as that vehicle impacts you. It depends on the profile of the vehicle, how high the hood comes up, whether you're going to wrap up onto the hood, or if it's a van or the back of an SUV, it will project or push your entire body to the left. So you're going to get initial contact and injuries to the right side of your body. And then if it propels you into the air, you're going to get airborne, and then you're going to contact the ground, usually with the left side of your body. So then we're going to see a correlation of injuries to the left side of your body as it slams down onto the ground as well. And at those speeds, normally you would also see more abrasions, greater abrasions or road rash along the entire part of the body, as your body then would slide until it came to the point of rest.
And you did not see that in this case.
Objection.
May I have a moment?
Yes.
Thank you, Your Honor.
Mr. Lally?
Good afternoon, sir.
Good afternoon.
Now, you, in conjunction with the other doctors on your team that conducted the analysis and testing in this case, you wrote a report, is that right?
We did, yes, sir.
And that report, excuse me, was issued on February 12th, 2024, is that correct?
I believe that's correct, yes.
And within the first paragraph of that report, the last two sentences state, this analysis is based on information currently available to ARCCA and is only to be only to be issued in its entirety. However, ARCCA reserves the right to supplement or revise this report if additional information becomes available. Is that correct?
I believe that's correct, yes, sir.
Now, the information that you received and that you reviewed either individually or as a team, that included some state police reports, is that correct?
Yes, sir.
Some Canton Police Department reports, correct?
Yes,
Some scene photos, is that correct?
that's correct, yes.
Medical examiner dispatch removal report, is that right?
I believe so, yes, sir.
Some videos from the location of 34 Fairview Road, is that right?
Yes, sir.
Some photographs of the defendant's vehicle, the 2021 Lexus LX 570, is that correct?
Yes, sir.
Photographs of evidence that was recovered from the scene, is that correct?
That's correct, yes.
CDR reports from the defendant's Lexus.
Yes, sir.
And then essentially there were some other materials, whether they be literature or other things that you and your team of other doctors reviewed over the course of formulating your opinions in this case, correct?
That's correct, yes, sir.
Now, in regard to evidentiary materials that indicates within the report that were reviewed, you talk about the lens cap to the taillight assembly photographs of that nature, and then there's a mention of a black straw that was found on scene, correct?
Yes, sir.
There's no mention in the report of either Mr. O'Keefe's shoe or his hat, correct?
Yes.
Doctor, are you familiar with a term called compression abrasions?
Compression abrasions? Yes.
And am I correct when I say compression abrasions are essentially when direct pressure from a blunt object together with slight rubbing movements produce skin and epidermal crushing? Is that what your understanding of the term is?
Yes, sir.
And you're familiar with patterned abrasions?
I am, yes.
And pattern abrasions are injuries that show a distinct pattern that may reflect the shape of the impacting blunt objects that you may see with reference to injuries that are left by that blunt object. Is that correct?
That's correct, yes, sir.
Now, as far as in general terms, from what you reviewed, at any point in time did you look at a state police reconstruction report?
I don't believe that I did, no, sir.
You weren't provided with that, is that correct?
That's correct, I don't believe so.
You weren't provided with any sort of forensic reports, DNA or anything like that, is that correct?
I don't believe so, no, sir.
And you never actually looked at the physical car, is that correct?
I did not, that's correct.
And you're aware that the physical car, being the defendant's car, is still in law enforcement custody and available for inspection if you had wanted to? Are you aware of that?
I think I'm aware of that, yes, sir.
You never made that request, is that correct?
That was not necessary in this case to inspect the vehicle.
But it's necessary not, you didn't make that request, correct?
I don't remember if we made that request or not. We obviously didn't look at the vehicle, but it wasn't necessary in this case.
Did you ever look at the actual taillight pieces or the taillight housing, is that correct?
Not the actual, we looked at photographs of the evidence, yes.
Now, the injuries that you observed or reviewed in materials in regard to Mr. O'Keefe were primarily on the right side of his body, is that correct?
Well, sir, on the right arm and the posterior aspect of the right arm, yes. And then the skull fracture was a little bit to the right, the occipital fracture. Right.
Also bruising on his right hand, is that correct?
There was bruising on the back of his right hand, yes.
The dorsal aspect?
Yes, correct.
And there was also bruising on sort of the posterior of his right knee, is that correct?
There was a small bruise, I believe, yes, sir.
With respect to within your report, you talk about the numerous linear abrasions on the posterior of Mr. O'Keefe's right arm and forearm, correct?
Yes, sir.
And in relation to those injuries, there's a sentence in which you or whoever authored this part of the report, assuming it's you, indicate that furthermore, any such injuries would be highly improbable if Mr. O'Keefe was wearing a jacket, correct?
Yes, sir.
Are you aware that Mr. O'Keefe was not wearing a jacket other than a long sleeve sort of hooded shirt?
I believe that came to light afterwards. Again, it doesn't affect my actual opinions in this case, but it was a sentence added in there, yes, sir.
And so also within your report, same paragraph, you indicate blood and DNA transfer would also be highly probable under such circumstances, none of which were reportedly found on the tail lamp assembly or any of the fractured pieces, correct?
Correct.
Are you aware that DNA consistent with that of Mr. O'Keefe was actually found on the tail light housing from the defendant's vehicle?
I'm aware after we wrote or issued the report that it became known to us that I believe DNA was tested and some DNA was found, I believe a small amount. I don't believe any blood evidence was located or found on any pieces, but there was indication of DNA on the taillight housing.
There was also DNA matching Mr. O'Keefe that was found on the exterior of a piece of drinking glass that was found right near his body.
I believe so, yes, sir.
And there was also pieces of approximately 16th of an inch by 16th of an inch of clear and red plastic that was subsequently found to be consistent with the defendant's taillight that was found embedded within Mr. O'Keefe's shirt.
Within the shirt, I believe, yes, sir. Not his actual body.
And so this is all things that you found out after you issued your report in February of 2024, correct?
That's correct, yes, sir.
Now, when you were talking about the injuries to the back of the head of Mr. O'Keefe, consistent with coming in contact with a hard surface, correct?
Yes, sir.
Would that hard surface include if the ground was frozen?
Well, you'd have to perform an analysis actually, because you'd have to determine how hard that ground was. You'd have to look at the freeze and thaw cycle, probably leading up to weeks of that. You can't just look at ground and say, well, it's below freezing, so that ground must be frozen. I mean, is it a possibility? It may be, but you have to go through an actual analysis and procedure to determine how hard that ground is and whether it could have produced those injuries.
So it is something that's capable of being done by you, is that correct?
Performing that type of an analysis? You could go through and do it, sure, yeah.
But you didn't do it, correct?
No, I did not do it, no, because yeah, there's no need in this case. We don't know what happened in this case. There's no indication of, certainly it's not consistent with getting hit by the car and ending up where he did, even if the ground is somehow hard enough to cause that type of an injury. Again, there's no movement and no force to get his body over there, and the damage with the car is inconsistent with him being struck by it. So whether the ground could cause it or not, the roadway could cause it, the curb could cause it, a back could cause it. There's numerous different possibilities, and we don't really have enough evidence in this case to determine what one specific event actually caused that injury.
You didn't have enough evidence based on what you were provided, isn't that fair to say?
I didn't have enough evidence based on what I was provided, and even looking at the additional evidence that I became aware of after the fact, there's still no evidence. I mean, you can't deny the science and the physics as to what would have happened if he was struck by the vehicle. So anything past that, you have to somehow overcome that hurdle, which is very difficult to do.
When was it that you looked at this additional material, and who provided it to you?
We were informed after a report was issued that DNA was found, and that was really the primary issue. I believe that some DNA was found on the housing, which again, there's numerous explanations or ways that DNA can get on a light housing.
Let me ask you this, sir. With regard to the materials that you were provided with, was there anything in there that stated that Mr. O'Keefe's skull fracture on the back of his head was caused by contact with the taillight?
No, I don't believe there was anything in those materials that stated
Was there anything in those materials that indicated, or that anyone stated at any point in time that Mr. O'Keefe's arm was outstretched at the time that he was struck by the vehicle?
No, sir, there wasn't.
Was there anything in there indicating that his arm was tucked in at the time that he was struck by the vehicle?
There's no indication in any of that evidence of what he may or may not have been doing, how he may or may not have been positioned. I mean, that's the whole issue. There's no evidence to indicate what may have allegedly occurred in this case.
Now, a typical pedestrian collision that you see through the course of your work involves a pedestrian being struck by the front of a vehicle. Is that fair to say?
No, I see all types of different people getting run over backwards, cars spinning, hitting sideways, frontal impacts certainly occur, yes, but we see pedestrians getting struck by all parts of the vehicle.
I'm sure you see all kinds. What I'm asking is predominantly when you see a pedestrian collision, the typical pedestrian collision would be a pedestrian crossing a road in front of a vehicle as it's approaching. Is that correct?
That's certainly not uncommon, yes, sir.
Now, as far as, I believe you described a little bit on your direct testimony, as far as there's differences in the type of injuries that you would expect or anticipate depending on how the vehicle interacted with the pedestrian in a pedestrian collision, correct?
Yes, sir.
And as far as you're familiar with what's called the sideswipe collision?
Yes, sir, I am.
And am I correct when I say that in a typical pedestrian collision with pedestrian crossing in front of a vehicle, there are a number of different types of interactions as far as a rapid and forward projection versus a fender ball versus a number of different ways that a pedestrian can interact with the front of a vehicle, correct?
It depends on the position of the pedestrian and certainly the profile of that vehicle and the speed of the vehicle. Yes, sir. There's many different factors involved in it.
And so in a typical pedestrian collision, when a pedestrian is struck by the front of the vehicle, that involves more of an assumption of the velocity of the striking motor vehicle by the pedestrian than you would expect to see in a sideswipe collision, correct?
Well, I mean, yes, generally speaking, a sideswipe means that the person or the pedestrian in the vehicle don't obtain a similar or common velocity. So if you're standing in front of a car and it hits you, it's going to speed you up to that same speed and then disengage. The sideswipe means that there's not this mass-to-mass impact. By its very nature, sideswipe has minimal forces. We see it even between vehicles that just rub against each other. So if there's a sideswipe impact with a pedestrian in a vehicle, there's going to be very little damage to the pedestrian. And similarly, there's going to be very little movement. There's really no force at all acting. You know, for instance, if a car came and swiped by your arm, but didn't have enough force or enough contact to cause any damage, well, it wouldn't actually cause any movement of the person either. So a sideswipe by its very nature involves minimal impact, minimal forces, minimal velocities.
Also contained with in the reports that you at least co-authored, there's an indication that Mr. O'Keefe's injuries, at least to his skull, the fractures to his skull, are consistent with him having been pushed or possibly even impacted by the subject Lexus and fallen backwards, striking his head. Isn't that correct?
Yeah, so that's another possibility.
Sorry, sir, yes or no?
No, let him answer. Let him answer the question.
So if we're saying that there's enough force if you fall backwards to strike your head and cause that skull fracture, well, he could have slipped and struck his head. The car could have backed up and not known that he was there and nudged him and caused him to fall. I mean, any event that would cause him to fall backwards obviously would result in him striking his head. So there's numerous, almost infinite possibility of different scenarios that could result in that type of an event.
Thanks.
Mr. Jackson? Okay, Dr. Rentschler, you are all set, sir.
Thank you, Your Honor.
Okay, jurors, I want to see counsel for the last time at sidebar right now.
Look the other way. Look the other way. 4 words that sum up the Commonwealth's entire case. 4 words that sum up the hopes of those who have tried to deceive you. Conflicts of interest, doesn't matter. Just look the other way. Magic hairs, magic glass, look the other way. Late night calls and Google searches, falsified affidavits, inverted videos, and butt dials galore. Just look the other way. That's what they want. That's what they're counting on, but the uncontrovertible fact is you have been lied to in this courtroom. And your job is to make sure you don't ever, ever look the other way. Your singular duty is to stare down the evidence and do it unflinchingly and do it unwaveringly. You see, you're the only thing standing between Kieran Reed and the tyranny of injustice. It's a job you didn't ask for, probably a job you didn't want. But it's the greatest responsibility we have as citizens here in America. Lest the government stop answering to us and we start answering to the government. And woe betide any one of us who might find ourselves in the crosshairs of a Michael Proctor. Preparing for today, I was reminded of a quote. It's a quote about the truth, and I want to share it with you. It is of great importance to set a resolution never to tell an untruth. There is no vice so mean, so pitiful, so contemptible, and those who permit themselves to tell a lie once find it much easier to do it a second time and a third. This falsehood of the tongue leads to that of the heart, and in time, it depraves all its good dispositions. What does that mean? It means that it's been observed that to tell an untruth, to exaggerate, to make a false claim, it's a cancer. One lie begets another, and it's a malignancy that grows over time. And that, folks, is how a cover-up is born. That's how a Massachusetts state trooper says in whispered tones to his friends when he thought no one was looking or listening, how he would make a case, how he would make it cut and dry, no matter the truth, how he would make sure to put, quote, serious charges on the girl. In other words, pin it on the girl. You may ask yourself, how does this happen? How could this happen? It's 2024. Surely people aren't going to come to this courtroom, this hall of justice, and lie to us, just give us false information. They wouldn't do that. They wouldn't try to cover up the truth. The Alberts, the McCabe's, Higgins, Lank, Michael Proctor, Yuri Buchanan, Brian Tully. You don't have to wonder if they would lie to support their narrative. You need only wonder how many times they did lie. Over and over and over. They and others were caught deceiving you. Big things, small things. It didn't really matter. They feared nothing. They'll look you in the eye and deny phone calls. They'll deny secret meetings. They'll claim that calls are butt dials and butt dials are answered. They'll show you a video and tell you left is right and right is left. They'll magically turn 3 pieces of plastic into 5 right before your eyes. And even when they're caught with their own lies, they won't blink, they don't sweat. They'll just look you in the eye and demand, pay no attention. You folks look the other way. Ladies and gentlemen, there was a cover-up in this case, plain and simple. You'll surely say to yourself, I don't want to believe it. I don't want to believe that could happen in our community. But sadly, over the past 8 weeks, you've seen it right before your eyes. So how does a cover-up happen? How could that happen? Well, let's count the ways, shall we? Handpick your investigator. Make sure it's someone we know, someone on our side. Keep him close. Offer him help. Offer him a gift. Have secret friends and family meetings. Get your story straight. Delete your call history. Make mysterious phone calls at 2:22 a.m. Delete Google searches. Monitor police activity. Get rid of evidence. Get rid of your dog. Destroy your phones. Destroy your SIM card. For the investigator, decide on a narrative early on. Don't go to the crime scene. Don't take witnesses in for questioning. Question all the witnesses together. Ignore witnesses who don't fit your narrative. Allow friends and family to contact those same witnesses. Don't record interviews. Write vague and false police reports. Omit witnesses' names. Omit witnesses' interviews altogether. Don't photograph the evidence. Don't conduct any forensics. Don't document the evidence. Don't document the logs. Don't create any logs whatsoever, and don't maintain a chain of custody. Keep all the evidence in the hands of one person, and then manipulate that evidence, including videos. Don't turn over videos. Invert videos. Turn 4:16 p.m. into 5:30 p.m. in affidavits. Turn 3 pieces of taillight into 5 pieces of taillight. Delete 42 minutes of surveillance footage. Hide personal relationships. Make this case cut and dry, and ensure the homeowner, quote, never sees any shit because he's a Boston cop. But most importantly, pick your patsy and pin it on the girl. It's not that it could happen. It's that every single one of those things I just mentioned did happen right in front of you. But this sort of injustice can't happen in a vacuum. So what about the prosecution? What about the Commonwealth? What does it look like when the government picks a narrative and then tries to form a prosecution around the narrative instead of the other way around? Looks a lot like this. If you don't have actual evidence, just throw every single thing you can against the wall to see what sticks. Drag her through the mud and make sure you attack her character. And that's what you saw in this case. The Commonwealth spent much of their time and resources trying to vilify Karen Read. They desperately resorted to calling witnesses to talk about Karen Read and John O'Keefe's arguments. They even stooped so low as to call the children and put them through this ordeal. All to say that John sometimes got upset because Karen was too kind, too nice, spoiled them too much. Their arguments illustrated what anybody could imagine is a normal set of ups and downs for any couple. Even on January 28th, they talked it out, they communicated, they worked out their issues, and they had a nice, affectionate evening out with their friends. And you don't have to take my word for it. Pull the tape, as they say. Look at the videos. C.F. McCarthy, Waterfall. What are the words that every single person who testified in this case used about Karen Read and John O'Keefe that night? Getting along, no issues, good mood, happy, affectionate, even lovey-dovey. No issues, no toxicity. They were a loving couple right up into the time Karen Read dropped him off and he walked into 34 Fairview. If an argument with a loved one is a motive for murder, folks, we're all in trouble. Speaking of which, what is the evidence that John went into the house? The Commonwealth will tell you, undoubtedly, no, he never went in the house. And they'll point to certain witnesses who they say didn't see him go in. Well, the question you have to ask yourself is, can you rely on that? First, these are all people who are related to or committed to the Alberts in some way or another. That all-powerful Kenton family, it's easy to say, I didn't see something, because how can that really be challenged? Some actually may not have seen John walk into the house. They were in the kitchen, as you recall, from Nicole. Third, at least one witness, Brian Higgins, forgot his narrative, at least for a second, and he admitted a man did, in fact, come into the house, and when he was caught and asked to describe that man, he had to. It was a little bit vague. You remember what he said. He was tall, with dark hair. That was a telling slip of the tongue by Brian Higgins. But what's the real evidence of the unbiased data, the data that's not connected to the Albert family? How about John's Apple Health data? It shows that at 12:21 a.m., an important time, John arrived. That's established by the monotonic time clock that you heard about in this trial. It was on his phone, and that represents a huge problem for the Commonwealth. It shows that he took 80 steps and ascended or descended 3 flights of stairs at that time. And that makes perfect sense, doesn't it? It matches. Walks into the house, goes directly to the basement. There's your 80 steps and your descending flights of stairs. The big problem for the Commonwealth is he wasn't outside at the car ascending and descending stairs, wasn't climbing on top of the car. So they'll tell you, wait, don't look at the Apple Health data. Look at this other thing called Waze. But Rick Green explained that if you apply the 3-minute offset that is built into that monatomic time, it aligns perfectly. They don't want you to see that. They don't want you to pay attention. They want you to look the other way. But even more importantly, at approximately 12:32 a.m., someone holding John's phone takes another 36 steps and travels 25 meters. Why is that so important? Because by 12:32 a.m., Karen Read was gone. She had already left the location. She left at 12:30. Trooper Garino told you that Karen Read's phone connected to John's Wi-Fi at what time? 12:36. It is undisputed in this case that it's a 6-minute drive on a good day from 34 Fairview over to One Meadows. She was gone by 12:30, and John's phone was taking 36 steps and logging 25 meters at 12:32 after she left. So don't be fooled. John walked into that house, after which Karen drove away, and the scientific data all prove it. But also, Ryan Nagel and Heather Maxson prove it. In addition to the Apple Health data, Ryan and Heather both independently testified that they passed Karen's SUV as they drove away after talking to Julie, and Karen was alone in the SUV. John was not with her. He wasn't in the car. He wasn't standing outside the car. He wasn't sitting beside the car. He wasn't laying on the ground beside the car. He was nowhere in sight. There's only one other place that John could have been, and that's in the house. Exactly where the Apple Health data places him. So it all fits. And Ryan was right behind her, remember, staring at her taillights, undamaged, brightly lit. That brings up another difficulty for the Commonwealth, and that's their star witness, Jennifer McCabe. You'll recall that Jennifer McCabe claimed that she was looking out the door, staring at that SUV over and over and over again from 12:29 to 12:50. She was very specific about that time frame. But we know that the SUV was gone from 34 Fairview by about 12:30. Had to be in order to connect to the Wi-Fi at 12:36. So unequivocally, Jennifer McCabe was lying about watching that SUV, and it makes you wonder why. And to add to that deceit, she was also blatantly lying about the calls to John's phone. You remember that calling me back and forth. She said that every single one of those calls to John's phone during that time was a butt dial. How are those lies connected? And why are they connected? Jennifer McCabe knows. Was she butt dialing John over and over? Or was someone looking for John's phone that went missing? Let's talk for a second about what actually happened in the time leading up to everyone going to 34 Fairview. Brian Albert, Brian Higgins show up drunk at the waterfall. They've been drinking in the afternoon. You know about the flirtatious texts that were sent between Karen Reed and Brian. Higgins was clearly pining over Karen, but for her, the flirtation had ran its course. It was done. She was happy and committed to John. You can see that in her actions with John that night. You don't have to guess. Brian Higgins, however, you can see in his actions, he wasn't quite so satisfied and he wasn't done. His text message, well, meaning, what the hell, Karen? What about me? Seemed aggressive, seemed annoyed. He didn't like being ignored. That was pretty clear. So he's 5 or 6 whiskeys deep into the night by this time, and she continued to ignore him. Then oddly, Higgins, who doesn't know John all that well, seems to want to coax John to 34 Fairview. I'll draw your attention to the waterfall tape if you want to take another look at it. It's at the 11:57 mark, between 11:57 and 11:58. Take a look at that tape. He's just about to leave. Higgins is just about to leave. He points over at John. He motions for him. Come on, come with me. And then at 12:20, he texts him, "You coming here?" This is a person he doesn't really know and didn't really talk to that entire night. Ask yourself, why was Higgins so insistent that John go to 34 Fairview that night? And then there's that sparring and fighting that he and Brian Albert were engaged in. Of all the things they could be doing, this is what they were doing just minutes before John O'Keefe walked into that house at 34 Fairview. We know that once John actually did walk in the door, it's about 2 steps, 4 feet or so, 2 steps for an adult male to reach that basement door. Remember, everybody was gathered in the kitchen. That's what Nicole Albert said. And every single witness agreed that at some point, Brian Higgins and Brian Albert left the group and went to another room. Where did they go? Where did they go together? Another important point. Chloe was not upstairs. Brian Albert slipped in one of his testimony that he provided. Quote, "I was watching Chloe downstairs, monitoring her because of the other people in the house. She's not good with strangers." Remember that testimony. So what happened next? We absolutely know that John was in the house. The data, Brian, Heather, they all established that. We know that John ascended or descended stairs. We know that Brian Higgins and Brian Albert excused themselves. How long does it take to have a crossword? How long does it take to have a fight? How long would it take for Brian Higgins to say to John, "You know, your girl's been texting me"? A push, a punch, a fall, pull Chloe off his arm, and now it's done. What was that? 5 seconds? 10? Doesn't take long at all. And then the panic sets in. It wasn't intended to go that far, but what's done is done. And then some very, very odd things start happening at the Albert household. Very odd indeed. What do we know? We know through the testimony and key swipes that Brian Higgins very oddly goes directly to Canton Police Department. Why would he do that? After a night of drinking and partying, why go to CPD when you're drunk? What was so important there? He couldn't even get his own story straight. First he said it was administrative work, then he said he was moving cars, then he said it was a factor of both. Is it both? Was it neither? Or was he there to gather intel? Ask yourself, why go? But the odd things keep piling up, and here's another. Chloe was the Albert family pet. Not only did she appear to be gone from the house that morning on January 29th, nobody saw her there. Even Jim McCabe admitted that I didn't see her there. But they actually got rid of the dog altogether. Within months of this incident, the dog was gone, out of the house, rehomed, never to be seen again. This was a dog they had had for 7 years. Also a dog who had a bite history. Why was it so important to get rid of that dog? Was there something about the dog they did not want law enforcement to find out? Recall what Dr. Russell said. She's seen up to 1,000 animal attacks. In her expert opinion, John's right arm, those injuries are from an animal, quote, most likely a large dog. And Dr. Russell's testimony, I'll remind you, was undisputed by any witness for the Commonwealth. But there are more odd and unexplained things. After a night of drinking and hanging out and partying, after being together for the entire day at 2:22 a.m., Brian Albert decides to call Brian Higgins. That call was missed. 17 seconds later, Higgins calls Brian back, and they speak for 22 seconds. Now, that call is odd and suspicious enough, and just in itself, the fact that the call was made. But what's even more incriminating is that both men, both of them, lied about the calls happening. They both claim astonishingly that those calls are, you probably say it with me, they're butt dials. Amazing. But Albert and Higgins take it a step further. Not only did they claim that they were making calls as butt dials, but they were answering calls as butt dials. And Higgins seemed awfully defensive about that call, didn't he? Remember on cross-examination when I was asking, can you have a conversation in 22 seconds? He unequivocally said, no, that's impossible. It's not reasonable. You can't do it. Well, let's test that out. Hey, did you make it over to Canton? Yep. Haven't been any calls. Nobody knows a thing. All right, don't talk to anybody until we talk again. Okay, fine. And by the way, come back over. I need help moving something heavy. How long did that take? 15 seconds, maybe? But the odd behavior isn't done yet. 5 minutes after that call that we just talked about, Jennifer McCabe is on her phone at her house, Google searching how long it takes for someone to die in the cold. That was at 2:27 a.m. That timeline seems to fit, doesn't it? And it fits a very telling and a very clear story. That search became a focal point of the Commonwealth's entire case. This case was starting to look a lot more like the defense of Jennifer McCabe than anything else. That's probably because there is no innocent explanation for that Google search at 2:27 a.m. None. At the end of the day, clearing away all the confusion, the Commonwealth's experts were left with two things that are true. First, neither of their experts could absolutely rule out that Jennifer McCabe made that search at 2:27 a.m. Neither. And second, the only person to use the actual phone model, the actual data, and the actual precise operating system was Rick Green. And he was clear. That search was at or before 2:27 a.m. And then it was deleted. So what else was going on at or around this same time when all this suspicious activity was happening at the Albert house and the McCabe house? 3 minutes after that search and 8 minutes after the Albert Higgins 2:22 a.m. call, Brian Loughran drives down the street in his snowplow. And he told you that there is no body laying on the lawn at 34 Fairview at 2:30 in the morning. Importantly, he didn't just simply say he didn't see a body, he wasn't paying attention. He said there was no body there. He knows the property, he knows the owners, he's grown up with these folks, he passes by all the time, not once, not twice, 3 passes. There was nobody on that lawn, period, at 2:30 a.m. And one other suspicious thing happened that night. By 3:30 a.m., someone moved a Ford Edge in front of the very area that would obstruct the view of where John's body would ultimately be discovered. Who's the only person in this case that you've heard about in Ford Edge? Brian Albert. Remember, as you're thinking about this, the basement at 34 Fairview is serviced by a bulkhead. It's a quick and convenient door to the backyard. And that backyard is serviced by a side fence. And that side fence is easily accessible to the front yard at the side of the house. Which side of the house? The side where John's body was found. And by 6 a.m., John's body was, in fact, now outside. While this flurry of suspicious activity was going on with the Alberts and the McCabes, what's happening with Karen? All she knows at this point, think about it, at approximately 2:21, she dropped off John, he walked into 34 Fairview, and that's all she knows. She knows nothing else that was going on. So what was she left to think? He goes in to check the party out, but all of a sudden he's not coming back, he's not responding. Minutes start to pass, 1 minute turns to 2, 2 turns to 10. Where is he? Why didn't he respond? She's sitting in the cold, dark, freezing outside in the car. Naturally, she's perturbed. Being perturbed turns into being peeved. Being peeved eventually turns into being pissed. By 12:30, Karen's mad. She's left 34 Fairview to make a point, but she's still texting and calling. What could she reasonably be thinking at this point? What's going through her mind? 12:33 turns into 12:34. I can't believe you do this to me. 12:34 turns into 12:35. Where is he? Why aren't you answering, John? 12:35 turns to 12:36. Jesus Christ. I'm calling and you're not answering. Where are you? Pick up the phone. But there's still no answer. There's still no response. By 12:37, she's getting furious. She does not know that something has happened to John. She does not know that. So she leaves the first angry voicemail. Illustrates frustration, aggravation, all the normal responses anybody might have, you and I might have. But little did she know. The next open voicemail has Karen parking at John's garage after she gets home. You can hear her heels clicking across the garage floor. For all she knows at this point, John's just drunk, he's been partying, he's hanging out, just forgot about her, blowing her off. But John's still not responding, and as the minutes tick by, Karen becomes increasingly upset. Those are the voicemails that you heard. How could he do this? Why is he ignoring me? Why is he ignoring the kids? Those are the thoughts bearing down on Karen Reed as she sat in an empty house late at night by herself. Ladies and gentlemen, she did not know what had happened to John. But within the next voicemail, you quickly learn what she was thinking and what she was feeling. Now it's 5:23 a.m. She's woken up. She's realized that he hasn't come home. He hasn't responded to a single text, not a single call. And anger quickly turns to panic and abject fear. She's so distraught, she reaches out to him again. John, where the fuck are you? She says in tears and desperation. And at 6:03, the question was answered and her worst fears are realized when she finds his body laying, dying in the cold in Brian Albert's front yard. You heard her. You can feel the grief. You can feel the raw anguish. You can see it. You don't have to wonder the emotional journey that Karen traveled that night. You can see it in the video. You can hear it in the audio. From the time he left her and walked into 34 Fairview and she called, she reached out 53 times. She called him 53 times before finding his body. Think about that. The Commonwealth wants you to believe that she murdered this man. And then after that murder, she called him not once, not twice, 53 times. It makes no sense. What does make sense is that she emotionally moved from anger, then to panic, then to grief. So back at 5:07, when she began her search looking for John, she backed out of the garage, and what would happen next would change the entire course of this case. As she backed out of that garage, she hit John's Traverse and cracked her right rear taillight. Folks, the Commonwealth has one job to do in this courtroom. It's an immutable responsibility to provide you with the truth. That's it. Not to win the case, but to seek justice and to do it through the truth. Ask yourself, did you get that truth from the Commonwealth? The Commonwealth continually tried to tell you that that video showed that the SUV came close to John's Traverse, and it took us showing you the video to unequivocally establish that Karen hit that car and cracked her taillight at 5:07. You can almost hear an audible gasp in the courtroom when we finally showed you the actual video. You can see that tire move. I'm only going to show you one series of exhibits during my entire closing, but it's that important. And it's this. Look at the condition of her taillight when she pulls out of the driveway at 5:07. That taillight, and I'm going to choose my words very carefully here. That taillight is cracked, but it's not completely damaged. And if there was any question in your mind about the level of damage to that taillight at 5:07, all doubt was extinguished. When Dighton Police Officer Barrows walked into this courtroom, he's a sworn officer. He's not associated with Kenton. He's not associated with the Alberts. He's not associated with the McCabe's. He doesn't know Michael Proctor. In other words, he doesn't answer to any of these folks. He's an outsider and he's completely independent. And his words were the following, quote, "That taillight was not completely damaged. It was cracked. A piece was missing, but not completely damaged." Take a look at this photograph and tell me, which one looks like Officer Barrows' description? The one on the left or the one on the right? The reconstructed light on the left is what that light looked like before it was in Trooper Proctor's possession. Remember that. That's what it looked like before Trooper Proctor had access to the SUV. And you have an independent police officer telling you so. You'll recall that after John's body was discovered, Blank, a very good friend of the Alberts, walked into Brian Albert's house and had an off-the-record meeting with him. No one's ever going to know exactly what that meeting was about, what they discussed, because that interview, like everything else in this case, it wasn't recorded. It wasn't memorialized. But we do know that shortly thereafter, the Canton Police Department was recused from the matter entirely. And the case was assigned to one Michael Proctor. You have to believe that when the Alberts found that out, they thought they hit the lottery. They thought they hit the lottery. What are the chances? The department where my brother works, that would have been great to investigate this case, but that department's been recused. That's tough luck. But the guy who catches the case is Michael Proctor, a guy we go back with for decades. That's such a break, they probably thought, when this is over, we need to get that dude a gift. Oh, wait a minute. They didn't think that. They said it out loud. But still, you've got to imagine that the Alberts had to be stressed with that whole thing about a dead body being on their lawn. That might get some attention. And they had to be wondering, will he set up a crime scene? Is he going to come into the house? Is he going to search the house? Is he going to send in a forensics team? Is he going to interview witnesses? Is he going to take us to the station? Will he take our phones? Will he look at our communications? Will he look at our Google searches? Will he look at our early morning phone calls? Is he going to look in the basement? And Michael Proctor answered every single one of those questions resoundingly. Nope. He's a Boston cop too. And with that, Michael Proctor didn't draw a thin blue line. He erected a tall blue wall. A wall that you can't scale. A wall that Karen Reed certainly couldn't get over. A wall between us and them. A place you folks are not invited. We protect our own. It's us or it's them. And by the way, who's she after all? Nobody. An outsider. This is going to be easy. Or so they thought. Let's look at what Michael Proctor actually did and did not do in this case. One of the consistent issues that's come up throughout this trial is how evidence always seems to be changing and evolving when in Michael Proctor's hands or somebody in this orbit. If it happens once, let's chalk it up to a mistake. Twice, it's starting to look a little bit like incompetence. If that happens every single time, it becomes intentional, which means it becomes corruption. The defense spent some time, we spent some time discussing the tow time that Michael Proctor swore to in affidavits. There was a reason that we believed it was so important. I want to talk about that for just a quick second. Because this was a concerted effort by Michael Proctor to falsify the time the car was seized, so that no one would know that he actually had possession of the car before the first pieces of taillight were ever discovered at the scene. But he got caught. And when he did, the best he could come up with was it was a typo. Like a dozen times, a typo. You'll remember what that testimony was. The truth is that car was in Michael Proctor's possession from about 4:12 in the afternoon. He said it was 4:16 when he finally had to tell the truth or some version of the truth. Those first pieces of taillight were not found until after 5:45 p.m. That is the very fact that Michael Proctor was trying to hide by those falsified affidavits, saying he didn't seize the car until 5:30. But that wasn't Michael Proctor's only manipulation of the investigation. What about Brian Lockwood? You met him. Michael Proctor did his level best to not just hide evidence, but to hide human beings from you and from us. Michael Proctor was informed that the plow drivers were out that night. There would be a witness, potentially along 34 Fairview, at the exact times in question. Even Michael Trotta expressly told Michael Proctor that 34 Fairview had in fact been plowed that morning, and by whom. Proctor not only did not interview Brian Loughran, he never disclosed his name in a single report. He hid him. This is a witness who was literally on 34 Fairview at the time in question where a body was found on the lawn. Wouldn't you want to get the truth from an eyewitness? Wouldn't you want to seek that out? Not if you're Michael Proctor, a close friend of the Outlaws. If it were up to Proctor, you literally never would have heard of or from Brian Loughran. That's a scary prospect. I want to touch briefly on the additional physical evidence, or some additional physical evidence presented by the Commonwealth in this case. You'll recall Christina Hanley. She established to a scientific certainty that the glass on the bumper, which was told to you in opening statement, was going to have something to do with this case. The glass on the bumper was going to match that cocktail glass. She told you unequivocally the glass on the bumper did not match the cocktail glass. They came from two different sources. The glass on the bumper has nothing to do with the cocktail glass. So that glass on the bumper had to get there somehow. It didn't get there by being broken from the cocktail glass. See the point? It had to get on the bumper somehow. It didn't jump up there by itself. And what's really interesting is that there was one piece on the bumper, only one, that matched something else in the case. It was a perfect match to a piece of glass that was supposedly found at the scene. Who do you think had possession of that matching glass? Michael Proctor. So the glass on the bumper had to be placed there. And the only person who had anything close to matching the pieces that had to be placed there is Michael Proctor. You do the math. That leads us to the magic hair. The Commonwealth spent a lot of time bringing in experts about mitochondrial DNA and maternal DNA lines and comparative analyses, and all that sounds really great and really sciencey, except for the fact that it just doesn't matter. Why? Because you would have to believe that that little hair, tiny, tiny little hair, barely perched on the side of that SUV through survived nearly 75 miles of a raging blizzard outside. That would be a magic hair indeed. A magic hair means nothing. The DNA means nothing, and that's because the hair was from somewhere else. It certainly was not from a motor vehicle incident at 34 Fairview on January 29th. That hair was placed there. The DNA on the outside of the taillight housing also merits very little discussion. John's DNA would be expected to be found all over that SUV, inside, outside, the exterior, the interior, everything he touched would have had his DNA on it. Here's what's actually important about that DNA. No DNA was found on the interior of that taillight. The taillight that they now claim crashed into his arm and shattered. No blood was found anywhere on that taillight or any taillight pieces, and no tissue was found anywhere on that taillight or any taillight pieces. But we're to believe that that taillight literally exploded on John's arm at 25 miles an hour with 1,000 pounds of pressure. We talked about the evidence doing very funny things when in Proctor's possession or the possession of somebody in his orbit. Now think about the videos that we saw. How many videos appear to be somehow manipulated or altered? Just about every single one of them. Look at the video of the Sally Port. Let's take that one, for example, that grainy one. It's missing the exact time that would show the condition of the taillight when it was pulled in to the Sally Port. Pretty important time, don't you think? Did someone not want you to see what the condition of the taillight was at that exact time? But the good news is there's a second video. It's much clearer. It's from the same time frame. We didn't get that one for about 2.5 years into the investigation. Literally, it was after the trial started that one was turned over. And this is important. The Commonwealth introduced you to a person by the name of Yuri Buchanan. They presented video showing what was clearly the right side of the car. They asked questions about the right side of the car. You'll recall, Mr. Lally asked Sergeant Buchanan, did you or Trooper Proctor ever go at, or near the right side of that taillight? And while he was asking the question, what appeared to be the right side of the car was looking at you. The video was still up. Buchanan paused, turned earnestly into the microphone, stared at you and said, never. We never went anywhere around that taillight. While he was showing you the right side of the car. And that trick might have worked until we got up to cross-examine him. And only then, on the second day of his testimony, did he have to admit that the video was actually inverted. It was backward. And it was cleverly inverted at that. The timestamp had the proper orientation, which means that timestamp had to be removed, the video inverted, and the timestamp placed back on it. Which means that was done intentionally. That was not a mistake. And when caught in that obvious fabrication, Buchanan doubled down and said, it's exactly the same. You remember that back and forth. It's exactly the same, he said, as if we're stupid. Is it exactly the same, or is it exactly opposite? Ladies and gentlemen, you were lied to. There's no other way to say it. It's inexcusable. It's abhorrent. But it's also a paradigm of everything that the investigators have been willing to do in this case. Lie, obfuscate, manipulate, alter. And when they're caught, they just excuse it away. Doesn't matter. It's the same thing. What's the big deal? Just look the other way. And don't forget, Buchanan is Proctor's supervisor. And he was in that little group chat where Karen Reed's naked photos were being searched for. You know the saying about the apple falling from the tree. Ladies and gentlemen, we haven't even started talking about the taillight yet. You'll recall that at the very beginning of this case, you were introduced to no fewer than 5 CPD officers very early on who searched the scene. None of them, not a single one, found any taillight material at the scene. Zero. Stephen Seraph, Sean Good, Stephen Mulaney, Michael Lang, Paul Gallagher, they were all there. They were all walking right around there. They were all looking. They were searching with their eyes. They were searching with their hands. Some said they were searching with their feet. They even used tools, a leaf blower. Not one piece of bright red taillight material was at the scene, not a single piece, but incredibly, over the course of the next 3 weeks, according to Michael Proctor, 47 pieces of taillight material would end up being found, some of which were the size of a salad plate. The CERT team shows up later on January 29th, and according to O'Hara, the first few pieces of taillight were found about 5:45. And here's some interesting testimony that you heard. Who else was there? Who did O'Hara say was there? Well, he said his team was there. He certainly expected that, but then he said there were others. These other mysterious figures, some from Canton PD, some from the Massachusetts State Police, that he could not account for. Heavy coats, big masks, hats. Even Lieutenant O'Hara could not tell who was who, but he did note Canton police officers were there, who were unaccounted for. Massachusetts state troopers were there, unaccounted for. And during that search that was overseen by Trooper Tully, Proctor's supervisor, 3 pieces of taillight material were found. That's super important. I want to concentrate on that for a second. O'Hara said all 3 pieces were in an area about 12 inches square. That's an area about as big as your dinner plate. Tully, however, claimed that 1 red piece was found about 3 feet away from that was a shoe. About 1 to 2 feet from that was a clear piece of plastic, and a few feet away from that was a red piece of plastic. So we have red, clear, and red over the span of about, added up probably 10 or 12 feet. Ladies and gentlemen, both of those things cannot be true. Somebody is taking liberties with the facts. Then Lieutenant Tully comes to court and makes this big grand gesture of opening all these evidence bags. These 2 evidence bags in particular represent exactly what we're talking about. Those 3 pieces, red, clear, red. They're marked, they're sealed, they look official. They're not stop and shop bags, thank God. At least they moved up from that. They've even got evidence tape on them. Who knew? There's evidence tape around here. So this must be real evidence, right? It must be real evidence in this case. And after making that big theatrical display, he opens up the bag with the red pieces and he pulls 2 pieces out. That's okay. Put the 2 red pieces together. Good so far. Then he opens up the second bag under Mr. Lowley's questioning. And you remember he hesitated just a second. Opened that bag and pulled out 1 piece of clear plastic. Then pulled out a second piece of clear plastic with no explanation as to how that could have possibly happened. And he quickly returned all 4 of those back into the bag, sealed them up, and we're done for the day. The next day I asked about that evidence again. I asked him to open up that bag with the red pieces, and he did the same thing. Pulled out 2 red pieces of plastic. I said, you recall this, I said, look deeper, look closer, sir. Pull everything out of that bag. Would he have had I not suggested it? And then he pulled a 3rd piece of red plastic out of the bag. So miraculously, Trooper Tully's 3 pieces of plastic became 5 pieces of plastic right before your eyes. Ladies and gentlemen, the forces at play that multiplied those pieces of plastic inside those evidence bags are the same forces at play that multiplied the pieces of plastic at 34 Fairview. Think about that. Let that sink in for a second. How easy is it? That's not sloppiness. That's evidence manipulation. That's how over the course of 3 weeks, those pieces of plastic go from 0 to 3 to 5 to 47, ever increasing in size with every single search. Now, knowing all that, ask yourself the moving question: who had access to that taillight, the cracked taillight? Who was it? Go back and watch the Sallyport video. I'll give you the timestamp, 5:37, and see it for yourself. We know that Trooper Proctor, with binder in hand, walked by himself. Once we corrected the video from being inverted, you can see that he walked back by himself to the right rear taillight where nobody could see what he was doing. Higgins' own key swipes put him in the Sallyport that same afternoon and evening. And then the Sallyport video magically skips, and Chief Berkowitz appears right next to Proctor at the back of that vehicle in the same spot, and they walk out of the Sallyport together. Where were they going? Remember O'Hara. Unidentified troopers in Canton cops were at the search at 34 Fairview. How hard is it to drop a piece of plastic? We spent a long time talking about the compromised and altered and tampered and manipulated evidence, but now I want to switch and talk a little bit about the true facts in this case, because you did hear some true evidence and true facts. The Commonwealth presented about 67, maybe more, witnesses, and expended 30+ days of trial and 9 weeks of your life. Maybe we're in the 10th week. For what? It should be relatively simple, right? The Commonwealth claims that Karen Reed pulled up to 34 Fairview, John got out of the car, she reversed into him and hit him, and then she drove home. That's 4 facts. It's just 4 facts. That's all it is. What evidence do they actually have to prove that that SUV ever hit John? The answer is none. They don't have any. There's no evidence whatsoever that Karen Reed's vehicle ever struck John O'Keefe, or that Karen Reed ever wanted to strike John O'Keefe. In fact, every single piece of material evidence in this case unequivocally proves the opposite. John went into that house. That SUV was not damaged by hitting John, and John's injuries did not come from being hit by a car. That's what the evidence actually shows. The Commonwealth knows that, and they've known it for a long time, and Proctor knows that. And because of that, the Commonwealth just resorts to character assassination and talking for weeks on end about the snow. Let's talk about what the real evidence actually shows, the unassailable science. Let's talk about the truth. Concerning John's injuries first, the Commonwealth's own medical examiner, Dr. Sporty Bello, could not conclude that John was hit by a car. Think about that. And she would not even say that it was a homicide. She told you without any dispute in this case, quote, evidence pointing toward one manner of death is no more compelling than evidence of a competing manner of death, end quote. Her words, not mine. She went on to say it's just as likely that he was punched and fell backward. His injuries are consistent with that. In fact, in her expert opinion, his injuries are consistent with a physical altercation, as she testified, but they are not, in her words, not classical injuries from an auto-pedestrian accident. That by itself is reasonable doubt. But the evidence and the truth goes far further. We introduced you to not one, but 2 thoroughly credentialed medical examiners from medical experts, Dr. Sheridan and Dr. Russell, both of whom said John's arm injury is consistent with an animal attack. Dr. Russell studied, diagnosed, and treated up to 1,000 animal wounds. She's an expert in animal wounds, and she was unequivocal. Those wounds are from an animal, likely a large dog, which means that John was attacked inside the home where Chloe was. There is no other possibility. And Dr. Sheridan, for his part, with thousands of 13,000 autopsies under his belt, decades of experience as the chief medical examiner, who's triple credentialed in anatomical, forensic, and neuropathology, he told you that John's injuries are inconsistent with a motor vehicle accident or incident. They're consistent, however, with a physical altercation. In layman's terms, the science proves John was beaten. That also is reasonable doubt and should end this case. But the facts and evidence don't stop there. Two of the most highly educated and highly qualified engineers you'll ever meet, Dr. Dan Wolfe and Dr. Andrew Rentschler, mechanical engineer and a biomechanist. They reviewed this case. They did testing, they did analysis, they evaluated the case scientifically. They were not hired by the defense, not by the Commonwealth. They're completely 100% independent of any party in this case. And they were equally available, by the way, to the Commonwealth. They could have called them. They explained that John's injuries were not caused by being hit by Miss Reed's SUV, and that the SUV is not damaged by coming in contact with John O'Keefe's body. That should end the inquiry right there. Both sides of the equation. From a physics, engineering, and biomechanical standpoint, they established that John O'Keefe was not struck by Karen Reed's vehicle, period. And that is yet another fact that establishes reasonable doubt and should put it into this case. So instead of calling the ARCCA experts, which they had available to them, the Commonwealth chose to introduce you to Trooper Joe Paul. You'll remember his testimony. I think I'm being kind when I say that Trooper Paul's analysis lacks credibility. Trooper Paul lacks the experience, the education, the training, the background, and the knowledge to not only render opinions on these issues, but to even understand the issues themselves. He makes the absurd claim that John was hit on the elbow area of his arm by a taillight. He was spun to the left in a pirouette. His arm stayed on the light long enough for the shards of plastic to explode around him, scratching his arm, even though he was wearing long sleeves, then projecting him 30 feet to the left, but not before making a stop to hit his head on either the curb or the pavement, before coming to his final resting place with his unbroken phone tucked neatly under his body. It's nonsensical. It borders on laughable. Compare that testimony to Dr. Dan Wolfe and Dr. Andrew Rentschler, both PhDs in engineering, both top of their field in accident reconstruction, both published peer-reviewed articles on the issues. Both men are highly sought after by the likes of national sports leagues and the United States Department of Defense, and these men are unrivaled in accident reconstruction. What did Dr. Rentschler say before he left the stand? This was even under cross-examination. He said that the physics and the science don't lie. His words were, you can't deny the science and the physics. John wasn't hit by that car, period. The Commonwealth cannot explain John O'Keefe's injuries. They can't explain his head wound. How did he get the head wound if he landed on snow-covered grass and dirt? And by the way, before Mr. Lally gets up and says it, because I know he's going to, there is zero evidence before you, zero, that cold grass and dirt turns into ice or turns into concrete. Zero. They can't explain the injury above his right eye, that laceration. They can't explain his nose. They haven't even tried to. They can't explain the injury to his tongue, the laceration on his tongue. They cannot explain the injuries to the back of his hands, the bruises, and certainly they cannot explain the injuries to his right arm. But maybe most importantly, they cannot and haven't even tried to explain the lack of injuries on John's body from the neck down. Nothing. He was pristine. Not a bump, not a bruise, not a fracture, not a broken bone. Nothing to suggest that he was hit by a 7,000-pound SUV going 25 miles per hour. And what of that right arm? According to the Commonwealth's best and brightest, Trooper Paul, John absorbed the entirety of the collision, a whole collision, with that 3.5-ton SUV entirely with his right arm, launching him some 30 feet. But amazingly, the arm suffered no break, no fracture, and didn't even get a bruise. So how are those injuries properly explained? The evidence is simple. John got into an altercation. He was punched. He tried to defend himself by putting his hands up. He maybe even scratched his own nose by putting his hands in front of his face to defend himself. His hands were bruised and covering up.
5 minutes, Mr. Jackson.
Thank you, Your Honor. As he continued, he got hit, punch went through, and he fell to the ground, fracturing his skull. At some point during that altercation, the dog got hold of him, and the dog was pulled away. Every single injury is answered. Every single injury is explained by that. Ladies and gentlemen, given what we know about the facts and the physical evidence in this case, the actual truth in this case, how did this happen? How did we end up here? We ended up here because of relationships, insider trading, playing the who you know game, and building a tall blue wall, which takes decades and generations. But the real question is it going to continue? Will this festering malignancy that allows a lead detective and a supervisor to gloat and sneer while looking over naked pictures or looking for naked pictures of the woman that they targeted, will that continue? And the answer should be, not if you have anything to say about it. Michael Proctor is the lead investigator in this case, and much as the Commonwealth might try, they cannot distance themselves from the stench of him on this case and this investigation. Those secret group chats illustrate the quality and character of his investigation. Remind yourself how, quote, unbiased and an objective investigator, someone who's supposed to be looking for facts. Ask yourself, how did he approach his job? Late at night, sitting there in his office, deviously looking for naked pictures of Karen Reed and talking about her like she's a piece of meat, talking about her bodily functions, her medical conditions, calling her vile names. I don't even have it in me to repeat what he said about her. He reduced her to an object And he went further by insulting her. He went further than insulting her, and he dehumanized her. And when he was done betraying that very humanity, he wished for her to commit suicide. That, ladies and gentlemen, is how you frame someone. That's how you dehumanize someone so viciously that you can just pin it on the girl and cover for the homeowner because he's a Boston cop. That's how you rip a person's life apart and sleep like a baby while doing it. And then further that by saying, I hope she kills herself. Ladies and gentlemen, I just began the discussion this afternoon or this morning with a quote about the truth, and I did that because that's what this case is about. Top to bottom, tip to tail, it's about the truth. Not hiding it or concealing it, but exposing the truth. The truth is immutable. It's not a feeling, it's not a whim. It's unflinching, it's unchanging, and it's everlasting. That's why the law is steady. That's why it's not captive to the whims of people drunk with power who think they're above the law, who think they're above scrutiny. That's why you stand as the guardian of justice and the protector of justice. The law demands the very integrity that Trooper Proctor and his investigation lacks, and it requires that you cannot convict Karen Reed unless the Commonwealth has met its incredibly high burden to prove every element beyond a reasonable doubt and to a moral certainty. And a moral certainty is defined as the highest degree of certainty possible in matters related to human affairs. It's the highest degree possible in your life. That's the level of certainty. And I'll leave you with this. You have the most powerful tool known to American jurisprudence because you have your vote. No one can take that away from you, not me, not the Commonwealth, not the court. You may not have asked to be here, but each of you have given something very special to yourselves. You've agreed to do that, which is the highest calling a citizen can answer in any way. You've agreed to give your community your best. And my question to you is, what will you do with this moment? Ignore the lies, the manipulations, the misogyny, the bias, the lack of evidence? Could you ever do that? Would you ever do that? Or will you say with your verdict, I see the truth, and I will not ever look the other way? When you stare the truth down, you'll see that the Commonwealth has not proven its case beyond a reasonable doubt into a moral certainty, not even close. Ladies and gentlemen, Karen Reed is innocent. Do justice and find her not guilty. Thank you.
Thank you very much, Mr. Jackson. All right, Mr. Lally.
Thank you, Your Honor.
I hit him, I hit him, I hit him, I hit him. Those are the words of the defendant. 4 times. You heard testimony from 4 different witnesses who overheard and observed those statements from the defendant on January 29th, 2022. You heard testimony from firefighter Timothy Nutter. He was trying to valve mask Mr. O'Keefe. He was working on resuscitative efforts to try to save Mr. O'Keefe's life. He asked if anyone saw anything or knew what happened. And the defendant said, I hit him, I hit him, I hit him, I hit him. Firefighter Anthony Flamati was asking if anyone had information on why Mr. O'Keefe was there in the snow. The defendant repeatedly said, I hit him, I hit him, oh my God, I hit him. Firefighter Katie McLaughlin was tasked by firefighter Flamati with asking for biographical information and for what the cause was of the traumatic injuries that all the firefighters testified that they observed on Mr. O'Keefe. She asked the defendant, and the defendant said, I hit him, repeatedly. Firefighter McLaughlin asked for clarification. You did what? And the defendant repeated, I hit him. Jennifer McCabe stated initially over the phone when speaking with the defendant that the defendant said, could I have hit him in the car while they're on the phone with Ms. Roberts going from Mr. McCabe's house to Mr. O'Keefe's house? Did I hit him? Could I have hit him? Once on scene, once asked, as Mr. McCabe described by an EMT, for name, age, things like that related to Mr. O'Keefe, what caused the trauma? She indicated in her testimony that the defendant said repeatedly, I hit him. You heard testimony from Officer Sarif, statements that he attributed to the defendant as saying that morning, this is all my fault. This is all my fault. I did this. This is what the defendant is saying on scene. Since then, stories changed a little bit. But those were the words that came from the defendant's mouth on January 29, 2022, as John O'Keefe lay dying on the front lawn of 34 Fairview Road, where the defendant had left him after striking him with her motor vehicle several hours before, and then left him freezing there in a blizzard. There's certain things that have come up over the course of this trial as far as evidence and testimony are concerned, little things. And what I would suggest to you is it's those little things that are quite telling as it pertains to the defendant's statements and the defendant's actions over the course of January 28th and January 29th and beyond. I'm going to bring some of those to your attention as I go through, but just ask you to keep that in mind as far as when you're deliberating, when you're reviewing this testimony and this evidence. The little things matter. The little things start piling up in this case. Throughout the course of this trial, you've heard a lot of purported evidence or questions of witnesses in an attempt to distract you from the evidence in this case. It's essentially defense by obfuscation. It's a 3-card launcher. The facts and the evidence in this case are your card, they're the Queen of Hearts. And so what I want you to, or what the defense wants you to do is not look at that card. Look at anything else. Look at movement, look at this person, look at that person, look at text messages, look at this. Don't pay attention to the facts and the evidence, because if you do, what it will ineluctably lead you to is that the defendant is guilty of each of the 3 indictments before this court. The evidence and the facts of this case are for you, the jury, to decide. Using your common sense, using your life experiences as your guide through that as you go. Before I turn to that evidence that I will submit to you and ineluctably demonstrates the defendant's guilt, let me first just address Trooper Proctor. The text messages from Trooper Proctor are unprofessional, they're indefensible, They're inexcusable. However, as distasteful as those messages are, and their content is, I submit they had no bearing whatsoever or impact whatsoever on the integrity of the entirety of the investigation that Massachusetts State Police collectively conducted into John O'Keefe's death here. As was asked of Trooper Proctor on cross-examination, these were texts from his personal phone that he never thought would see the light of day. He was asked whether or not he ever thought that he would be asked about these in a courtroom, put to him in sort of a safe space, a safe place for him to discuss, if you will. What do you not see in those text messages? You don't see any discussion or any illusion of any conspiracy, of any framing of the defendant, of any planting of any evidence, no evidence whatsoever. Why? Because it didn't happen. There is no conspiracy, there is no cover-up, there is no evidence of any of that beyond speculation, rampant speculation and conjecture on behalf of the defense. Two things can be true at the same time. They're mutually exclusive. The texts from Trooper Proctor are distasteful, they're disrespectful, they're unprofessional, there's no defense to them. And the defendant killed John O'Keefe. Turning to the evidence, let me first talk a little bit about John O'Keefe. We heard a lot about him over the course of this trial, about his selfless story, to his family and friends that loved him, including his adopted niece and nephew. We heard a lot about the lives he touched and the different people who he had friendships with. We heard a lot about from those particular friends and from his family. Turning to what I would submit to you as a time. This may be a little hard to see up here. What I'm going to go is from left to right. January 28, 2022, 9:49 in the morning, Karen and John begin fighting over text messages. 2:25 p.m. in the afternoon, defendant texts Mr. O'Keefe, tell me if you are interested in someone else. Can't think of any other reason you've been like this. John texts back, nope. 2:25, Mr. O'Keefe texts the defendant, things haven't been great between us for a while, ever consider that. This is also testimony that you heard through multiple sources, whether it be phones, whether it be from the children, whether it be from other friends or family members as to the relationship in the months and weeks leading up to John's murder. 2:32 p.m. John texts the defendant, sick of always arguing and fighting. It's been weekly for several months now. He then texts the defendant, OMG, stop calling. This is during the time frame that Trooper Garino was talking about with 18 phone calls, most of which were rejected, some of which were missed, and a couple of which were answered over the course of this afternoon as she's continuing to needle and try to engage him in a fight that he doesn't want to have. 2:33 p.m. The defendant texts John, so you're not into this anymore. 2:34 p.m. John texts the defendant, I am not answering, stop calling. The defendant then texts John, then stop starting with him. 2:38 p.m. The defendant texts John, I'm going to grab a drink in a bit. 2:38 in the afternoon. Around 3 p.m. is a testimony you heard from Erin O'Keefe in regard to the defendant texting her, asking if she can go out without her husband, Paul, asking to go out for a drink. This is while Erin O'Keefe testified she was waiting for one of her children at the bus stop, picking that child up around 3 o'clock in the afternoon. This is also the point at which the defendant says to Ms. O'Keefe, wish I didn't speak to another O'Keefe after 2004. 7:30 p.m., you have Mr. O'Keefe and Mr. Camerano arriving at C.F. McCarthy's with the defendant arriving at 8:51. 8:58 p.m. is when the defendant receives drink number 1 at C.F. McCarthy's. Vodka soda, tall cylinder glass, lime and Pastrana. 9:13 p.m., drink number 2. 9:20 p.m., drink number 3. 9:33 p.m., drink number 4. 9:57 p.m., drink number 5. 10:22 p.m., drink number 6. 10:29 p.m., drink number 7. 7 drinks from 8:58 p.m. through 10:29 p.m. when she receives that last drink at C.F. McCarthy's. The drink that she indicates to Sergeant Mechanic and several others on the next day that she did not take with her from C.F. McCarthy's to the waterfall, which several individuals at the waterfall testified that she produced from her coat when she walked in, and that you can clearly see on the C.F. McCarthy's video her walking out the door with the same tall cylinder glass in her right hand. Now, keeping understanding that some of these drinks are not the full tall cylinder drinks, what she's doing is she's getting shot glasses of vodka and then pouring them into the drink after she's consumed the drink. 10:54 p.m. The defendant and Mr. O'Keefe arrive at the waterfall, during the course of which, on an hour that they're there, the defendant receives drinks number 8 and drinks number 9. 12:10 a.m. from the waterfall video, you have Ms. McCabe, Ms. Kolokithis, and the defendant departing the waterfall together. Interestingly, around the same time, you also have the text and screenshot communications between Colin Albert and Allison McCabe in reference to him getting picked up at that time. You also have testimony from Brian Albert, Cole Albert, Caitlin Albert, Brian Albert Jr. in reference to them sort of walking in from the waterfall as Colin Albert is walking out of 34 Fairview Road, gets picked up by Ms. McCabe, and then is driven home. 1 minute later, 12:11, Mr. O'Keefe is then on the waterfall video walking out with a cocktail glass in his right hand. At 12:14 a.m., Mr. O'Keefe texts Ms. McCabe, where to? 12:14 a.m., based on the fact that she's driving, and Matt McCabe indicated in his testimony that she should call him instead of texting while driving, Ms. McCabe calls John O'Keefe, speaks with him regarding directions or going over which way to come in Chapman Street over Cedar Crest as far as coming into Fairview Road. 12:15:38 a.m., the defendant's vehicle drives by the Canton Library. You can see that on the video. 12:17:56, the defendant drives by the Temple Beth Abraham video. Again, you can see that on the video. Remember also the testimony from Lieutenant Tully in regards to the CSLI data and the ranging data in reference to coinciding with what you observed with black SUV from each of those respective videos. 12:19:32, Mr. O'Keefe enters 34 Fairview Road into his Waze app on his phone. 12:23 a.m. is when the defendant conducts a 3-point turn on Cedar Crest and travels back toward Fairview. That's from Mr. O'Keefe's GPS native location data from his phone. Around the same time, 12:23 and 12:24 is when you have that testimony from Ryan Nagel, Heather Maxson, and Ricky Cantono, pulling into Fairview Road around the same time and pulling in behind the dark SUV. 12:25 a.m. is the last native location GPS data of John O'Keefe's phone. It's in that area between 32 and 34 Fairview Road, where his body is discovered the next morning, in which there is no movement of that phone from that 12:25 a.m. period until Miss Roberts then picks up the phone on the grass underneath Mr. O'Keefe's body sometime after 6 a.m. What you have up on the screen right now is that data, those plotting points that Sugar Marina was testifying about as far as the movement of the vehicle. The movement of the vehicle as it comes down Cedar Crest, passes by Fairview, reverses direction, and then comes down Fairview, moving up, as the witnesses described, eventually stopping in that area of the property line between 32 and 34 Fairview Road, which happens to coincide with the vehicle control history database information from the Toyota text stream, which you now have up on the screen for you here, indicating that following that 3-point turn, approximately 8 minutes after that, from Trooper Paul's testimony, as far as the mileage, 36 to 38 miles, matching up with the time that the vehicle is in front of 34 Fairview Road, that the vehicle travels in reverse, in a straight line, for 24.2 miles per hour, for 62.5 feet, with a minor steering angle change, which the trooper indicated was consistent with a pedestrian collision. At 12:30 a.m., you have that second triggering event, 8 minutes after the 3-point turn when the vehicle is in reverse at 24.2 miles an hour. 12:35 is when the defendant calls John, and that's unanswered. 12:36 is around the time that the defendant's phone connects to the Wi-Fi at One Meadows Ave, Mr. O'Keefe's home. 12:37 is when the defendant leaves this voicemail. So within minutes of that vehicle's data, going 24.2 miles an hour in reverse for 62.5 feet, the defendant leaves that voicemail, seething in rage as she's screaming, "John, I fucking hate you." 12:40 to 12:42, Ms. McCabe is texting Mr. O'Keefe. She tries calling Mr. O'Keefe, gets no answer. If you recall from her testimony around this time frame, about 12:40, she was unsure whether the vehicle was actually still out front or if it had gone at that point. But she was looking for John because she had seen the defendant's vehicle in front of the house and no one had come in. So she was wondering where her friend, Mr. O'Keefe, was. 12:55, the defendant texts John, "See you later." 12:59, the defendant calls. There's another voicemail from Mr. O'Keefe. Exhibit 637, it sounded like this.
"John, I'm really a fucking kid. Nobody knows what the fuck you want, fucking pervert."
But somebody did know where Mr. O'Keefe was. The defendant knew exactly where he was. She had driven him there. She had struck him there. She had left him to die. 1:02 a.m., the defendant leaves another voicemail with no content. And then she texts John, "Your kids are fucking alone." 1:09 a.m., the defendant texts John, "I'm back in Mansfield. The kids are home alone." She's not. GPS, as far as it never disconnects from the Wi-Fi until the following morning. There's no indication that Ms. Reed left and went to her home in Mansfield at any point. 1:10 a.m., the defendant calls her parents. 1:11 a.m., she calls Mr. O'Keefe and leaves this voicemail.
"John, I'm going home. I cannot make it to any go home. You are fucking using me right now. You're fucking another girl. She's sleeping next to me. You're a fucking loser. Fuck yourself."
1:18 a.m., the defendant leaves another voicemail. Now, about 1:43 or 1:45 a.m. is when Julie Nagel testified that they were leaving the house. And she sees a large black object on the lawn near the flagpole while leaving 34 Fairview Road. Doesn't think much of it at the time, isn't expecting Mr. O'Keefe or any body to be out on the front lawn. 4:42 a.m., the defendant calls and speaks. The calls to her parents are finally answered. 4:49 a.m., the defendant calls Ms. Camerano, screaming, "Where's Mike?" 4:53 in the morning is when the defendant instructs Kaylee, Mr. O'Keefe's niece, to call Ms. McCabe. Why? Because the defendant doesn't have Ms. McCabe's phone number. Indicates that John didn't come home. We got in a fight, and I left him at the waterfall. Those are the first statements or the first version of events that she's able to communicate out to the world as to what happened to Mr. O'Keefe, where he is. We got into a fight. I left him at the waterfall. 5 a.m., the defendant calls Kerry Roberts, saying, "John's dead, Kerry, hangs up the phone. 5:01, the defendant calls Kerry Roberts again. And it's at this point that she indicates that John's dead. He must have been hit by a plow. 5:07 a.m., the defendant leaves One Meadows Ave. You have the video of that. It's number 153 in Exhibit 6. We'll get to that a little more in a moment. About 5:10 a.m., the defendant calls Kerry Roberts. Ms. Roberts starts calling hospitals, calling 911, something that you would do if you didn't know where Mr. O'Keefe was for all of these hours, that all of these other phone calls are being made and these text messages are being sent, calling your parents, and all of these other things. No calls to 911 from the defendant. While John O'Keefe is laying, freezing, and dying from brain injury and skull fracture on the front lawn of 34 Fairview Road. 5:11 a.m., the defendant's vehicle is seen on the Canton Library camera heading towards the waterfront. Seems to be sort of retracing steps. 5:18 a.m., the defendant's vehicle is seen at Washington Street and Chapman on the Temple Beth Abraham video, heading in the same direction that it was the night before when it was heading to 34 Fairview Road. 5:35 is when the defendant arrives in Ms. McCabe's house. Ms. Roberts arrives shortly thereafter. Both of them see the broken tail light at that time in the driveway. Now that gap of 5:18 to 5:35 is way too much time to be driving from the area of the waterfall to Jennifer McCabe's house. And as I indicated a moment before, heading in the same direction, same directionality, retracing the steps from the night before, heading towards 34 Fairview Road. Why is it that the defendant can see Mr. O'Keefe when they eventually get to Fairview Road and no one else can? It's because she knew exactly where he was. She had hit him and left him there the night before, and she had gone back during that time frame between 5:18 a.m. when she's seen on the Temple video and 5:35 when she arrives at Ms. McCabe's house. 5:33 is when the defendant, Ms. McCabe, and Ms. Roberts return to One Meadows Ave searching for John. 6:03 is when the defendant, no one else, spots Mr. O'Keefe's body buried in the snow. Exhibit 12, indicating this cruiser camera video, which I know you've seen a dozen times. So where I'm starting it from this point in this card right here is the spot that Officer Saraf had to use in order to locate, even with a vehicle of Ms. Roberts parked right in the middle of the road. In the darkness, in the snow, in the blizzard, in those conditions, the defendant sitting in the back seat of the vehicle knows exactly where Mr. O'Keefe is, covered in snow, as you heard from all of the paramedics, from the civilian witnesses, from the first responders. The defendant knows exactly where he is. 6:07 a.m., Ms. McCabe calls 911. 6:08, the defendant leaves that 4 or 5 minute voicemail, leaving the phone in the car for some reason to Mr. O'Keefe's phone. 6:23 and 6:24 in the morning is when Ms. McCabe conducts those Google searches. 7:50 in the morning is when Mr. O'Keefe is pronounced deceased at Good Samaritan Hospital. 4:13 to 4:20 p.m. is when the defendant's SUV is towed from her parents' house in Dighton. 5:20 p.m. is when the search team arrives in the area of 34 Fairview Road to conduct the search of evidence. 5:30 p.m. is when the defendant's vehicle arrives at the Canton Police Department south. We circle back for a moment to Mr. O'Keefe, to his family, to his friends, and to his relationship with the defendant. We heard testimony from Paul and Aaron O'Keefe that they liked the defendant, that they thought he was good for John, thought he was good for the kids. All outward appearances of the relationship were good. We heard testimony from the children that that was not true behind closed doors. But Paul O'Keefe testified that he told the defendant's parents this, that he liked Israel, that he thought that she was good for John, thought that she was good for the kids, weeks before John's murder. He even blew her a kiss in the emergency department at Good Samaritan as he was walking out and she was still being treated while they were there. Invited her over to John's house to grieve with him, invited her to sit down with him while he explained to their nephew Patrick about John's passing. Bennett shows up at the house, abruptly goes upstairs with her father for a period of about 15 minutes, which is about half of the time that she spent there that morning grieving with the family. She left with a bag of her belongings, drove with her family there, and then took an extra vehicle in the height of the blizzard, around 1 o'clock in the afternoon, drive that vehicle all the way from Canton, where it was parked at her boyfriend's house, where she stayed over on many occasions, drove that vehicle, or felt the need to drive that vehicle from Canton all the way down to her parents' house in Dighton at the height of the blizzard. You heard testimony from Aaron O'Keefe of the text messages and the phone call on January 28th. You heard that Aaron O'Keefe called the defendant on the morning of the 29th because she was concerned for her. She wanted to know what was going on with someone she considered her friend. The defendant yells, "John is dead." Ms. Robertson grabs the phone and then updates Aaron O'Keefe as to what's going on with John. Aaron O'Keefe again calls back later because she's concerned for someone that she considered her friend. How does the defendant respond? These are some of the little things. The defendant indicates to Ms. O'Keefe that she just has to remember the bad times and indicates to her, "I don't think I'll ever see you guys." This is after she's done her quick in and out at One Meadows Ave and is now with her parents or with her father, driving that car, essentially taking the murder weapon from Canton and bringing it down to her parents' house in Dighton. She's indicating over the phone to Aaron O'Keefe, "I don't think I'll ever see you guys." Why? If she didn't kill John, why would she say that? We heard a lot of testimony about New Year's Eve in a room. You heard the testimony from Ms. O'Keefe in regard to them exchanging, her and the defendant exchanging text messages on the flight down, arranging times to meet up. And then the defendant telling Aaron via text message that she caught Johnny kissing Laura's sister in the hotel lobby. She got into an argument about it, and then they never met up. Meaning the defendant, Ms. O'Keefe, got into an argument about it, and she and Aaron O'Keefe never ended up meeting up in a room. We heard testimony consistent from Laura Sullivan, Marietta Sullivan, as well as the children. The kiss never happened. It never would happen, based on the relationship, the godfather relationship that John O'Keefe had with Laura Sullivan, her family, and particularly Laura Sullivan's child. The defendant persists with this unfounded suspicion and accusations of infidelity in her text messages with Mr. O'Keefe, in her text messages with Mr. Higgins, where she's accusing Mr. O'Keefe of making out in the lobby with Marietta Sullivan. Both of the Sullivans and the children have the defendant and Mr. O'Keefe following this incident with Marietta Sullivan going into a room. Both of the children testified that they're in that room for about 20 to 25 minutes, and they're arguing about the defendant indicating that Mr. O'Keefe kissed someone in the lobby. And you have Laura Sullivan's testimony, about 20 to 25 minutes after her sister comes out and states her displeasure about the defendant. It's about 20 to 25 minutes before Mr. O'Keefe comes out, and then he and Ms. Sullivan have a conversation. Ms. Sullivan indicates that Mr. O'Keefe's phone is essentially blowing up, lighting up with calls and texts from the defendant. I would submit similar to the afternoon of January 28th. Mr. O'Keefe says she's crazy and he needs to take this and goes off from her. Ms. Sullivan has later conversations with Mr. O'Keefe on this Aruba trip, asks him if he's okay, asks him if he's happy. She indicated in her testimony that Mr. O'Keefe shrugs it off and says it is what it is. You heard testimony from the children about the arguments in the weeks and the months. I know this is a displeasure to the defense counsel that the children came in and actually testified as to what happened behind closed doors in the house. They both recall frequent fights. They both recall Mr. O'Keefe trying multiple times to break up with the defendant, asking her to leave the house, the defendant refusing to leave the house. His niece Kaylee, John tried to diffuse, tried to walk away, and the defendant would follow each time during each argument. They both indicated that Mr. O'Keefe had told the defendant that the relationship had run its course, similar to language within the text messages you have between the defendant and Mr. O'Keefe. That Mr. O'Keefe was sick of arguing, again, mirroring those text messages from January 28th, leading up into going out to see if McCarthy is eventually the waterfall, and the defendant killing Mr. O'Keefe in the early morning hours of January 29th. We have testimony in regard to the ring camera. Haley indicated in her testimony that John had that for about a year. So during the course of 2 years or so of the relationship with the defendant, he got it while he was dating the defendant. The defendant had the security code for the garage. Neither of the kids had access to the camera. Trooper Garino checked the laptop and the desktop that were left after the defendant did quick cleanup upstairs with the father, upstairs in the home. Neither of those devices had access to the ring cameras. John had access on his phone. The defendant indicates, if you recall, in some of those text messages in regards to the romantic kiss that she placed on Mr. Higgins earlier on January, whatever it was, during the Patriots game. Mr. Higgins and Mr. Jackson's indicating weren't very good friends with Mr. O'Keefe, but had been invited over to his home for a Patriots game, in which time the defendant escorted Mr. Higgins out of the garage and placed a romantic kiss on him. But during those text messages, when they're talking about that, if you recall, the defendant is saying something or joking about something that Mr. O'Keefe had been looking at the videos and had been asking her if there was something going on with her and Mr. Higgins. And what was her response to that? I know where the cameras are. There are only 2 videos missing from that ring system. One being the defendant getting to Mr. O'Keefe's house after murdering him, and the other when the defendant is showing Ms. McCabe and Ms. Roberts the broken taillight, both of which, both Ms. McCabe and Ms. Roberts testified as having occurred. No video. The variety of stories that the defendant tells in the morning of January 29th. There are text messages and voicemails from the defendant to Mr. O'Keefe, 53 phone calls from 12:33 a.m. to 6:03 a.m. 0 phone calls to 911. The defendant calls Katie Camerano. The defendant calls her parents at 1:18 in the morning, 4:38 in the morning, 4:42 in the morning. The call then from Kaylee's phone to Ms. McCabe, because the defendant didn't have Ms. McCabe's phone number. Both Kaylee and Ms. McCabe indicate the defendant initially indicates or says that she got into a fight with Mr. O'Keefe and left him at the waterfall. From this information, Ms. McCabe then testifies she starts to call Julie Albert. Because Chris Albert, Julie Albert, they live close by the waterfall. Maybe that's where he went. As the phone is ringing, and this is a phone call that both Mr. Albert and Ms. McCabe testified was never answered. As the phone is ringing, her husband Matthew McCabe reminds her that they saw the defendant and Mr. O'Keefe in the car outside of 34th Fairview. So she hangs up. During this call, or during these subsequent calls, the defendant indicates to Ms. McCabe, maybe I hit him, did I hit him? She then calls Ms. Roberts at 5 a.m. on the dot, indicates John's dead, hangs up the phone, calls back a minute later, indicates that Mr. O'Keefe was now hit by a cloud and that he's dead. And then indicates further that she's drunk and doesn't remember. She tells Ms. McCabe about the cracked taillight before they even get in the vehicle and go anywhere, as you recall the testimony of Matthew McCabe, indicating that he has some concerns about them driving around in a vehicle with a damaged taillight in the middle of a blizzard. Ms. Roberts' testimony that she saw the broken taillight in the driveway at Ms. McCabe's house, and that it was consistent with what she observed in photographs that were shown to her of it later in the Sally Port at the Canton Police Department garage when the search warrant is executed on February 1st. You have the text messages between the defendant and Lord Sullivan from January 29th, in which the defendant indicates to Lord Sullivan that John is dead, indicates that we found him in the snow at 5 a.m. And every indication is that he was found in the snow by the defendant, Ms. Roberts, around 6 a.m. 5 a.m. would be about an hour before. 5 a.m. would be between that time of where the defendant is unaccounted for, heading in the direction of 34 Fairview Road, 5:18, 5:35. Little things. The defendant asked Ms. McCabe to Google how long to die in the cold. She did so at 6:23 and 6:24 in the morning. You have the testimony of Ms. Hyde and Mr. Whitfield as to SQLite databases, plist databases, knowledge C databases, state DB tabs, as far as all of them, also from Trooper Garino as well. These searches were unequivocally done at 6:23 and 6:24 in the morning, and not at 2:27 and 40 seconds in the morning. They were not deleted by a user. That is not what deleted means. Frankly, Mr. Green, the last question that I asked Mr. Green is, was he aware that Cellbrite, and by Cellbrite, the person who designed that being Mr. Whitfield, had to alter exactly how their software worked because of people like Mr. Green misinterpreting the data as he did in this case. And what did Mr. Green say? Yes. But those questions, as far as how long to die in the cold, I would submit mirror the questions that the defendant asked firefighter Whitley in the back of the ambulance, if you recall those. She asked firefighter Whitley how long to die in the cold without a jacket. She knew how Mr. O'Keefe was dressed. She knew when she left him to die in the cold how he was dressed. The defendant made statements to firefighter Becker that the last time that she saw Mr. O'Keefe, they were in an argument. Again, back of the same ambulance as firefighter Whitley. You have testimony from firefighter Woodbury. Same kind of questions. If Mr. O'Keefe could be alive without a jacket. You have the testimony from each of these firefighters as to sort of the vacillating emotional state of the defendant that morning. What you have in the testimony from firefighter Woodbury is that despite all that, there were no tears that he observed from the defendant at that time. But each of those first responders indicated that the defendant repeatedly stated, is he dead? Is he dead? Not, is he okay? Is he going to be okay? How is he? Any sort of questions about the medical condition. Is he dead? That phraseology repeated over and over again. And when you take into juxtaposition that phraseology, text to Laura Sullivan, found him in the snow at 5 a.m. The unaccounted for time heading in the direction of 34 Fairview Road, 518, 535. The repeated questioning, firefighter Whitney, firefighter Woodbury, asking Ms. McCabe to look up those things in her phone. She's looking for confirmation, is what she's looking for. When she asks over and over again, is he dead? Is he dead? Is he dead? You have the testimony that you heard from Ms. McCabe and Ms. Roberts. I say them together because as far as these two women were concerned, they did not know each other really at all. The only time, as they both testified to, that they ever spent appreciabely together prior to January 29, 2022, is when Mr. O'Keefe nicely took them out for sneakers because he had some sort of deal at Reebok's outlet or something like that to sort of try to pay them back for the help that they provided him and the children. Jennifer with respect to the niece and Kerry with respect to the nephew. But they're both contacted by the defendant in the early morning of January 29th. As Mr. McCabe testified, John was my friend. I love John. He was an amazing guy. At the waterfall, Mr. Alberts said going home to have a drink with his son, Brian Jr., if anyone wants to come. Open invitation on the table. She said to Mr. O'Keefe and the defendant, you guys should come. Both the defendant and the victim indicated that they wanted to come and that they were. She describes the phone calls and the text messages that she receives from Mr. O'Keefe. She's providing directions. She indicates she's providing them directions to go down Chapman. She describes how that is. And you've heard this testimony from a couple of different witnesses as far as the steepness as you're going down Chapman, as you're going down Fairview, coming off of Chapman. That you first go down a big steep hill. It flattens out for a little bit, and then you go down a second. 2 hills going down on Chapman. Matching the GPS native location and the health data as far as where Mr. O'Keefe's phone is, a half mile away from 34 Fairview Road at the time that his health data is reporting that he's ascending or descending 3 flights of stairs. You hear the testimony from Ms. McCabe as far as the last time that she spoke to Mr. O'Keefe. That she's still trying to provide directions to Fairview because Mr. O'Keefe's never been there before, and neither has the defendant. Which is further corroborated in Trooper Garino's testimony as far as the vehicle passing by Fairview and then coming back in on the other side, having to reverse direction. But she's giving directions and she indicates that she uses a house that Mr. O'Keefe will be familiar with, that belonging to Bella or Bella's mom. Bella's mom is an ex-girlfriend for a short period of time, a long time ago. However, in the defendant's mind, it's so fresh on her mind that she's still talking about it the next morning or later on that morning when she's riding, going towards Fairview Road with Ms. Roberts and Ms. McCabe in Ms. Roberts' car. She's still talking about it at that time. It's that much on her mind. Ms. McCabe indicated that she looked out and she saw a vehicle initially from the front door as Mr. McCabe, as Brian Albert Jr., as Julie Nagel, as Brian Nagel, and the vehicle moved up several times or several spots to where it was then positioned. Initially at some point in front of the door, then it moves up further so that it's in the area of the fire hydrant and the flagpole where Mr. O'Keefe's body was discovered later on that morning, at least by Ms. McCabe and Ms. Roberts, and then moves up further beyond that. And I say that in the sense that it moves up further beyond that with sufficient distance for it to then go in reverse for 62.5 feet at 24.2 miles per hour, striking Mr. O'Keefe and leaving him where he was found later on the 29th. Again, the testimony from Ms. McCabe that about 12:40 when she's texting him, she indicated in her testimony she couldn't be certain if Mr. O'Keefe was still out front or had left at that point. She wakes up to a phone call from John's niece Kaylee, 4:53 in the morning. This is from an 8th grader, 14-year-old girl. That's why she answers the phone at 4:53 in the morning. She then hears the defendant screaming loudly over and over, Jen, Jen, Jen. John didn't come home, got in a fight, left him at the waterfall. The variations, the different iterations of that story as it evolves and changes over the course of that morning. Ms. McCabe then indicates to the defendant, we saw you outside of my sister's house. Then she starts yelling, Jen, Jen, did I hit him? Could I hit him? Then they start discussing what the defendant brings up her cracked tail. Then hear her, both Ms. McCabe and Ms. McCabe hear the defendant screaming outside of their home at about 5 o'clock in the morning, or shortly after 5 o'clock in the morning. They go to Mr. O'Keefe's house. And both Ms. McCabe and Ms. Roberts indicate, and you heard this testimony from a number of different witnesses, friends and family of Mr. O'Keefe, that he had a rule. Pretty strict rule in his house as far as you take your shoes off when you come in the house. And so what did Ms. McCabe and Ms. Roberts both do when they're entering in that house on January 29th? They take off their boots, they get out in the snow, they take off their boots in the mudroom, and then they walk in. What did they both indicate that the defendant did that morning when she came back to the house? Walk right in with the shoes. You hear that second voicemail. It's after the defendants arrived back at One Meadows Ave, after her phone's reconnected with Mr. O'Keefe's Wi-Fi. And you can hear the footsteps. Part of that may be in the garage, part of that might be in the house. Why is it that the defendant has no issue with wearing shoes in the house when Mr. O'Keefe has that search? Well, because she knows where he is. She knows it's not an issue. He's not coming home because she hit him with her SUV and she left him in the snow. Ms. Roberts and Ms. McCabe are frantically sort of running around the house looking for Mr. O'Keefe. Defendant's not. They then get in the vehicle. They drive back towards Fairview Road. And again, the defendant from the backseat of the vehicle immediately sees the defendant, starts pulling and kicking on the door, and runs in sort of a beeline straight over to where Mr. O'Keefe is laying on the front lawn. You have the testimony from Ms. Roberts as far as John's phone. John's phone, when the firefighters pick him up, and you recall several witnesses testifying about that, pick him up on scoop stretcher and then bring him over to the ambulance while they're conducting resuscitative efforts trying to save Mr. O'Keefe's life. But Ms. Roberts indicated that she observed underneath it only the phone on the grass in the area that is completely covered in snow in every other area except under Mr. O'Keefe. Which I would submit indicates how long Mr. O'Keefe has been there. Now recall, around 12 o'clock or so is when it starts to snow and it starts to stick a little bit. You heard all that testimony. And I know it was a lot of testimony about snow, a lot of testimony about weather, but there's a purpose to that. There's a point to that, okay? As far as the grass underneath Mr. O'Keefe's body, where his cell phone was, and Ms. Roberts observed some 6 hours later after it starts snowing, it's still visible only under Mr. O'Keefe where his body is, which I would submit as evidence to you as to how long he's been there. Now, on top of that, you also have hours of ring videos of the driveway as far as shoveling and Paul O'Keefe and other people snow blowing and shoveling and all those kinds of things. There's a purpose of that as well. If you look at those, if you look at the video of the defendant crashing into Mr. O'Keefe's vehicle at a speed of anywhere from 0 to 5, which Dr. Wolfe would indicate would not cause the damage to the taillight that was observed in this case. You know what you don't see? You don't see snow move off Mr. O'Keefe's vehicle when they come into contact. You don't see any red or clear plastic pieces in the snow. And if you look at those stills, not the ones that counsel put up there during his closing, but if you look at each of the video and the stills, you can see the damage consistent with the taillight at each and every point. You see the damage consistent with the taillight from the 507 video. You see the damage consistent from the 822 video, from Lieutenant Ray, from the cruiser camera video, who's pulling into the driveway. You see the damage consistent from the Dighton video at the defendant's home. You see the damage consistent from the right here, February 1st, 2022, when the search warrant is conducted, Ms. Hartnett removes all those pieces from the vehicle. The weather is also important when it comes to the hair. The magic hair, as Mr. Jackson likes to call it. See, the magic hair was actually frozen to the vehicle, as was the glass to the bumper, because the vehicle looked like that on the left when it was caked in snow. And Officer Barrow saw it in the driveway in Dighton as they were wading through 1.5 feet of snow, walking up. Because remember, they didn't even pull into the driveway because they had to have someone come down and plow it before they could get into it. That's what the vehicle looked like. What you can see, however, is the damage to the taillight, to the side of that taillight, consistent with it. So that hair, that 7/8 of an inch hair, was frozen to the side. And as you remember, the testimony from Sergeant Mechanic about the heated condition of the Canton Police Department garage, and that's one of the reasons that they took it there, because the other barracks that they could have taken it to didn't have that heated condition. So yes, after it's been in there from January 29th, about 5:30 p.m. until February 1st, when they conduct the search warrant, the hair isn't still frozen, as it's contained within the heated garage, and the pieces of glass on the rear bumper have melted. The snow has melted, as you can see from left to right. The weather, also important, I would submit, weather was wet. Remember, the cause of death here is not just blunt impact injuries, it's blunt impact injuries and hypothermia. You heard all that medical testimony in relation to it. You heard all that testimony in relation to the snow and the weather and the wind. Wind gusts up to 37 miles per hour while he's out. Mr. O'Keefe is out there in just a shirt and jeans. Now, you heard also testimony from Ms. Roberts in relation to the injuries she observed to Mr. O'Keefe. That initially on scene, there was one eye that was swollen, not the other. So that's indication of the swelling that Dr. Sporty Bell was testifying to, and no indication of physical altercation. And then both eyes being swollen when Ms. Roberts viewed Mr. O'Keefe's body after his passing. That's a good submit. Submit that all the testimony tells you the same consistent account, internally, externally, from civilian testimony to investigator testimony to medical testimony to forensic testimony to the reconstruction testimony. You have the testimony from Ms. McCabe and Ms. Roberts that they couldn't see Mr. O'Keefe at Fairview when they initially pulled up. You can see that from Officer Sarah's cruiser. You have Mr. O'Keefe being covered in snow from the storm. You know where Mr. O'Keefe's body was. It's clearly visible on the cruiser camera from Officer Sarah. You have testimony from each of the responding officers, anywhere from 5 to 12 feet off the roadway, and from the civilians as well. Ms. McCabe, Ms. Roberts, Officer Mulaney has 6 inches of snow on Mr. O'Keefe when he first sees him. Firefighter Kelly says that he couldn't even see Mr. O'Keefe until he was 5 feet away in the darkness, in the snow, the blizzard conditions. There's no footprints around the body. There's no drag marks around the body. There's no evidence of anything in relation to Brian Albert and Brian Higgins. Brian Albert and Brian Higgins spent January 28, 2022, traveling to New York City to go to a funeral for another police officer, for another department, who they didn't even know. Traveled all the way down to New York and then came back before the blizzard, only to come back from that, to go out drinking, to come back to Mr. Albert's house, to then murder another police officer who they did know, who worked for the same department as them. And then criminal mastermind genius that Brian Albert is, 28 years on the Boston Police Department, he's then going to just leave Mr. O'Keefe's body on his front lawn. Really? That's a conspiracy? What evidence do you have of that? You have statements that the defendant made to Sergeant Mechanic on January 29th. She was willing to speak, but didn't want to give too much detail. Conversational tone throughout. She indicated that the night before they had gotten into an argument, something about what was fed to the children, nothing about the detailed arguments, incessant phone calls, and everything else that you saw from the defendant and Mr. O'Keefe's phone on the 28th. She indicated that she got to C.F. McCarthy's around 9 p.m., started drinking vodka sodas, the men were drinking beers. When asked where she parked her vehicle, she said she parked on Washington Street across from C.F. McCarthy's, facing northbound on the side, same side as Waterfall. Same testimony that you heard from Ms. O'Keefe, observing the defendant going over to her vehicle, getting in the driver's seat, and the victim, Mr. O'Keefe, getting into the passenger seat. She said they left the Waterfall, were invited to a residence. She drove her and John to the location in Canton. She dropped Mr. O'Keefe off, did not see him walk into the home. She, being the defendant, stated she made a 3-point turn and then left. When asked about the damage to her vehicle, she indicated to the troopers, "I don't know, it happened last night." June 2022, you have that other recording of that other version that she now has evolved into as far as stating, Sergeant Mechanic, are you aware that John was beaten up by Brian and Colin Albert? We're all in on the same joke, right? John was pulverized and my taillight was cracked. What evidence do you have there? Mr. O'Keefe never went in the house. You have testimony from Nicole Albert, Brian Albert, Jennifer McCabe, Matthew McCabe, Caitlin Albert, Brian Albert Jr., Sarah Levinson, Julie Nagel, all indicating never went in the house. John O'Keefe's phone never went in the house from the testimony and the data points that you have from Trooper Green. You know how Mr. O'Keefe was dressed, and you know the defendant knew that. You have the testimony from Kurt Roberts, Jennifer McCabe, Matthew McCabe, Karina Kolakithis, Nicholas Kolakithis, Brian Albert, Paul Albert, Brian Higgins, all indicated in the testimony, and the defendant knew, based on our questions to the firefighters the next morning, that Mr. O'Keefe was not dressed for the weather when he left the waterfall. The weather was a weapon. You have the testimony about the car, the defense car being there in front of the house, moving multiple times. You have that from multiple sources. You have that from Matthew McCabe. You have that from Jennifer McCabe. You have that from Brian Albert Jr. You have that from Julie Nagel. You have that from Ryan Nagel. You have the testimony of Ryan Nagel, Ricky D'Antonio, and Heather Maxson. Ms. Maxson indicated she saw a male passenger, female operator as the vehicle was turned. Remember, they were coming towards Fairview at the same time. The defendant, after conducting that reverse or 3-point turn on Cedar Crest, is then taking a right on Fairview, while Mr. Nagel, Mr. D'Antonio, and Ms. Maxson are taking a left on Fairview. Mr. Nagel indicates that Mr. D'Antonio then flashes lights. During that time, Ms. Maxson can see inside the vehicle. She sees a male passenger. She sees a female operator. They follow the vehicle as they're turning onto the street. Lo and behold, they're going to the same residence. They park. There's nothing in between them and the defendant's vehicle. They indicate that at no time do they see anybody get out of the vehicle. At no time do they see any damage to the vehicle, or it hasn't happened yet. At no time do they see anyone leave the vehicle and go into the house. The vehicle moves up on different successive occasions, as testified to by Mr. Nagel and several others. And then as they're passing that vehicle, Mr. Nagel indicates that he sees a female operator in the vehicle with the dome light on. Interesting, when I asked Mr. Nagel, as far as when Julie Nagel came out to the vehicle, did he roll down the window or did he open the door? He indicated he opened the door. I asked him, what happened when you open the door? What happens when you open the door to a vehicle? The dome light comes on. So there's a reason I would submit, or the inference that you can make, is that no one sees Mr. O'Keefe in the vehicle because that's the moment he steps out of the vehicle. And then they're gone. The Nagels, Ryan Nagel, Ricky D'Antonio, and Heather Maxson drive away from them. We have the testimony from Julie Nagel and Sarah Levinson, the peanut butter and jelly sandwich conversation they have with Ms. McCabe, which while they're pulling away from the house, where everybody's attention is drawn, Ms. McCabe is turned around, facing both of them in the backseat. Ms. Nagel is facing Ms. Levinson on the passenger side, looking out the window towards 34 Fairview Road. Ms. Levinson is looking back at Ms. Nagel, away from that area, in which Ms. Nagel indicates that she sees a 5 to 6 foot dark blob on the lawn near the pole in the hydrant, which is just where Mr. O'Keefe is discovered the next morning. You have testimony, recall, and you have text messages in regard to Colin Albert when he gets picked up.
Mr. Lally, 5 minutes.
Yes. Colin Albert, Ms. Allison McCabe, Brian Albert, Cole Albert, Caitlin Albert, Brian Jr., all indicating that he was picked up around that time at 12:10 a.m. You have the testimony from Chris and Julie Albert, his parents, as far as when he comes home, kisses them at night before he goes to bed. You have that testimony in regard to Chris Albert, as far as how John O'Keefe and the defendant come to be at the waterfall in the first place, as far as John O'Keefe and his nephew coming in early in the day, getting a couple slices of pizza, what are you doing later on, contained within those sections. You have testimony from Lieutenant O'Hara, Lieutenant Tully, Sergeant Mechanic, about those items being recovered. And in particular, the items being recovered on January 29th by that search. What did Lieutenant O'Hara say? The items were found close to the curb. The items were at ground level, 3 feet of snow that they had to sift through in order to find those particular things. The detail or the delay in the recovery of evidence. The photos and the video, most of which you have in evidence, is earlier in the storm. This is before the 18 inches of snow falls down, before there's drifts and 3 feet of snow in places. They found evidence where it had been at that same ground level, in the grass, under the snow, at 34 Fairview Road. We heard all of the medical testimony, which I would submit is consistent, from firefighter Flamati to Dr. Rice. We heard testimony regarding the defendant's blood alcohol concentration with Dr. Fowler and Nick Roberts, 93 milligrams per deciliter, 0.07 to 0.08% at 9:08 in the morning. We heard Mr. Roberts' testimony in regard to the retrograde extrapolation, 0.13 to 0.29, extrapolating back to the time of the operation. The defendant admits to drinking vodka. It's on the receipts from C.F. McCarthy's and from the waterfall. You have the witness testimony in the surveillance video in regard. The forensic testimony that you have. In regard to the medical testimony, you have this sort of pattern abrasions, clear plastic that's recovered by Lieutenant O'Hara and Lieutenant Tully on January 29th. The clear plastic that has the dimples on it. No one, not Trooper Paul, not anyone, at any point in time, ever said Mr. O'Keefe's arm was out like this at the time he was struck, and then he did a pirouette and then flew 30 feet in the air. 12 inches of abrasions that the doctors were, the biomechanical people were talking about yesterday, 12 inches and then 6 inches for the tail line, is easily solved by this. And the dimples on his arm are, and I would submit, are consistent with the dimples on the tail light cover piece, are right around this area of the elbow. You have testimony in regard to forensics as far as Mr. Porto, Mr. Bradford. John O'Keefe's DNA is on that tail light house, on the house. His DNA is there to the exclusion as well of Sergeant Mechanic and Trooper Crocker. Mr. O'Keefe's DNA is on the exterior of the broken drinking glass. Mr. O'Keefe's DNA, and only Mr. O'Keefe's DNA, is on his clothing and his fingernails, consistent with Dr. Sportibello's testimony that there is no evidence of a fight or an altercation. There's no one else's DNA under his fingernails. There's no one else's DNA on his clothing. You have testimony from Ms. Hardman and Trooper Paul as regard to the damage that they observed, the dents, scratches, 7/8 of an inch hair. You have testimony from Ms. Chart in regard to the mitochondrial DNA profile from that hair being consistent with the DNA profile of Mr. O'Keefe. You have the testimony from Ms. Leader and Ms. Hanley in regard to the microscopic pieces, 1/16 of an inch by 1/16.
You have 1 minute, Mr. Lally. Wrap it up.
Yes. All consistent with pieces of taillight that are found within his clothing. Ms. Young, if I could. 605, this is what this vehicle looks like backing up at that speed for approximately that distance. There's another, years and years ago, started practicing in Norfolk County. Braintree was now Quincy. Eventually became a far smarter man than myself. Eventually became President of the United States. His name was John Adams. John Adams once wrote, "Facts are stubborn things. And whatever may be our wishes, our inclinations, or the dictates of our passions, they cannot alter the state of the facts and the evidence." What the constellation of the facts and the evidence ineluctably demonstrate here is that the defendant drove her vehicle in reverse for 24.2 miles per hour for 62.5 feet, struck Mr. O'Keefe, causing those catastrophic head injuries, leaving him incapacitated and freezing his death.
Mr. Lally, I have to stop you. You've gone over.
I really have one sentence.
One sentence I'll give you.
From that facts and that evidence, I would submit ineluctably demonstrates their guilt on each of the indictments before you, and I would ask that you find this. Thank you.
All right, thank you. Jurors, I have my instructions in the law. I'm going to give you. My guess is it's probably about an hour. I'd like to start it now, but does anybody need a short break? We can take a short break. Okay, we'll come back in 5 minutes.
You are muted.
All right, jurors. Thank you for serving on this jury and for being so attentive. You'll soon deliberate for the purposes of reaching a verdict in this case. But before you do that, it's my responsibility to give you instructions concerning the law. The instructions are divided into 3 parts. The first is general instructions that are provided in every criminal case. The second, specific instructions concerning the crimes alleged in this case. And third, guidelines for your deliberations. Please listen carefully to all of the instructions. Do not ignore any instruction or give special attention to any other instruction. To make sure that I give you the instructions accurately, I will read them to you. You will also get a written copy. I'll probably send in 3 or 4 to the jury so that you can refer to it in the jury room during your deliberations. I will try to make sure that my oral instructions match the written instructions. If there is any difference between what I say aloud and what the written instructions say, please follow what I say aloud. You must take the law as I give it to you. You may not quarrel with it. You can't do that regardless of any opinion you may have as to what you think the law ought to be. What the lawyers or witnesses may say or suggest about the law is not necessarily the law. That's because it's my responsibility as the judge and mine alone to instruct you on what the law is. So I now will turn to part 1 of the instructions, the general instructions that apply to all criminal cases. As I explained to you at the beginning of the trial, there is a fundamental rule that applies in all criminal cases, including this case. Every person who is accused of a crime is presumed to be innocent of that crime. Ms. Reed is presumed innocent of the charges in this case. That means you must consider Ms. Reed to be innocent unless the prosecution is proved beyond a reasonable doubt through evidence presented during the
All right, I don't care about jury instructions. I just cared about like the case facts. So we have finally come to the end of trial 1 testimony. I have a few other people who have not seen privately, like outside of live chats, their testimony, but I should finish up hopefully by tomorrow. Like I said, today I have like 26 pages of notes, but I missed so much, and I appreciate you guys all joining these live chats, but I'm just kind of wasting time having to go back again to confirm my notes for things that I missed. And with so much stuff to, at least, I've hardly watched any of trial 2, mostly just Burgess and Whiffen, I think. So I cannot do more live chats with trial 2 testimony. So sorry if anybody wanted to watch that, but I ain't got time. Ain't nobody got time for that. Yes. So again, thank you so much for joining I'll answer a few questions before we're dismissed. Crispy Treat, you're lucky I've never banned you. No, seriously, thank you for all your insights. Thank God. I was just going to say, Tom, please don't make us sit through jury instructions. Yes. Let me just highlight a few things. Thank you, Giuseppe. For anybody who cares, I Googled, and it seems like Ring introduced mandatory two-factor authentication in 2020, but I can't find whether it was already SMS-based at the time or if it allowed email too. So I'm going to have to go back and rewind because it looked like Lally just said that Trooper Guarino, looked at the computers at John's house, and I thought he said they did not have access to Ring. So if John's phone had Ring and his phone is under his body, how would Karen delete 2 videos at any point? On the opposite side of that, people say, oh, well, Proctor had John's phone. He is the one who deleted Karen returning home and the 3 ladies leaving John's house to go find John's body. But it was mentioned that Proctor made 2 requests of Ring. So in my opinion, if Proctor knows that he deleted those 2 videos, Ring could have a report that said the videos were deleted at the time that the police had John's phone. So I don't know, that's kind of conflicting information there. Oh my gosh. Yeah, thanks, Glammies girl. Crispy Treat should be sentenced to some kind of community service for saying I look like Todd Chrisley. Anyway, it's okay. Or she said like my Todd Chrisley looking ass would not last in jail. I guess I was saying like if I was in jail, like Richard Allen or prison, I would be talking back to the security guard saying I want my recreation time or something like that. Anyway. Just a few more comments. Some talk about what Karen was drinking. So yeah, so I guess Lally just said Karen had 9 drinks. There's a video interview where Karen said it's more like 4, but the defense in trial 1 asked a lot of witnesses, did Karen seem drunk? And everybody said no. And if Karen's saying, oh, I only had 4, so she's okay to drive, why can't she remember certain facts? I mean, you can't have it both ways to say, oh, she was so drunk, she can't remember things, but she was not drunk, so she was okay to drive. And I don't know. There's a lot of conflicting viewpoints on a lot of these scenarios. We were talking about at the end there, Lally showed, what did he show? The 8:22, 8:23 a.m. police dash cam. They went to John's house, I think, to do a wellness check of his niece and nephew. And you can obviously see the right taillight is missing the red. That's before police even had a chance to tamper with it. And then on the right, he showed the Sallyport photograph that essentially shows the red is missing. I know there's certain issues, and a huge issue to me is why did they keep finding different pieces of taillight over the coming weeks, including some of them were like 7 inches long or wide. But if they were going to plant them, why not just plant them all at one time and not up until like, I think February 3rd, 8th, 11th, and 18th? I don't know. Fern's mom says, people who do photo editing have looked at that, I guess, 8:22 a.m. video, the dash cam, and to trained eye, the taillight has been blurred out. I've not seen any of those videos that are alleging any kind of editing. But we know, I mean, even Karen herself admitted she cracked her taillight. There's some discrepancies between, did she say it after 5:07 when she backed into John's car? Or was it before? Did they look at it at Jen's house or as they were leaving One Meadows to look for John. Jen McCabe testified in trial 1. They arrived at John's and the 3 of them looked at the taillight. Then they played that video from Ring and they all walked inside without looking at the taillight. The 3 of them leaving, that video is missing. Who's it more beneficial to delete Karen arriving around 12:36-ish and delete the 3 ladies leaving? Police or Karen? Crispy Treat says, Tom is so boring. His clothing is lackluster. I'm kidding. I know you meant Lally, although you're probably thinking the same thing about me. All right, 3 more comments, then I got to go eat. I think I'm going to make a cherry cheesecake. While I was watching this, I was thinking about a cherry cheesecake. Anyway, Crispy Treat says, Jen is not credible at all. She lied to the FBI and got caught lying to them. I'll have to go. I do have a lies spreadsheet for everybody involved. Can you say first what you're referring to? What did she lie to the FBI about? Thank you, Fern's mom, for the recommendation. Be in Trouble on YouTube has done loads of taillight videos. Right, thank you. Let me screenshot that. Glammy's girl, snow took a long time to melt. Some piles of snow were higher. Yeah, so you're talking about why it took so long to find certain taillight pieces, but if it was a fairly small area, why not go back with shovels and rakes and do a better job? And Crispy Treat's hair dryer. There's a ring cam of her backing into his car. Yes, but there's no taillight that falls off, and she's literally going like 1 mile an hour. Peanut butter and jelly. I have thought about eating peanut butter and jelly while looking at your comments. Who does it benefit to keep footage of Karen hitting John's car? It benefits Karen. Was that the correct answer? Crispy Treat, she lied. She told them she wasn't here. Sorry, she told them that she wasn't here. She said she was initially, then she said she had to brush her teeth. Could she get a few minutes and call everybody involved to tell him that the feds, then she made all these phone calls to them, all that the feds were on their way to her house, and then her husband showed up and called the interview off. I have to do some investigating into that. I'm not sure what you're talking about. PB&J, if Proctor is deleting things, why not the video of Karen hitting John's car? That's a good point. And there seem to be a lot of like comments from people inside the house that if there was a conspiracy, they could have like changed their comments to make it look like Karen was more guilty. Fern's mom, that background looks like New Zealand. It was the island of Oahu, Hawaii. This is where they filmed Jurassic Park. All right, 3 more comments, then we're done. Hi, Naven. Karen was at John's at 12:36, but pulls into the garage and shuts the car off at 12:41. What was she doing for 5 minutes in the driveway? I was going to say, or inside the garage. I'm trying to think, were there tracks at 5:07 that could have proved? I don't know. Ignore me. Looking at the taillight, she broke when she hit John. Had to delete. That's a very plausible explanation. But how would she get access to that Ring video? John's phone is under his body. Crispy Treat with clarification. She told them she wasn't who she said she was initially. Then she said she needed time to brush her teeth and then called all of the people involved. Yeah, didn't she say she was, oh yeah, so I remember this. I guess 2 undercover officers show up outside of her house and said, or no, show up outside of Julie's house or Fairview. They may have said, "Are you Julie?" Or no, "Are you Jen McCabe?" And she said, "I'm Julie Albert." I don't remember. But if two strangers are asking you these questions, are you really being honest, or are you concerned who these people are? Giuseppe, why didn't the conspirators claim to have seen the accident? Well, then they would have had to have said why they did not go outside. I can't get past, like, some of these people saw Karen's car outside as they're sitting at the dining room table. It was mentioned that the front door had, like, the main door, but I think they had that open, and like the glass storm door was open because they were expecting Karen and John to come in. So how do they not see her go flying in reverse? I don't know. I need to figure that out. Crispy Treat, Jen deleted her Google searches about somebody freezing outside. I'm almost certain Ian Whiffen said, when you close the tab, it shows as deleted. It was not user deleted. Giuseppe, is there any chance she drove home with lights turned off to not trigger the camera? It also measures like movement, the Ring camera, so I highly doubt that it did not register, even if she's going really slow. One more comment. Anything? Bueller. Crispy Treat says she admitted that she deleted it. I think Jen said she did not delete that search. To me, we'll end with this 1220 or 227 search. Jen goes to bed. She looks at websites for her daughter's like athletics. So we're supposed to believe, like, she gets home after this conspiracy to like hide the death of her good friend. Jen like watched Kaylee, John's niece, repeatedly. She helped him out. So we're supposed to believe like she's involved in this conspiracy just because her family, it happened at their house. She goes home at 2:27, searches her daughter's athletics, then decides to search how long does it take to die in the cold. That does not add up to me. What adds up more is being at the scene at 6:23, trying to figure out what happened, and maybe Karen saying, search these terms, how long to die. And that's when it was done. And I did watch Trial 2. Ian Whiffen showed on his phone an open browser maintains the first time it was opened. So I think that search was at 6:23 and not 2:27. All right, we're done. So yeah, my next video on this case is going to most likely be, actually, I think for my members, once I have a deep dive done, I'll either upload it for my members and then do a live chat to get their feedback before the general public rips me to shreds. It's going to take, I've been doing this for 3 weeks, all day, every day. Just now I'm finishing Trial 1. If I finish this before the end of July, I'll be lucky. And honestly, like, this video is probably going to make me like $100 in YouTube ad revenue. So I'm wasting like a month and a half of my time, but I'm going down the rabbit hole and I can't get up until I'm done. Thank you for sharing your thoughts and for being polite to other people who have different opinions. I appreciate it. I'll see you maybe in a few weeks in a live chat. Keep me in your thoughts and prayers as I'm going through my spreadsheets and all this testimony. If you're in America and you celebrate being independent from the UK, go outside and go watch some fireworks or something. Go light some on fire. If you're outside the US, be glad you're outside the US. See ya. Bye.